Good morning to you all. Good morning, Ndate Chauke. Good morning, Advocate Riley. You are muted.
My apologies. Good morning to everyone.
You good today?
I'm good, thank you.
You continue to be under oath?
I accept that. I confirm I'm under oath.
Thank you. Advocate Cheney, you can take off from where we ended yesterday.
Good morning, Advocate Riley.
Good morning, Advocate Matoni.
Yes. Advocate Riley, yesterday, just before we adjourned, the chairperson had asked you to go through Annexure SR5 and identify those dockets which had ballistic reports in them. Do you recall that?
I recall that, yes.
And you subsequently did that, and you've prepared a document with a list of those dockets with the individual reports.
It is correct, yes.
Madam Chair, I've got a list that I'm referring to. If I might beg leave to hand it up, it will obviate the need to go through Annexure SR5 in order to try and identify each document, each page in the document for that purpose. But it addresses the chairperson's request yesterday that we identify those dockets where there were ballistic reports in them.
Have you shared it?
After I've shared it with my colleagues.
You shared it with your colleagues?
Yes, and last time I checked, Advocate Ngcukaitobi had no objection.
Please give me a second. Let the gentleman come and help me here. Thank you, Dr. Chauke. I'm being schooled here. I might have forgotten how these things work.
It's Matoni, Judge.
Thank you. Thank you. Thank you, sir.
Yes. Now, may I proceed, Madam Chair?
Just give us, we're looking at this document that you've just given us now. What is SRF?
I think it just seeks to, SR is the, I think it was an error, Madam Chair. It should be SR, simple. It's part of the SR documents.
What is SR?
Is the annexes, the reference that is given to the page names of Advocate Riley's statement. You would have noted the documents all start with SR.
So I was asking you about SRF.
No, it should be, it should simply,
wait a minute, that you see at paragraph 13, 14, 15, 16, 17, 18,
I think, Madam Chair, she seems to say
to the end.
it should say SR5. It should SR5. They just use the F to represent the 5.
Ascertain it with the witness.
Advocate Riley. Advocate Riley, are you there?
Yeah,
If you go to
I am, yes.
if you go to your to the document that we've just been talking about, and starting at number 12, no, number 11, where there's a reference like in Kwamashu 629 of 4 of 2009, where there's a reference to pages. It says 70 to 71 of part 2 of SRF. Can you just explain what is SRF?
It's just a grammatical error. It should contain the number 5
So
instead of F.
So where we see an F, we should substitute that for a 5, a numeric 5.
That is correct, yes.
Thank you. Advocate Riley, thank you for compiling the list.
Yes, ma'am.
It appears to me that in most of these cast numbers, ballistic reports had been filed and had been considered by your team.
That is correct, yes, Madam Chair.
And the report, your report, does not contain a summary of the ballistic reports that you had looked at and analyzed?
What it does contain is reference to the ballistic report in terms of the whole docket, the relevance of it.
My question is, the report itself does not contain the summaries of your analysis of the ballistic reports.
That is correct, yes.
Thank you.
So,
Before you do, let me just find out from my sisters whether they have any question in relation to the list. Yes, thank you. None, you may proceed.
Chair. Thank you, Madam Chair. Advocate Riley, just before we step off this document, in light of what you've just said to the chairperson, in response to the chairperson's question pertaining to your report not containing the summaries or analysis of each ballistic report that you had analyzed, and us only finding that in SR5, which was not given to Advocate Batoi. So would I be correct to say that if Advocate Batoi did not have SR5 and she did not read the documents, the dockets herself, she would again not know what those reports contain? Would I be correct to say that?
If she didn't read the dockets, yes, she would not know what those reports contain.
Yes. We will come back to that. Now, yesterday, when we adjourned, we were about to start on paragraph 71, where you tell us the conclusions that you reached in the task that as a panel you were given. And you tell us in summary that first and foremost, you considered the basis on which the authorizations granted by Advocate Jiba were set aside. And you cite two reasons. Firstly, that Advocate Jiba relied on the unsworn and undated statement by Danikas, which statement also did not cover the period within the indictment, save for one case being the, for one case. Is that correct?
It is correct, yes.
And the second one is that Colonel Ayer's statement does not in any way whatsoever implicate Boysons in any of the offenses. That was your reasoning.
That is correct, yes.
Yes. Now, I'm not sure. I'm just going to ask Advocate Lekgetho to just take you quickly to the judgment by Gorvin in CL 0037357.
May we refer to him as Govan J?
Gorvin J, I apologize, Madam Chair. Madam Chair.
Yeah, maybe before she does that, Advocate Riley, I see, the part that now the Advocate Matoni is taking to relates to the certificates that were issued by Advocate Jiba.
That is correct, yes.
And at the time when you were requested for an opinion by Advocate Batohi, already the issue of the certificates that had been issued by Advocate Jiba had been settled by the court.
That is correct.
And the court gave its reasons for setting that aside.
It is correct.
And why then did you still undertake the exercise of analyzing the certificates or information relating to the furnishing of the certificates by Advocate Jiba? And I'm asking you this because what you are saying is what is already said by the court, and much as there were issues about whether the concessions were correctly received by the court or not, it's not material. What is material is that, as far as we know, the matter was already settled by the court. And now you were reviewing what had been reviewed by the court, and the court had done a finding.
We were, as the panel, we were not reviewing that decision. The reason why we went to that decision, and in particular, it must be read in conjunction with Advocate Sean Abrams's affidavit in the second review application brought by Major General Boyson. He specifically agreed that the Jiba authorizations were inadequate, but he said in his analysis, and the reason why he granted the authorization is that there were new evidence, additional evidence that prompted him to grant authorizations. So it was obvious for our reason that we decided as the panel to look at what was the evidence that was available at the time when Advocate Jiba looked at granting the the authorizations, and what was then more available for Advocate Sean Abrams that was not available for Advocate Jiba for him to grant the authorizations. So it was not simply a case where we were reviewing the judgment. We considered it in terms of what they said were lacking in the application for racketeering authorization in the JIBA judgment, and then obviously to look at what Advocate Abrams had in addition to that.
Yeah, thank you. I'll ask you once more. When you are a prosecutor, am I right?
That is correct, yes.
And you have led evidence in courts.
That is correct, yes.
And you have pleaded with your witnesses to answer your questions.
That is correct,
And
yes.
you would see when your witnesses are going astray with the answers that they are going astray.
That is correct, yes.
Please disallow me from doing what you would do to your witnesses when they don't answer your questions. And the way to disallow that would be to answer the questions that I ask. I hear the long story, but let's go to the conclusion. Just to illustrate that the JIBA certificates were under review by your panel. If you go to the conclusion, in the conclusions, amongst others, you say that the certificates issued by Advocate JIBA should be declared invalid. It's one of the conclusions. And the court had by then already pronounced on that. And you are now saying the certificates of Advocate JIBA must be declared invalid. The certificates issued by Advocate Abrams should be declared invalid. And my interest in this is in you still pursuing what had been finalized by the court.
I've explained why we did that. I can't take it any further than the explanation as to why we went into the JIBA authorizations.
Yeah, I'm talking about declaring it invalid. This is what I'm asking you about now. You don't have anything to say. Is that
That
the
is
answer?
correct, yes.
Thank you.
That is correct.
Thank you, ma'am. Thank you.
Advocate Matoni, before you proceed, Advocate Riley, good morning.
Good morning.
You were asked to analyze the evidence for the benefit of the NDPP, Advocate Batohi, in order for her to take a decision whether she proceeds with defending or otherwise with the application that was before court. Am I right?
That is correct, yes.
And that was in 2017. Is it 2017? Let me just check the date. Because my question, 2019.
That is correct, yes.
Now, were you as a panel aware that in 2012, the DPCI, IPID, and a team of prosecutors worked on the very same documents, and there was some work done on the cases, on the issue of the Keto manor?
That is correct, yes. We found that information in the office file of the DPP South Gauteng, that they were starting to look at the Keto manor prosecution around about March of 2012.
During your analysis, did you get to sit with these teams, the team that was led by General Mabula? Did you interview them or have a discussion with them to understand better what was happening in relation to these matters?
Ma'am, are you referring to both the prosecution team as well as the investigation team? in respect of both, we have not met with any one of them.
You have not met with any one of them.
That is correct, yes, ma'am.
Were you aware that there was a stage where a member of IPID requested to open a number of dockets and reinvestigate them, and there was some preliminary findings that were made? I'm talking specifically about Ms. Williams, who was with the then ICD. Were you aware of that?
At the time when 2019, I picked up Ms. Williams' name as an IPID member only in the dockets. I was not aware of it, that she has started this type of investigation.
So you never consulted her also?
That is correct, yes.
Okay. Thank you, Chair.
Proceed, Counsel.
Thank you, Madam Chair. Now, Advocate Riley, as you were being asked by Madam Ramakaka, you explained the reason why you had to start off by analyzing what was before Advocate Jiba. And you tell us that you did so in order to understand whether there was new information before Advocate Abrams, which was not before Advocate Jiba when she granted the authorizations in 2012. Is that correct?
That's correct, yes.
Yes, and you said that the affidavit by Advocate Abrams tells you the reasons for that.
That is correct, yes.
Yes. Can I just ask you to go to SR 0179?
Just repeat it, SR
0179.
Can I just ask Advocate Legeto to assist me with that one?
Is she not there?
You can place on record what that
Yes.
document is.
It is the answering affidavit by Advocate Abrams in the second review application brought by Major General Boysons.
It's SR.
It's SR 0179. Is Advocate Legeto not with you there?
He is. I'm just trying to find it.
It's part of your statement.
I got it now in front of me.
Yes. At paragraphs 119 to 121, Advocate Abrams tells us what triggered his decision to grant the authorizations. And I will just, for the sake of time, read. He says, Mayama met with Danikas on about 20 January 2016. Danikas supplemented his aforesaid statement at NJ3 and handed Mayama additional photographs and video clips on a flash disk. Mayama returned with Danikas supplemented unsigned affidavit, which is attached as SM6. Dawood, Adam, and Mayama briefed me regarding their consultation, handed me a copy of Danikas' supplemented statement, and showed me certain photographs and video clips on a flash drive concerning the manner in which the Cato Manor SVC dealt with suspects. Now, satisfied, I issued the POCA certificates on the 13th February 2016 by signing the draft certificates provided by Matenja. Do you see that?
That is correct, yes.
Where are you reading, Counsel? SR 0159.
No, SR 0179.
79.
I apologize if I was not audible enough, Madam Chair.
And this is the affidavit of Advocate Yes.
Abrams.
Abrahams. Yes, thank you.
Yes. You then, in your statement, you set out the history that led to Advocate Abrams in your statement at SR 0023. You then tell us what your understanding of Advocate Abrams revealed, but what is important is that you, at paragraph 78, you said, upon his return from Greece, Advocate Mayama submitted a copy of supplemented statement by Danikas with certain photographs and video clips to Advocate Abrams. Upon receipt of this information, Advocate Abrams was satisfied and granted the authorizations. And then you then go on and say, we discovered that you then say, against the backdrop, we turned to the amended prosecution memorandum and compared same with the memorandum submitted in support of the authorization certificates on 27 August 2015. You said that we then say, we discovered that there were no significant differences between the two. So the only issues that the October 2015 memorandum contained was, you then list those. But what I'm concerned about is that, based at paragraph 81, based on their foregoing, we were of the view that there was no new evidence in the October 2015 prosecution.
You can't go so fast, counsel. You refer to paragraphs. We don't know what documents. You have to place all that on record.
Okay, if I may just read paragraph. You then say at paragraph 80, we discovered that there were no significant differences between the two memoranda.
This is SR 0024 of the affidavit.
Of my statement, yes.
Yes.
And then you then say the only issues that the October 2015 memoranda contained were the following. It now reflected that Cochrane was not the pilot but a crew member. It contained a schematic presentation of the Durban Organized Crime Unit, contained the detailed description of how the unit operated, highlights the roles of the alleged managers, and provided a summary of the modus operandi. But then you nonetheless go on and say, at paragraph 81, based on their foregoing, we were of the view that there was no new evidence in the October 2015 prosecution memoranda which could have satisfied Advocate Abrams to grant new authorizations. Do you see that?
Is correct, yes?
Yes, and we know that based on what Advocate Abrams says in paragraph 118 to 121, he was only persuaded to sign the authorizations after Advocate Mayama returned from Greece with a supplemented statement by Danikas, together with the photographs and video clips. Do you see that?
I see that, yes.
Now, I just want you to turn to SR 0449.
What volume?
It should be in volume 2, Madam Chair.
To make our task easier, counsel, if you can take us to the volume you have prepared us to, because we must get those volumes in front of us. You might have prepared your notes on a laptop. You have to take us to those volumes.
I apologize, Madam Chair.
What is this document at SR 0450?
It's the supplemented statement that was submitted to Advocate Abrams in January 2016 by Advocate Mayama upon his return from Greece.
A supplemented statement of Mr. Danikas.
Yes, which is what Advocate Abrams refers to in the paragraphs that we just referred to.
When you refer to documents, tell us what those documents are and where they are precisely.
I will do so, Madam Chair. Advocate Riley, are you there?
It is correct, yes.
Now, this is the statement that was submitted to Advocate Abrams by Advocate Mayema upon his return from Greece, which was given to him together with the video clips on a disc. And then what I want you to explain to the panel is your conclusion that which is on paragraph 81.4, where you say you are not convinced that the evidence of Danikas would suffice to prove similar modus operandi based on similar fact evidence. Can you just explain to the panel what is it in particular about that statement that you found so wanting to make you conclude that it would not suffice to prove the similar fact of modus operandi?
Let me just get to my notes book, please. What we did when we actually analyzed that statement, we also relied on Advocate Mahema's email to the attorney of Danikas when he said he was not prepared to use Danikas as a statement. So we also looked at the indictment, and so one of the first aspects that we actually concur with Advocate Mahema is that the incidents that Danikas referred to, any statements, draft statements, does not cover the period in the indictment. What the second aspect that we considered was the fact that there were never dockets registered in respect of the incidents that Danikas referred to. That was also confirmed by Advocate Mahema. Then he also indicated that Danikas is a potential Section 204 witness in terms of the Criminal Procedure Act, and that he might expose him or incriminate himself. And he said, we ourselves are not sure whether the witness is telling us everything. The chances of surprises in court may be real. At that stage, you also indicated that he did not, for the reasons above, it appears, considered Danikas to be a witness. Then, in terms of the statement, we also said that the statement in Greek was only signed, and that is when we refer to the unsigned statement. It was unsigned and uncommissioned on the 26th of October 2016, months after the NDPP signed the authorizations on the 13th of February 2016. The English translation was only made available to the prosecution on the 12th of October 2018. None of the statements were also made available to the defense, and Danikas has never signed the English translation, as he pointed out a number of mistakes. So when we indicated that based on all these challenges that were already identified by Advocate Mahema, we concurred with him and said basically there's going to be difficulty in proving that those were similar fact evidence.
Now, just to understand, so that I can clearly understand, what weight did the fact that the Danikas statement was unsigned, what weight did you as the panel attach to it to arrive at your conclusions?
We attach weight to it in a sense of we felt that a signed statement, even if it's not commissioned, will have probative value for us as the panel. But the fact that it was unsigned and uncommissioned, that was problematic in the sense of that, in light of all the aforementioned that I mentioned as well, the fact that they were not sure whether Danikas was going to be a witness as well, that should not have been considered, his evidence should not have been considered.
Yes. Then at paragraph 81.1, you criticize reliance on Aya's statement, Colonel Aya's statements. Can you elaborate why did you find that Aya's statements would not have assisted the prosecution team? When I say 81.1 of your statement.
Okay. I'm just looking. In respect of Colonel Aya, we did study all three of his statements. He made three statements on the 3rd of August 2012. That was after, I think, the arrest of the Cato Manor accused in June of 2012. We also looked at the subsequent supplementary statement that was requested by Advocate Matoni, as well as his statement that he made on the 13th of March 2013. We considered that his statement does not prove that Boyson managed an enterprise or participated in the affairs of a criminal enterprise. We indicated that there were hearsay evidence, and by that we meant that potentially the prosecution team could have and should have obtained further statements to corroborate his evidence in respect of the hearsay, where, for example, says he was told by certain persons that of certain things of Boyson. We felt, for example, in respect of Aya, if Aya was, for example, wanted to prove that Boyson was at the Cato Manor unit at the time when certain strategic decisions were made about the killing of people, that there were other corroboration that they could have obtained in the form of, for example, what were the times that he was at the Cato Manor unit. That is not clear from Aya's statement. It's a generalized statement that he makes that Boyson was at the Cato Manor unit and he was unaware of it. They could have done that through, for example, cell phone records that corroborates Aya's statement in the form of, at the time when Boyson was there at the Cato Manor unit was these times, by means of a pattern of communication, as well as the base stations that would pick up that Boyson was at the Cato Manor unit. So we felt that to rely on Aya's statement to prove that Boyson managed the Cato Manor unit, that it fell short of what was required as evidence to prove that in terms of Section 21E.
And then you then also find that you criticize the reliance on Commissioner Brown's statement. Can you explain that?
Commissioner Brown's statement, similar to Aya's statement, we found it didn't elaborate on why it contained. It didn't contain any evidence to show that Brown was in charge of the Cato Manor unit, that he managed it instead of Colonel Aya. His statement basically gave an organogram of the structure of the walks. He elaborates on the challenges in the relationship between Boyson and Aya. He said it was a volatile relationship. It also shows that between 2008 and 2010, the period of the indictment, that Boyson reported to Major General Brown, Masemola, and Lieutenant General Nkabinde. So we felt that there was a reporting structure in terms of Boyson, and that did not prove or show that he alone undermined Aya, and that he alone was, to the exclusion of Aya, commanded the Durban Organized Crime Unit.
Yes, but what is important is the the next issue that I want us, you criticize the reliance further by the panel, by the prosecution team, on the statements by Dlondlo and Matoni. Do you see that?
Can we just get to that, please?
It's 81.5 of your statement.
That is correct, yes.
Yes. Now, I just want us to look at those statements, and the closest where I could find them, Madam Chair.
Advocate Matoni, I'm sorry. Before you go to the statements, I have two questions for the witness. Advocate Riley,
Yes, ma'am.
remember that question that I asked, that did you consult with the team led by General Mabula, and you said no. But were you aware that Advocate Mahema was the lead prosecutor during that period when the prosecution was working with DPCI and IPID?
That is correct, ma'am. That was based also on internal email communication, where he was requested to provide us with all the information, evidence relevant to the Kaito Manor case.
Well, now, when you deal with Mr. Danikas' statement, you say that it was indicated in Advocate Mahema's memorandum that he might not call Mr. Danikas as a witness. Yet, someone went to Greece to take the statement. Did you ever interview Advocate Mahema to find out what is the game plan, or what was the game plan with trying to secure a statement from Mr. Danikas when it seems there was no intention of calling him as a witness?
There was no consultation with Advocate Mahema.
There was no consultation.
That is correct, ma'am.
Okay. My second question then is, do you, from your resume, you deal with poker-related matters, racketeering?
That is
And
correct.
obviously, you then approach the NDPP for authorizations.
That is correct, ma'am.
Now, do you normally share the statements that you submit to the NDPP for purposes of authorization? Do you normally share them with the defense first?
Before authorization.
Before authorization, do you share with the defense?
No.
When you summarized what you found to be lacking, one of the points that you made was these statements were not shared with the defense. Can you just think back and explain to us what you meant when you said these statements were not shared with the defense? And in the backdrop of you saying that when you go and apply for authorizations, you don't share the statements with the defense.
That is correct, yes. This was Danikas' lawyer, and in that the communication related to as to why he felt he will not call him. That is what I indicated. And then in respect of the Danikas statements that were not shared by the defense, we also tried to get hold of those statements. And it's in that context that I said those statements were not at any stage, even after the authorizations were granted, was shared with the defense.
Which authorization are you referring to? Because you were dealing with the period of Advocate Sean Abrams at that stage, and you were dealing with a statement that was secured, I think, in 2016. the Greek statement, the Greek version in 2016 and the English version in 2018. So which one are you referring to that it was not shared with the defense?
It's the that one, ma'am, the one in terms of the Abrams authorizations.
So you were saying, your point is the statements should have been shared with the defense.
What we felt, if there was confidence in calling Danikas as a witness, there would have been no problem that after authorizations were granted, after the matter has been enrolled on the court for trial, to have provided those statements. And that was a key question. Why not? What was the problem with the statements? Why couldn't you provide it as part of your a request for further particulars?
And that takes me back to the question, did you say you did not consult with Mahema, so you did not know, with Advocate Mahema, pardon me, so you did not know his reasons why he was keeping Mr. Danika's statement under wraps?
Ma'am, I speak under correction, but I will go back to my email communication, and I think it's the reasons why he didn't share it is because it wasn't signed or commissioned, and they didn't have, for example, the Greek translation into English.
Okay. For now,
And then, sorry, ma'am, and just to make the extra point, that was also what we considered in terms of his reluctance to call this person as a witness.
Advocate Riley, are you aware that the two people that we are about to look at their statements were both killed? The two potential witnesses in these cases were both killed.
That is correct, ma'am.
Did you ever consider the safety or not of the potential witnesses while you were analyzing the evidence before you as a team?
Ma'am, can you please explain the question? Did we, if I understand it correctly, did we, during our analysis of the docket, considered the safety of the witnesses?
I'm saying, are you aware that those two potential witnesses were subsequently killed, or they subsequently died?
I'm aware of that, ma'am, because we do it as part of our analysis when we looked at the probative value of the evidence.
And what I want to put to you, or what I want you to explain to us is, given that the two potential witnesses have been killed under circumstances that are, I think, up to today, have not been explained, did you ever consider that the prosecution might have decided to keep the fact that Danikas is going to be a witness a secret in an effort to try and protect him, given that the two potential witnesses, the two people who came forward and gave statements, have been killed? Did you take that into consideration?
We worked on the evidence, the files, and what was contained in the files. So, as I indicated, in respect of Mahema's email, that was an important piece of evidence to look at, his reasoning. If I found in any of these files an indication of that nature, I would have been able to tell the panel that, and I haven't come across that reasoning in any of the files that I have read, as well as the panel, that he gives that as an indication. So I have not, from my side, have considered that.
So as the panel that was analyzing the evidence in order to advise the NDPP, you never considered that. You just confined yourself in what was on the paper or in what was in the emails. You never thought outside what was before you.
We had to indicate to the NDPP the evidence upon which the decision was made to grant authorizations in terms of 21E and 21F. And that is what we worked upon in coming to our decision. And you're absolutely right if you say that we did not consider that.
Thank you.
Proceed, Council.
Thank you, Madam Chair. Now, ma'am, we were going to deal with your criticism of the reliance on the Londlo statements. And as I was telling you, the closest where I could find them would be in Advocate Mayama's statements. Madam Chair, it would be the annexes to Advocate Mayama's statement on page 1, Annexure GSM 8, page 157 of Advocate Mayama's statement.
Is this with reference to paragraph 81.5 of the witness statement?
Yes, Madam Chair. One five seven.
Advocate Msweni, I don't have that document. Can I just please ask for assistance in that regard from Advocate Legetu?
Yes, in fact, that I would have thought that when we refer to documents, she will assist you in that regard. Can just ask her to open that document for you on her device. Annexure GSM 8.
What is the document?
It's the statement by Beginkosi Mtiane Londlo. You would find that on page 157, going all the way to 163 is the handwritten, but then there's the typed version from page 164.
Can you refer
Or-
to the B numbers, please? Because
or it's-
there are a lot of numbers there.
Okay, it's 1A-186, Madam Chair, I apologize. 1A-186. Mr. Morane just pointed out that I was using the wrong pagination. It's the 1A-186. I was using the top page number, Madam Chair, I apologize for that.
And it is the statement of who?
It's the Londlo statement by, it's Beginkosi Mtiane, looks like also known as Londlo.
Does the witness have the statement?
Advocate Riley, do you now have the document in front of you?
I do.
Yes, I will focus on the typed version that is on page 1A186. And did you see, when you considered the documents, did you as the panel see this document?
I'm just trying to find the type one.
You say, did you guys?
I retracted that, Madam Chair. I apologize.
Can you indicate where can I find this statement? The typed one.
It's Advocate Nkcukaitobi is 1A-186.
Yeah, this is the one. Is that the statement that starts with, I'm an adult male, and the
Yes,
deponent name deleted?
yes, that is the handwritten statement is the one above that. So because of it's not clear, I'll just focus on the typed version because the typed version is easier for everyone to read.
Does he have the typed version in front of him?
Do you have the typed version? She has got the typed version in front of her, Madam Chair.
Advocate
That is
Riley, the statement should have 164 bold letters on top. Devon Central case 185/02/2009. Do you have that? Right on
I
top?
have it now.
Yes.
I have it, Madam Chair.
And it says deponent name deleted, states under oath in English. That's the statement. You have it?
That is correct. I have it now, yes.
That's good.
Yes. Mr. Dlondlo starts off at paragraph 1. He tells us his details and that he's the taxi owner at Stenga Taxi Association. Do you see that?
That is correct, yes.
And then at paragraph 2, he tells us about the people who were killed and how monies were paid for that. Do you see that?
That is correct, yes.
Mr. Matoni, sorry, before you established that the witness has this statement, you had asked a question and the witness had not answered that question.
Thank you, Madam Chair, Madam Advocate Nara, for reminding me. Advocate Riley, I had asked you that as the panel, when would I be correct that you considered this statement when you made your report?
That is correct, yes.
Yes. And you then arrived at the conclusion that these statements would not have sufficed, and you cite the following reason. Firstly, that it is not clear whether this witness was warned in terms of Section 204 of the Criminal Procedure before they make the statement, and thus that the evidence will have to be treated with caution. And then the third reason is to say that the evidence would have constituted hearsay. Do you see that?
That is correct. That is correct, yes.
Now, the reason I've taken you to this statement and referred you to paragraph 1 is so that you understand, and I take it you understood, that Mr. Dlondlo was the taxi owner at the Stenga Taxi Association.
That is correct, yes.
And would I be correct that as the panel, you understood that some of the members who, the suspects or people who were killed were members of the KwaMaphumulo Taxi Association?
That is correct, yes.
And that there was a rivalry between Stenga Taxi Association and KwaMaphumulo Taxi Association?
That is correct.
And would I also be correct that amongst the documents that you had considered was the application that had been brought by Mr. Bongamkize?
That is correct, yes.
And if you recall what is in his affidavit, he alleges that the Cato Manor squad was being used as a hit squad by the Stenga Taxi Association to eliminate members of the Goma Taxi Association. Do you recall that? Did you read that?
That is correct, yes.
Yes.
Yes, that is correct.
Now, Mr. Mtiane or Mr. Dlondlo then takes us into what was happening in the offices of the Stenga Taxi Association. Right? Do you see that?
Yes, that's correct.
And I just want us to start off at paragraph 164, at paragraph 4 on page 18-187. Right? He says, I would also like to state that after the death of well-known provincial commander of taxi violent crime, Mr. Konko, I was one of the trustees at the Stenga Taxi Association. I was the chairman of the disciplinary department within the association. I knew every secret that members do not have to know. Do you see that?
That is correct, yes.
And then he then tells us that I have always have secret meetings with the following members of the in the association. Mr. Kanyile, who was the chairman, Mr. Ngobo, who was the vice chairman and also treasurer, Bongizo Mhlongo, who was the PRO, and Sanele Zondi, who was an additional member. Do you see that?
That is correct.
And then at paragraph 6 says, our meeting were so sensitive even to discuss people who must be killed. Bongizwe was a close friend of Mr. Konko. Mr. Konko would always make favor to hitmen of Stenga in order to arrest Koma Pumulo Taxi Association. If there was something against Stenga Taxi Association, Bongizwe would organize payment to Mr. Konko. Do you see that?
That is correct, yes.
In the course of Mr. Konko's death, he was investigating and wanted to arresting members of Mapumulo Taxi Association. Mr. Konko was killed by Mapumulo Taxi Association. Nkosi Zondi was a policeman working at Cato Manor unit. Information was taken to Nkosi Zondi, and Nkosi Zondi arranged with his unit, Cato Manor, and also boys and his commander. Do you see that?
That is correct, yes.
And he then goes on to say, the first member of Mapumulo Taxi Association to be assassinated was Lindelani Buthelezi. Lindelani Buthelezi was killed by Cato Manor unit as one of the trustee was there when money was arranged. I think he wanted to say as one of the trustees I was there when money was arranged to pay Cato Manor for a job well done. A lot of money. Sanele and Bongizo were said to see Nkosi Zondi and paid him money. We were told feedback that Nkosi Zondi was paid the money. I cannot recall how much it was. Do you see that?
I see it, yes.
Yes. So, but the gist so far is that this is a witness who says, I had intimate knowledge of what was going on within Stenga Taxi Association. I was privy to the relationship between Stenga Taxi Association and the Cato Manor unit. He does not say that I was told. Now, against that backdrop, I wanted to understand what would be the reason that you would say that Dlondlo's evidence would be would not live up to would constitute hearsay when he gives you the direct evidence.
In terms of the fact that he was deceased, that it would amount to hearsay, but we were alive to the fact that in terms of Section 2, subsection 2 of POCA, hearsay evidence as well as similar fact evidence and previous convictions can be admissible in POCA prosecution. But we further looked at the fact that this was a person that in terms of Section 2 of the Criminal Procedure Act was also an accomplice witness We felt that he was not warned in terms of Section 204 of the Criminal Procedure Act, as was required by our case law. Then, part of his evidence, he also speaks about Zondi. I think in terms of Zondi, he was already deceased as well. And then he merely refers to Boyson. We felt at the time that they could have done a lot more, even before when he made that statement, to find corroboration as a Section 204 witness for him. And then we also know that there were other, I'm not entirely sure whether it was his statement or Matoni's statement, where there were two persons that actually disputed the fact that any of these things happened, as he indicated about meetings with Mostert and another white male. So we felt that it amounts to double hearsay. It would have been much more easier if it wasn't double hearsay. Then we also felt that he was an accomplice witness, and we felt that even if we look at Savoy and other decisions that deals with Section 2, subsection 2, the question still going to arise in terms of the unfairness of a trial of this nature to present that evidence in court. So those were our considerations when we looked in particular at his statement.
Yes. But were you aware that Mtiane at the time, and when you looked at the record, could you find any evidence that he had or he was charged?
This person,
Yes.
the witness,
Yes.
no, we couldn't.
So he was just a witness who was not charged.
He wasn't charged for any. Are you asking me, was he charged for any offenses that I'm aware of?
Yes.
No,
relating to the incidents that gave rise to why we're here.
No, and that's why we debated around whether he was a Section 204, why wasn't he warned? Why, if he's an accomplice witness, potentially why wasn't he charged? Why didn't he, for example, plead on these charges and then use him as an accomplice witness? So those were the considerations around it. He wasn't warned, he wasn't charged, and then in terms of we felt that based on those factors that it wouldn't amount, that it could amount to an unfair trial.
But would you agree with me that the question as to whether it would be fair or unfair to introduce hearsay evidence is a matter that would have to be raised at the trial, not at the decision-making stage?
We based it on the fact that in terms of our policy directives, that as a prosecutor, when you exercise your discretion, there are various factors that you will take into consideration. And this will include one of those factors that you will consider. We are not required to take each and every matter to court. Even if it's prima facie evidence, we still have to find that we still have to look at whether there are reasonable prospects of success. And those were the factors that we also considered in terms of our discretion and how we exercise our discretion. So in my opinion, when you actually as a prosecutor have to make your decision, your policy directives gives you guidance. It gives you guidance in respect of what factors one should consider. And in our opinion, this was one of the factors that we can consider whether it will lead to an unfair trial. Not necessarily that it's only in the domain of the court to make that decision.
Can I just, as a follow-up, did you find out whether this witness was warned in terms of Section 204 of the Criminal Procedure Act, or you assumed because you didn't find anything on paper that this witness was warned? And
we studied.
And then my next question would be, please address us on hearsay evidence in terms of the POCA Act.
maybe I can, in terms of, is it two questions? The one was, I'm sorry, I just want to make a note.
Okay, let's do this. Sorry, ma'am, to do this to you. Did you verify that this witness was or was not warned in terms of Section 204 of the Criminal Procedure Act?
We couldn't find any evidence of it, as I indicated before, in any of the dockets that we read. And I think these statements were primarily filed in the Durban Central, I think it's 85, that case number of that docket. So we studied that docket in terms of whether we could find anything in that docket that relates to him being warned in terms of Section 204, and we couldn't find anything.
And you didn't take steps to try and find out?
No.
Okay. Then the next question is, please educate us on the admissibility of, or not, of hearsay evidence in terms of, I think it's Section 2 of the POCA Act.
In terms of Section 2 of the POCA Act, Section 2, subsection 2, was discussed at length in the Savoy decision by the Appellate Division. And it was accepted that in terms of POCA, previous convictions, hearsay evidence, as well as similar fact evidence can be admissible. So, but the understanding is it must be in the interest of justice and it must not lead to an unfair trial. Those are the considerations. So, according to us, you still bring an application before court and try to convince the court that it is in the interest of justice and that it would not lead to an unfair trial. And so you will obviously look at other factors such as prejudice to the accused as well.
So that can be decided by a judge at the criminal trial?
Yes.
Madam Chair, I see it's 15:15. I'm alive to the fact that we lost an hour before we could start. I'm happy to proceed, but I know that there are people who are statutorily entitled to a tea break.
Advocate Msweni, can I also take a comfort break, please? Just for a couple of minutes.
We will take a tea break until 11:45. Thank you, Advocate Msweni. You are still under oath, madam.
Okay. Yes, ma'am.
Ola Jane.
Hello?
Good day. Good day, Advocate Chauke. Good day, Madam Advocate Riley.
Good day, ma'am.
You continue to be under oath, madam.
I confirm that, Madam Chair.
Advocate Mchweni, you may proceed.
Thank you, Madam Chair. Advocate Riley,
Remember your undertaking that you'll finish leading before lunchtime. Are we still on that?
Madam Chair, may I not make an undertaking, but I can say I'm on track.
You're on track.
Yes. I just don't want to
Well,
make
you
an,
did make an undertaking this morning.
I just don't want to make an undertaking in the public. But,
In the public.
Yes. But I confirm the undertaking.
Well, you did undertake to finish leading before lunchtime at Chambers, so we accepted that. Try to expedite your evidence in chief
Yes.
to the extent reasonably possible so that Advocate Ngcukaitobi can start cross-examining the witness.
Advocate Riley, I was referring you to the two statements, being the statement of Londlo as well as Mtiane. But I want to just jump because we're already exhausted where you... Can you just conclude, based on your previous evidence, just conclude what your... just read out what your conclusions were in relation to the prosecution's reliance on the statements of Aya, Brown, Advocate Mayama's memorandum, the challenges raised by Advocate Mayama in his memorandum relating to the utilization of Danikas, as well as the probative value of Danikas' statement, as you set out in paragraph 82. What were your conclusions in that regard?
Which says, in the premises, we concluded that Advocate Abrams' reliance on these statements were misplaced and that there was no new evidence before him when he granted the authorizations on 13th of February 2016.
Yes. You then go on to look at, over and above that, you then went on to analyze the evidence, whether was it sufficient to, to sustain the charges of racketeering. And you first looked at against Major General Boysons, is that correct?
That is correct, yes.
And you looked at it from, firstly, the premise that whether the prosecution would have been able to prove the existence of a pattern of racketeering.
That is correct, yes.
And then you say, in order at least to prove the element of section contravention of 21E, one of the offenses that would have to be proven was that Major General Boyson would have to prove that there were at least two or more of participated in two or more of racketeering activities of the Katomena unit.
That is correct, yes.
And you then found that you then referenced that against the backdrop of the predicate charges, and you say that although Major General Boysons was charged with 6 predicate charges, all of them arise from one incident which occurred on the 22nd September 2008 under Howick case number 106 of 09 of 2008.
That is correct, yes.
And you say this would not have been enough because the predicate offenses or the racketeering activities must not arise from the same incident.
That is correct,
Can
yes.
you just elaborate on that, just briefly?
When we had a look at the Howie case docket, because that appears to be in terms of 21E, where the prosecution have decided to list counts 8 to 12 in both the August 2012 and the August 2015 indictments as the reason why Boyson can be charged in terms of Section 21E. Now, when we studied counts 8 to 12, we found out that it related to the one incident in the Howie case 1069 of 2008. And based on the case law, we said that predicate acts, and when there's a reference to offences, right, cannot arise out of the same incident or event. And part of our discussions around this related to our pattern of racketeering. Now, the pattern of racketeering must be planned, ongoing, as well as continuous participation in And we found that in terms of simply referring to the same incident, it's not going to meet the requirements in terms of a pattern of racketeering activity. In other words, what we ordinarily will look for is not one incident, but multiple incidents over a period of time. So, for example, it could even relate to robberies committed over a period of a couple of days. That will satisfy a pattern of racketeering activity, and not the fact that it could potentially be just simply one robbery where there are multiple counts in terms of robbery of several people, possession of firearm or possession of ammunition. It must relate to the pattern of racketeering activity, what is described as a pattern of racketeering activity. And we found that in terms of Section 21E, the one count in Howie does not satisfy that requirement. We do say, if you look, for example, at our report at paragraph 153,
I beg your pardon, Advocate Mtsweni, are you following what the witness is saying, elaborating?
Yes, Madam Chair.
Does she answer your questions?
In fact, I wanted to come in and say, can you just explain, just answer the question? Advocate Riley, the question is simply this. Can you just explain why you say that the incident of the Howick incident would not have been sufficient to prove pattern of racketeering activity on the part of Major General Boysons? That's all that we're asking you to do.
Okay. It relates to the same incident. And it's the requirement in terms of 21E, it must be 2 or more predicate offences, which cannot come from the same incident.
But there's evidence before this tribunal, this panel, this inquiry by Advocate Maema to say, well, and Noko, who say it's not necessary. All that you need to show is a pattern of racketeering activity. And when one looks at the predicate offenses with which Major General Boyson was charged, he was charged with 6 counts, with 6 predicate offenses, and which then leads to the threshold of 2 or more of the racketeering activity. What is your comment on that?
I don't agree with that. It refers to the same incident, and it does not comply with the pattern of the description or definition of a pattern of racketeering activity.
Yes. Now, just then we turn. Chair, did you have a comment?
Can I just clarify before you proceed? Can I just clarify one aspect with you, Counsel? In relation to the entire of paragraph 81, read with your conclusion at paragraph 82 of your affidavit. When you prepared your report, Had you read the judgment of Govan J?
That is correct, ma'am.
Paragraph 38 and 40. Paragraph 38, 39, and 40. Do you have the judgment in front of you?
Sorry, ma'am, I don't have it.
As at the time of preparing the report, judgment was already handed down, correct?
That is correct. We referred to it in our report as well.
Yes, and my sister dealt with it. My sister, Madam Ramakaka, referred to it earlier. And if you can read into the record, paragraph 38, 39, and 40 of this judgment. You can just end at 39. 38 and 39.
Paragraph 38, I hasten to emphasize that this outcome is based purely on the facts of the present case. It does not provide a basis for opening the floodgates to applications to review and set aside decisions to issue authorizations, to prosecute under Section 2, subsection 4 of POCA. If the respondents had properly understood the principles of legality, it seems to be that their responses to demands for documents or reasons might have been different. As mentioned, there is a reference to documents in correspondence, and the NDPP state that she will not detail all the information placed before her prior to her making the first informed decision. Had she outlined even in basic terms what these documents and information comprise, said that she relied on them and shown that they had included information linking Mr. Boyson to the offences in question, this application might not have seen the light of day. The rhyme or reason test for rationality might have been satisfied. The level of disclosure of the NDPP for offences of this nature cannot be such as to prejudice the states in its conduct of a future trial. In my view, it will therefore not require an exacting, still less an exhaustive level of disclosure. The Vries found that the consideration of a request for authorization forwarded to the NDPP under cover of a letter summarizing the form and content of the charge sheet, setting out a detailed background to the charges and summarizing the evidence was sufficient. It is certainly not necessary to disclose every detail of the state's case, strategy, or evidence when this is not subject to the criminal discovery process. In light of the provisions of POCA, it is also not necessary to have before her sworn out statements from witnesses on which the state intend to rely. I expressly refrain, however, from making a positive finding as to the level of disclosure necessary in meeting an application such as the present one or the detail required. This can only be assessed on a case-by-case basis. It is important to note that the above findings do not amount to a finding that Mr. Boyson is not guilty of the offences set out in counts 1 and 2 and 1812. That can only be decided by way of a criminal trial. Setting aside the authorizations and decisions to prosecute also does not mean that fresh authorization cannot be issued or fresh decisions taken to prosecute if there is a rational basis for these decisions.
At that time, the impugned authorization certificate related to the certificate that had been issued by Advocate Jiba. Am I correct?
That is correct, ma'am.
And the judge there says that future applications could then arise. Correct?
That is correct, ma'am. That is correct.
And they did arise before
That is
Advocate
correct.
Abrams.
Correct.
And the judge specifically said that he was not excluding a possibility of General Boyson's being found guilty by a court or not guilty.
That is correct, ma'am.
He is also saying there that similar facts evidence and hearsay evidence are admissible.
That is correct.
And further that that which appeared in the application for authorization need not have been fully detailed in the sense of everything being included in that application.
That is correct.
And you then concluded in that paragraph, having found that their evidence, including that of Mr. Dondo, the evidence, the statement of Mr. Dondo, Mtiani, Mr. Danikas, and others, introduced hearsay evidence, and the likelihood was that the application to admit such evidence and the granting thereof would have been slim, according to your affidavit.
That is correct, ma'am.
Why so?
As I
Against the
explained,
background of what the judge states in the judgment.
we accepted that, Madam Chair, that that type of evidence can be admissible. But in respect of the hearsay, we first of all says that the testimony of the two deceased witnesses amounts to double hearsay. We also said that in respect of that,
I beg your pardon, whether it is double hearsay or triple hearsay, according to the judgment and the law now, as we understand it, and you also referred to the Savoy judgment, hearsay evidence is admissible. It doesn't matter whether it's double or triple or 4 times, isn't it?
that is correct, ma'am. However, you must see that in the context of the statements, when it was deposed to, we make that point in respect of these statements as well, that many of these statements were taken down that relates to incidents in 2007 and 2008, was taken down on the 1st of July 2012, as well as the 31st of July 2012, and then the 15th of March 2013, which is years after the incident. So that's a consideration. Then we also considered the fact that there was no corroboration for these witnesses. The only corroboration they had were in the form of 2 witnesses, Saneli Zondi and Bongiswe Zondi. But they have disputed the averments of the witnesses. So that's another aspect that we did consider about the probative value of the evidence and how high or low that probative value will be.
Yes.
Then we also mentioned the fact that of the 204 witness.
Don't be fast,
Yes.
and just stay calm.
Okay. So then, sorry, ma'am.
Just be brief and just answer the question briefly.
Then besides the double hearsay evidence, we also said that they were warned they should have been warned in terms of section 204 of the evidence.
I've noted your extensive experience according to your resume, including the fact that you had experience in relation to the POCA applications for authorizations, summarizing dockets in relation to those poker matters. Am I correct?
That is correct, ma'am.
In other words, you do have experience in relation to the poker proceedings and the understanding of the law.
That is correct, ma'am.
Poker in particular.
That is correct, ma'am.
Given the complex nature of this piece of legislation, especially in relation to organized crimes and white-collar crimes, and given all these issues relating to admissibility of certain evidence, hearsay evidence, for instance, and similar facts evidence, etc., was it not appropriate to let the court decide on these matters? Especially because when you prepare this report and you say so in your evidence, in your statement, that as at that time, the investigation was not complete.
That is correct, ma'am. The investigation was not complete.
That being the case, and as a prosecutor, I'm sure you will agree with me that an investigation in a criminal case does not stop. It can even continue during the trial. Am I correct?
That is correct. That is the law.
Now, having so found that the investigation was not complete, you nonetheless made the conclusions you made.
Yes, ma'am, and I will explain that. If you look, for example, and it's contained in SR5.
I just want the answer. You nonetheless made the conclusion, despite the fact that the investigation was not complete, and it is common course that investigation continues, even if the matter is before a trial court. Why then do you give a conclusive response or recommendation without even recommending that the investigation should continue?
Our recommendations were that the authorizations were invalid, and in terms of the predicate offenses, we did say that the investigation should be completed, and in the event of completion, the DPP KZN can make a decision whether she wants to institute prosecution or not. But we also have to remember, we dealt with this matter in 2019 relating to incidents from 2008. So at the time when we received the dockets, there were no attempt on the part of the prosecution team to actually complete the investigation, not in 2012, not in 2013, and not in 2014 or 2015. So there were time periods available for them to have completed the investigation. So by the time we received it in 2019, we received incomplete investigation.
You nonetheless recommended as you did?
In terms of the racketeering authorizations, and as I indicated, in terms of the pattern, if that was your pattern of racketeering activity, there were opportunities for you to
Is your answer yes or no, please? You nonetheless recommended as you did, despite the fact that the investigation was ongoing?
We made a recommendation that the investigation should be completed.
You did recommend that the investigation should be completed?
To Advocate Zungu, and we did say that in the event that it's completed, she can make that decision whether she wants to institute prosecution, further prosecution or not.
You did make a recommendation in relation to the validity or otherwise of the authorizations?
That is correct, based on the evidence in the dockets and in the files and before us.
Advocate Riley.
Yes, ma'am.
Maybe I should we should first look at the caliber and status of persons that constituted this panel that was to assist the NDPP to decide whether to review and set aside the decision of Advocate Abrams or not. It is correct.
Yes, ma'am.
Yeah, it is correct that all the panelists were juniors of the NDPP, or they were junior to the NDPP.
That is correct, yes.
And it is so that when one looks at the affidavit of Advocate Sean Abrams, he sets out the reasons why he pursued the issuance of the certificates later. That is correct.
Correct, ma'am. That is correct.
And Advocate Abrams is not doing that of his own accord, but it is in response to an application that was made by Advocate Noku for the issuance of the certificates.
That is correct, ma'am.
And actually, Advocate Noku, yourself, I think, and also Advocate Tenga also, you are actually peers. So it is your
No,
peer.
ma'am.
Are you not a Director of Public Prosecutions?
No, I'm
Okay.
a deputy
You
director
are a
of public
deputy.
prosecution.
Okay. No, that's even worse then. So you are actually junior to Advocate Noku.
That is correct, ma'am.
And I'm asking these questions because at the end of the day, you look at the origin and say, here are people who are put into office to try to query work that was done by some people that are seniors, right? So Advocate Abrams, when in his affidavit, I don't know why you chose the spots that you have referred us to, but if you are to look at that affidavit, Advocate Abraham says there were presentations made to me in support of the application for the certificates. Is that correct?
That is correct, yes.
And he says, I sent them back and asked for more information. And how do you see that approach, where a prosecutor says, or the NDPP says, I've read your material, I've seen your presentation, but please get me 1, 2, 3. Is that not a sign that he wanted to be satisfied that when he takes a step, he takes a step that he can be able to defend?
That is correct. He asked for more information or more evidence.
Exactly. And thereafter, more information was brought. There were presentations again. And he sent it back again to say, I want more information. In this case, amongst others, I want Danikas to be contacted in person. Is that correct?
That is correct.
And finally, the information of Danikas came. And it was not only about Danikas, but the rest of the information that he had wanted. And he expressed a view that he's satisfied that he can go on now to consider the application and finally grant the application.
That is correct.
And after all these efforts, I will not touch the issue of Advocate Jiba, because even there, the judge is quite clear that it's not about Advocate Jiba being wrong, but it's about failing to do certain things only. But then focusing on the application or the issuance by Advocate Sean Abrams, are you saying, you, the Deputy Director of Public Prosecutions, are you saying that in your view, Advocate Abrams did not exercise his prosecutorial authority appropriately?
I sat as a member of a panel, so there were 4 people on that panel. And the 4 people looked at the new evidence that Advocate Sean Abrams said were made available to him, and therefore he granted the authorization. And the panel found...
Did you hear my question, ma'am?
You're asking me in the context now.
Just a minute.
I beg your pardon? Advocate Riley.
You're asking me in the context... sorry, ma'am. Sorry.
Advocate Riley, if you may please listen to the question and don't interpose when my sister, Madam Mahaha, is asking you a question. Or for that matter, anybody. Just listen first and take your time to answer the question without giving a full answer that is not sought by anybody. Please try to listen to the question carefully and answer as brief as it is reasonably possible. Thank you.
Thank you very much, Chair. We've been at pains from yesterday to try to get direct answers to direct questions, but it's becoming even more and more difficult. The question that I've asked you, Madam, it's about your view about the appropriateness of exercise of prosecutorial authority by Advocate Abrams when he issued the certificates. And I've said, is it your view that his exercise of that power in that manner was not appropriate?
Madam, I can only speak in the context of the panel's decision. I did not make that decision on my own. The panel made that decision. So I did not, as a deputy director, reviewed the decision of a NDPP, if I understand the question correctly, and I may not.
You'll remember that amongst other questions that you were asked yesterday, and I think it was myself who wanted to know as to whether, do you align yourself with the contents of that report? Is it your report? And you said it's our report. And when I ask you and say you, I'm not talking about you as an individual. It's a product of the panel. Now that you know that when I say you, I'm not referring to you as an individual, I'm sure you understand my question. And the question is, and I'm asking it for the last time, you found it. You found the Advocate Abrams' decision or exercise of prosecutorial authority in a manner that produced those certificates that he produced as inappropriate and not in accordance with the law. That is the question.
Yes, we said that his authorizations were invalid. The panel said that.
Yes. And that would suggest that they are invalid because it's a product of the exercise of prosecutorial authority that was not in order. Answer?
His decision, yes.
Inappropriate, ne? Now,
Said that, yeah.
okay, you wanted to say something?
I said based on the evidence before us.
And maybe let us just take another step back to look at the Advocate Ngasana, just to complete this picture. Advocate Ngasana comes after the Judge Govern's decision or judgment. And what does he do? He looks at the material available and he says, I need more information. Do you remember that?
Yes, ma'am.
He does not say, this is a dead case. After he had seen the documents that he saw, he does not say that. Is that correct?
I can't speak about that. I do know that he was unhappy about the authorizations himself. Regarding if you can refer me to a statement or anything, I can comment on that.
Yeah.
But I can't speak for what Advocate Nakasana said.
Well, even the issue whether Advocate Ngasana would have been happy or unhappy with the certificates would not even feature, because already the court had pronounced. But then, in the face of the pronouncement of the court, what Advocate Ngasana does, he studies the material and then he says, you need to get more information for me to be able to exercise my prosecutorial authority. And he sends them to get the information. Are you aware of that?
No.
Does it just black out the issue of Ngasana?
No, if you can refer me to his statement or if he testified during this inquiry, I can comment on that. But I cannot say I know that's what he said if I don't know that's what he said.
Okay. Now then, I am maybe then bringing it to your attention that the evidence before this panel is that Advocate Ngasana was not satisfied. Then he sought for more information in order for him to be able to exercise his prosecutorial power to pursue justice. Any comment?
If that's what he said, I accept it, ma'am.
You accept it, yes. Well, I will not put something that is not correct to you. That would be very wrong of me to do that. So the picture that emerges is that so many prosecutors have spent so much time trying to deal with this matter of General Poisons and Company, and there have been blockades and blockades by people at different levels. At the level of the new NDPP and even at the level of the juniors that drew the report. Any comment?
No comment, ma'am.
Thank you.
Thank you. You may proceed, Advocate Msweni.
Thank you, Madam Chair. Now, okay, thank you, Madam Chair. Advocate Riley, you have told us why you believed that charging Major General Boysons for contravention of Section 21F was not proper because there was no evidence of a pattern of racketeering activity. But I just want us to shift our focus just whilst on Major General Poison to 21F, that is the management. You'd recall that Major General Poison was charged with 2 counts of racketeering. Do you recall that?
2 counts of racketeering.
Yes, the first one was the participation, contravention of Section 21E, and the other one was 21F, management.
That is correct, yes.
Yes. At paragraph 68 of your statement, you said that, I'll quote, in order to demonstrate management, our courts have pronounced that knowledge of an accused to be found guilty of management, the accused must or ought to have reasonably known that another person was engaged in a pattern of racketeering activity, close quote. Therefore, knowledge and not participation is required. Do you recall that?
That is correct, yes.
Yes. Now, you also found that the basically Major General Boysen should not have been found guilty of both counts of racketeering activity. But I just want us to focus on the management. And in this regard, I want you to please go to the same document that we're looking at, where we were looking at London's statement, but at Annexure GSM 23, page A18-305.
Page?
A18-305 of
you
Advocate
just repeat it?
of Advocate Maima's statement. It is the same document that had Matonzi's statement in it. No, London's statement in it that we looked at earlier before tea.
Can you just repeat that for Advocate Ngcukaitobi?
It's GSM 23, page 1A-305.
You can tell her what that document is?
Yes. It's the statement by Simpiwe Cyprian Matonzi. He's one of the people whose evidence you criticized as amounting to double hearsay when we looked at page 80 under paragraph 82.
It is
81.
annexure, I think you can just give the specific details. Annexure GSM 23. Madam Riley.
Yes, I'm giving the information to Advocate Ngcukaitobi.
Yes.
She's trying to retrieve it for me.
GSM 23, you have it?
She's trying to retrieve it. I don't have it yet.
Advocate Ngcukaitobi can look at that document at that page. It is the statement of Mr. Simpiwe Cyprian Matonzi, page 244, GSM 23.
I will have it now. She found it.
Yes, thank you. You proceed, Counsel.
Now, Mr. Matonzi tells us at paragraph 1 his age, and then he tells us in paragraph 2 that he was employed as a VIP protector guarding the Stenga taxi rank, and amongst his mandate was to guard the senior members of the Stenga Taxi Association, being amongst others Mr. Ngobo. Do you remember Mr. Ngobo was referred to in Mr. Ndlondo's statement as the chairperson of Stenga Taxi Association?
That is correct, yes.
Yes, and if you recall, Mr. Ndlondo told us that he used to have secret meetings with, amongst others, Mr. Ngobo.
That is correct, yes.
And we know that Mr. Ngobo was the chairperson of the Stenga Taxi Association.
That is correct, yes.
And in this case, Mr. Matonzi tells us that he was assigned as one of the protectors of Mr. Ngobo.
I confirm. That's what I'm reading, yes. That's correct.
Yes. Now, what he says, he's at paragraph 3. He says, sometimes I was also given tasks to guard Mr. Bibi Gwala. I was close to all the executive members of the association. I was a trustee to all executive members of the association. Even when they plan to do something wrong, like hire a hitman to kill someone, they will discuss in my presence. Some of the members of the association were close to the unit called K-Tomena unit. Do you see that? By paragraph 3.
That is correct, yes.
These members were Sanele Zondi and Bongeleni Zondi was a member of the K-Tomena unit.
That is correct.
Yes, and then it says Bongeleni only had a taxi within Stenga Taxi Association. The taxi were under or registered under his younger brother Sanele.
That is correct.
Yes, he said somewhere in 2007, I accompanied Sanele and Bongesiwe Mhlongo to meet Mostert and now General Boysen. The place was near Gateway Shopping Mall by Shell Garage behind the private hospital. After the meeting, I had a conversation about what the meeting was all about. Sanele and Bongesiwe wanted Mostert and Boysen to cover up if the police wanted to arrest members of the Stenga Taxi Association. Do you see that?
That is correct.
Sanele and Bongesiwe were untouchables because they had senior officials on their side. The day of the meeting, Sanele said the executive have to pay money to Keito Mena unit senior officer, referring to Mostert and Boysen that they had met. Do you see that?
That is correct.
And then at paragraph 6, it says, after a week, I was called to accompany Sanele and Bongesiwe. We went to Gateway Shopping Mall off McDonald parking. Bongesiwe had an envelope containing money. It was not inside. Upon arrival, we met now General Boysen and two senior officers were traveling in a grey BMW 5 Series. The driver was Mostert. And Bongesiwe and Sanele got out and went straight to the BMW. Bongesiwe had same envelope contained cash. I did not know how much it was, and it was a lot. Sanele and Bongesiwe remained in the car for about 45 minutes to an hour. Do you see that?
That is correct.
And then he says that in the process, there was a conflict between Stenga Taxi Association and Maphumulo. According to my knowledge, during those years I was there. Nobody from Stenga Taxi Association was either arrested or killed by Keito Mena unit. Right? And then says the only police officer who was a threat to Stenga Taxi Association was Superintendent Konko. According to association, Konko was a straight police officer. Konko did not take bribery either from Stenga or Maphumulo Taxi Association. If somebody committed murder relating to taxi, he would get out and arrest suspects without involving Keito Mena unit. And was not happy with Superintendent Konko. Sanele and Bongiwe were not happy with Konko. I heard them, Sanele and Bongesiwe, saying Konko was trouble and they will talk to senior officer referring to Boysen and Mostert to sort him. Do you see that?
That's correct. Just paragraph 9.
Yes, and then it says, paragraph 10, I heard them talking about the plan to kill Superintendent Konko. Sanele and Bongesiwe arranged someone who was a member of Maphumulo Taxi Association to organize a hitman for Konko. Sanele and Bongesiwe did not want to arrange or hire hitmen themselves. They, Sanele and Bongesiwe, wanted to be seen as Maphumulo are the ones who planned the killing of Superintendent Konko. Hitmen for Konko was Kopolota, Lim Tembu, and Swayo, and others. Do you see that?
That is correct, yes.
Yes. And he says Keito Mena unit was also part of the plan. Konko was gunned down. After the killing of Konko, Keito Mena started to kill all hitmen behind Konko. I heard Sanele saying that he had a list of all people that need to be killed by the Keito Mena. Bongani Mkhize was a chairman of Maphumulo Taxi Association. He was also on the hit list and he was the last person to be killed. It was difficult for Keito Mena to get to Mkhize because the reporting Mkhize did to the high authorities. Do you see that?
That is correct.
Yes. Now, the gist of this is that what Mr. Matoni seeks to do is to show that, paint the picture that Major General Boysen knew that in killing the members of the Maphumulo Taxi Association, I.E. Kopolota, whom we know was killed by the taxi, died at the hands of the taxi of the Keito Mena, and all the others, that basically this was a cover-up for what the Stenga Taxi Association did, or Keito Mena did, in killing Superintendent Konko. In essence, to show that, in fact, Major General Boysen knew that the Keito Mena squad was had embarked on a pattern of racketeering activities. Did you have regard to this statement?
We did.
Now,
and we
would-
did analyze it.
Yes. Now, if one reads this, it seeks to paint the picture that Major General Boysen knew, at least, or ought to have known, that the Cato Mena squad was in killing those people, was not looking for them, but was killing them.
And as I indicated before, it was a hearsay statement. It was a statement in terms of Section 204.
I beg your pardon?
It was a statement.
Wait a minute, madam. What was hearsay?
His statement. It
Mr.
amounts to hearsay in the
Mr.
Mr.
Matonsi's,
Matonsi.
Mr. Matonsi's statement.
That is correct, yes. Then, in terms of the requirements that that we considered for a Section 204, is the fact that one needs to find corroboration because you're an accomplice witness. So in this statement, his corroboration is actually two people that he said were also part of this plan. Now, these two people denied his statement and said that in actual fact it's not true. The question also remained is, as we discussed before, he could have been charged together with those other two people if they implicated themselves in these offences, which did not happen. So in our opinion, there was other outstanding information in terms of they could have indicated through cell phone records a pattern of communication, because it appears that they said that Boysen was part of the plan even to kill Chauke. On the other hand, it is also being said that the motive, the killing spree, started in 2008 as a result of the death of Chauke. So in our opinion, we did analyze the statement and it felt it was lacking.
But if you look at it, would you agree that in terms of poker, with the admission of hearsay evidence, and if this statement was to be admitted, the conclusion or inference that can be drawn from there is that Major General Boysen could have or ought to have known or may have known that the members of the Cato Mena were committing racketeering activities.
If the statement was accepted, yes.
Yes. And in terms of poker, that could be accepted. It can be accepted, if despite it being hearsay.
And the other factors that we considered, yes.
Now,
If the statement was accepted by who? By court? You've just said that if the statement was accepted by who?
I responded to a question by the advocate when he said if it was accepted.
okay.
Yes, now you answer that if it was accepted. I'm asking you, advocate, accepted by whom?
If there's an application before court and it satisfied all the requirements, it would have satisfied in terms of Section 2, subsection 2 of poker.
In other words, it will be the court that will make an assessment of whether such a statement is admissible or not admissible, inadmissible. Are you
If there's
saying
an application before court.
yes? Are you saying accepted in that sense?
Accepted, yes, in terms of Section 2, subsection 2, which allows
By
for
a
the start of
court.
evidence.
My question is
That-
by a court.
That is correct, yes.
Thank you.
Now, Advocate Riley, with what we have just demonstrated, can I just also ask you to go further insofar as the knowledge or otherwise, or the ought to have known fact by Major General Boysen, ask you to go to the same document that you were looking at, Maton's state, that you are looking at that statement. Look at page 1A162. It's the answering affidavit by Major General Boysen in the application that was brought by Mr. Mkhize. I just want to get your comment on something there quickly.
Can I just ask to get to the document?
For the sake of you identifying the page quicker, there is a top page 70 at the top. That would be Anisha GSM 7.
As Advocate Ngcukaitobi is helping you, Advocate Riley, might I
Yes,
remind you, yes, as Advocate Ngcukaitobi is assisting you, might I take this opportunity to remind you that you are testifying before us, firstly, because you have been involved, among others, in the preparation of a report on which Advocate Matoni relied when she made certain requests or recommendations. And secondly, because you seek to assist us in this fact-finding process. Do you understand that?
I do, ma'am. Madam Chair, I do.
We are not here to victimize you. We have no reason whatsoever to do that. We appreciate that you are here to assist us, and we require that you understand that to be the case as you answer the questions.
I do, ma'am.
We verily expect and honestly expect you to assist us in this fact-finding process.
I understand that, Madam Chair.
Thank you.
Now, Advocate Riley, did you find the document I was referring to?
Is that the statement of Johan Wessel Boysen?
Yes, it's the answering affidavit. Now,
Okay.
that affidavit was deposed to in the course of or in response to an application that was brought by Mr. Mkhize, who was the chairperson of KwaMaphumulo Taxi Association, wherein, amongst others, he sought to interdict the police from assaulting or killing him. You recall that application? It was part of the dockets. In
That is
fact,
correct,
in
yes.
fact, this affidavit in the Durban Central case is Annexure A92. Did you see that affidavit?
That is correct.
And if you read, the affidavit by Mr. Mkhize, the gist of it is that the Cato Mena unit was busy killing or killing members of the KwaMaphumulo Taxi Association, and he understood that he was on the hit list. Remember the list that Mr. Matoni, that we were reading from Mr. Matoni's statement of the people who had to be eliminated?
That is correct. I
Yes.
read it in his statement.
Yes, he said that there was a list. And Mr. Johan Boysen, in answering to that affidavit at paragraph 2, he says that the facts that are in this affidavit, unless were indicated, fall within his personal knowledge and belief, or alternatively have been obtained by him from files or documents under the or in control of South African Police Service. Do you see that?
That is correct.
Now, in amongst the allegations in the papers were that these members, your Kopolotas and others, were assassinated. They were actually not killed in self-defense. Do you see that?
In the papers.
You read that affidavit, is that correct?
Some time ago, yes.
Yes. Now, if one looks at it and with what I've just taken you through, do you still maintain that the inference that Major General Boysen may have known for the purpose of management is far-fetched?
Can you just repeat it so I can think about what you said?
I'm saying, based on what I told you through Mr. Matoni's statement, as well as what Boysen says in the answering affidavit. Now, would you say that the inference or conclusion that Major General Boysen knew or may have known that the Cato Menace Squad, which were embarked on a pattern of racketeering activity, would you say that that conclusion is far-fetched?
That is correct, yes.
Can you please explain that?
I'm trying to see, I do understand what you said about the Matonzi statement, and I indicated to you when we analyze it why we said it was of very low probative value. I need to understand the current statement. I need to understand your question. The current statement, what are you referring to me in this statement that in addition to the Matonzi statement explains potentially knowledge of what the Cato Manor unit was busy with? I don't understand that part.
In paragraph 2 of the answering affidavit, Boysen says that the allegations that he talks about in the answering affidavit fall within his personal knowledge, or it comes from information provided to him by those within SAPS. Right? Do you see that?
Yes, so it can either be within his personal knowledge and belief, but alternatively, he could have obtained that information also from files and documents under or in the control of the South African Police Service. That's how I understand it. But I'm trying to find out what are you saying is about that paragraph?
Now, if Boysen admits that he knows, because in the answering affidavit, he talks about the circumstances that led to the deaths of your Kopolotas and everyone else. Now, basically, he accepts that he knew how they died. Now, remember, for management, the requirement is knowledge. Now, if we accept that Boysen knew, do you still maintain that it was not proper for Boysen to be charged for racketeering for the purpose in contravention of Section 2 and F?
I don't see how paragraph 2 assists with that he had knowledge, because he qualifies it. I might have had personal knowledge, but alternatively, any information relating to that might have been obtained from files and documents under or in the control of the South African Police Service. I can't see how that paragraph 2 can lead you to that conclusion that he had knowledge of that the Cato Manor unit were unlawfully killing people.
So do you still maintain that they were not, the Major General Boysen, there was no evidence that he knew?
That is correct. And if I'm allowed to, I can qualify why I say that when it comes to knowledge.
Just briefly, ma'am.
And my...
Advocate Riley, you wanted to explain, to qualify. Can you just qualify that briefly?
That the evidence in the dockets doesn't show that he had knowledge that the Cato Manor unit was unlawfully killing people for rewards.
Can I follow up on your question, Advocate Ntweni? Advocate Riley, do you accept that GSM 7 is an affidavit prepared under oath?
That is correct, ma'am.
And do you further accept that the deponent says the fact stated herein are within my personal knowledge. And he says that under oath to a court.
But it qualifies it. Alternatively, it could have been obtained also from other sources.
Please don't
So-
don't leave me behind. I'm still coming.
Okay.
Do you
thank ma'am.
accept
Sorry about that.
Do you accept that he says the facts stated herein are within my personal knowledge and belief?
That is correct. I accept that's what he says in paragraph 2.
And then he says, alternatively, alternatively, I may have obtained them from the files and documents under or in the control of the SAPS.
That is correct.
And he further says, well, unless if the contrary is proven, but I accept that everything is within my personal knowledge.
That is what he says.
And do you accept that this is a standard way of saying to the court, I am not bringing hearsay evidence. I'm bringing evidence that is within my personal knowledge. Where it is not within my personal knowledge, someone might file or may file a confirmatory affidavit.
That is correct.
So do you accept that this is what this paragraph means?
Accept that what it means.
Thank
it's
you.
either information to his personal knowledge or alternatively that you have obtained from the South African Police Service.
Thank you.
Now, Advocate Riley, does it matter for the purposes of Section 21E as to how one acquires the knowledge?
21E or 21F?
21F, I beg your pardon.
We have to prove how did he acquire the knowledge.
Yes. But the question is,
That is-
does it matter?
Doesn't matter, but we still have to prove how we acquired the knowledge.
Advocate Riley, I'm going to really beg you to answer Advocate Ntweni's questions. If the question starts with, does it matter? Then it means the question should be, yes, it does, or no, it doesn't. Thank you.
Thank you, ma'am.
Now, just on your answer, when you say we have to prove, now, do you still have to prove when Major General Boysen says so himself that I know, when he makes an admission? He admits himself that he knows. He said so on his own words. I know.
And I still don't agree with you, Advocate Msweni, that paragraph 2 speaks only of personal knowledge. It's qualified by the fact that he could have obtained the knowledge from files, documents in the control of the South African Police Service. If it simply said there, personal knowledge, then I would have conceded to that.
Okay. Can I just make the following analogy? Sorry.
Advocate Mchene, I think you have been dealing with the issue of management
Yes.
for a long time. This could be a matter for argument.
Yes, thank you, Madam
I'm
Chair.
just getting worried that we are not making any progress, and we are still going to take a long time, I suppose.
Yes.
I think the witness has answered. Maybe you can consider moving forward.
Thank you, Madam Chair. Now,
May I just ask the witness, Advocate Riley?
Yes, ma'am.
It seems to me you are very angry as you
No, I'm
answer
not,
the
ma'am.
questions. If you can get composed, if you need a short break so that you can take a deep breath, let us know. We will allow you a chance to pause and reflect and come back. Against the background that I postulated to you, that we are here on a fact-finding process. We are not a court. we seek you to assist us, and we really plead that you assist us. Do you understand?
Understand that, ma'am.
You understand
Understand.
our approach?
That is correct,
You
yes.
have read the terms of reference, and you know why we are here. We seek
That is
your
correct.
assistance to the extent you can. If you cannot, you can say so. But don't be agitated, and I can see that you are very unhappy as you answer our questions. Do you need a break?
Yes, ma'am, please. Thank you. I would
Yes.
appreciate it.
Yes, please take a deep breath and stay composed. We'll pause for 5 minutes to allow you a chance to compose yourself, and we will come back in at about 1:15. We are still under oath, madam. We're taking this short break to give you a chance to compose yourself. We'll pause for a few minutes, Advocate Mchweni, and resume at 1:15. We will take a lunch break at 1:30. And I do so because I can see that Advocate Riley is just unhappy.
Madam Chair, if I might just say to Advocate Riley, Madam Advocate Riley, I'm not seeking to persecute you by asking you these questions. All we're seeking to do is to just ascertain and get clarity on the conclusions of the panel's report and test those conclusions. I'm not seeking to persecute you or prosecute you, ma'am.
We've made an observation as we are looking at the witness and the way she answers questions, and I think it is fair to her as she agrees that she needs to pause and compose herself. May we pause for a few minutes and give her an opportunity to compose herself. Thank you. And pause. Good afternoon again, Advocate Riley. Advocate Riley.
Hi, ma'am, I'm here.
Oh, good afternoon.
Good afternoon.
You feeling better?
Yes, ma'am.
Yes, thank you. You can take a glass of water, just put it in front of you, and take your sip as we proceed. You continue to be under oath, madam.
Yes, ma'am.
Thank you. You may proceed, Ndata Mutshweni, until 2 o'clock. We will take a lunch break at 2 o'clock, and hopefully you would have made progress by the time we pause.
I hope so, Madam Chair. In fact, I'm going to try now.
Remember, we have to work until late.
Yes, no.
But that does not necessarily mean that you must move slowly. Please, let's make progress.
Yes. Now, Advocate Riley, we've covered insofar as Major General Boysen is concerned. We now move on to the other members of the Cato Manor who were charged together with Boysens for management. That is Olivier, Eva, Lockham, and Van Tonder.
That is correct.
And you say that the prosecution memo is quiet or is silent as to what role they played in their, what is it that they did in their managerial roles. And on those basis, you then say that the fact that they were commanders or held senior positions within the unit is not of its own sufficient to prove that they were managers.
That is correct, yes.
Yes. And you say, in fact, this is one of the issues that I didn't cover under Major General Boysens. You then say, further, if they were managers and participated in and managed the enterprise, then one would have expected them to be charged for the underlying predicate offenses.
That is correct, yes.
Now, if I might ask, is it a requirement or necessary for one, when charged in terms of Section 21F, to also be charged for the with the predicate offenses?
Can you just refer me to that part? Which paragraph is that?
Paragraph 89 of your statement.
No,
You can
what
read
I-
paragraph
what-
89 in conjunction with paragraph 88.
Maybe I can just explain my submission in 89. I said, and the panel concluded that if you based it on knowledge, that they were aware what the Cato Managed Unit did in terms of a pattern of racketeering activity, in terms of the underlying predicate offenses, that they were involved in several crimes in the sense of that they went out to kill people, not in self-defense, but for the purpose of rewards. That knowledge would then be, one would have expected that as managers, they would have been charged for all the predicate offenses, because that's the premise or the basis, that they had knowledge about each and every murder or killing of innocent people.
Yes. Now the question then, on those bases, I'm saying that for the purposes of contravention of 21F, is it a requirement that the person charged for playing a managerial role also be charged for the underlying predicate offences?
No, it's not necessary, but I said I would have expected if you had knowledge of 28 murders and you did absolutely nothing about it, even negligently, one would have expected the whole group to be charged for all the murders because they had knowledge that these people were killing people unlawfully.
Okay.
That's the point.
And then you again repeat at paragraph 90 that even the evidence by Dlondlo and Matoni that Mostert was present when there were payments made by the Stenga Talks Association, it would not be sufficient because they were not to say that you say that Mostert was not charged for contravention of section 21F.
The reason we looked at those statements and we also looked at the other predicate offences is that master tends to play a very prominent role. So our understanding was that if you look at how they structured who are the people that participated in the enterprise and who are the people that are the managers of the enterprise. We argued that it doesn't matter what your title or status, you must exert some degree of control over the operations of the enterprise. And we found that there was evidence to that effect. Now, if you simply excluded him on the basis of his rank, we felt that was, they could have charged him also in terms of 21F.
Now, the question that I have follow-up on that is, does the fact that a person who ought to have been charged was not charged, does that render the charging of those who have been charged wrongful?
No, it doesn't make it wrongful.
Yes. So the question, does the fact that Mostert was not charged for contravention of 21F, does it have any role in the others who were charged in the decision to charge others for management?
No.
Yes. Okay.
Sorry, the follow-up question would be, you were asked to analyze and where you find shortcomings and you identify them. For example, here you identify that Mostert should have been charged in terms of 21F. Wasn't it prudent that in your conclusion and recommendations, you assist, because you are all members of the NPA, you assist the prosecution, or you assist the NDPP with taking this matter forward by making recommendations that, for example, Mostert should have been charged in terms of 21F, which to a certain extent may have strengthened the NPA's case against the Katomena, instead of pursuing just one line of analysis that is finding fault with those that were working on this, and at the end coming to the conclusion that the authorizations by Advocate Abrams were unlawful and therefore should be set aside. Thank you. What is your comment on that?
We did say that he should, if the prosecution was proceeding, he should have been charged for 21F. We do make it in our, we make that submission in our report. And we explain why we say he should have been charged for 21F.
Now, the reason you say that you should have been charged in 21F, would I be correct to say it's because you accepted that there was strong evidence, given what you could pick up from the dockets the prominent role that he played in these activities?
Based on the predicate offences, as well as if you had to proceed on the hearsay evidence, in terms of what they said, that he attended a meeting, for example, with Major General Boyson, and that he received a bag of money.
Yes. Now, when you read the dockets, you also find that in most of the crime scenes, after the person would have been killed, Captain Eva would take over control of the scenes and manage the scenes. And it was on those bases, according to Advocate Mayema, that he was charged for contravention of Section 21F. Now, if you say that the role that Mostert played was significant, would you say that Eva's role was also significant?
In the context of, and I'm trying to understand.
Crime scene management. After most of the suspects would have been killed, Captain Eva would come in and manage the scenes, and the evidence that we'll look at shortly would be that he would plant the firearms that were allegedly used by the deceased in so-called shooting the police. Now, if that evidence is proven to be correct, that Captain Eva played that role of doctoring the scene, would you accept that then, therefore, it was correct for him to be charged for management because he played a critical role?
That's the evidence. That's the evidence, yes. I would agree, he played a critical role in.
Yes.
If the evidence is that he planted firearms and that he cleaned up the crime scene, if that's the evidence, yes.
Now, let us look at that evidence. In the document that you gave us earlier, where you were asked to analyze where you analyzed the ballistics, do you recall that?
That is correct, yes.
And the first case, the sixth case that you looked at, and I'm just want to zoom in on what Captain Mangena said. Remember, you wanted to deal with Captain Mangena's evidence.
That is correct.
Yes. Now, this is that time, ma'am, that I'm going to ask you to deal with that. Now, if you look at case number 6, Durban Central, amongst the dockets that you analyzed was the report by Christian Mangena. Is that correct?
Let me just, with my notes, I just want to compare it with my notes.
You just have to look at case number 6 on the list you provided this morning. You list A, B, C. Number C, an affidavit by Christian Mangena.
That is correct, yes.
Yes. Now,
Where do I find that?
on the second page of the document that we gave this morning, the case number 6.
Durban Central.
Durban Central, yes. Now, I'm just going to ask Advocate Lekgetho to go to the statement by Colonel Mangena, who at the time was a captain, and the annexures to his statement or his reports, and go to page 2A-68. Are you there, ma'am? Is Advocate Lekgetho helping you?
Just looking for it, yes.
You're referring us to that document as well?
Yes, I'm going to ask to go to 2A-68. That is his report in the Durban Central case.
Where do we find that in these bundles of documents?
It's in annexed to Captain Mangena's statement.
Yes, but please refer us to the volumes, Counsel. You have prepared for leading evidence, and you have to assist us.
I'm not sure of the volume number, but it's 2A-68, page 2A-68.
Yes, thank you.
Did Advocate Lekgetho find the document?
Not yet.
Advocate Lekgetho, you can look at 2A, Colonel Mangena Report, Volume 1 of 2. Volume 1 of 2, 2A, Colonel Mangena Report, Volume 2, 1 of 2. The page referred to is 2A68. It is a section 212 statement by Christian Mangena. Are you finding it?
Yes, ma'am. I'm looking at it now. I'm just trying to go to the first page.
Yes. It's in relation to Durban Central case.
Yes, ma'am.
We can tell him who the deceased was in that case.
Yes. Now, Advocate Riley, this is Captain Mangena's statement, Colonel Mangena, in fact, currently, and at the time was a captain. This is his ballistic report in the Durban Central case, which related to the death of Mr. Bongam Kize. Do you remember Bongam Kize was referred to in Londlo's statement as the person the Cato Manor struggled to kill because he was highly connected?
That is correct, yes.
Yes. Now, if you recall, and you said this report is amongst the documents that you considered when you prepared your report.
That is correct.
Yes. Now, if you recall, the facts in this matter is that the members of the Cato Manor unit, together with members of the NIU, had tried to flag Mr. Mkize, who was driving a black Lexus, and then Mr. Mkize refused and then started firing at them, and then they retaliated. Do you recall that?
That
Those
is
facts?
correct. That is
Now,
correct, yes.
I just want to take you to. I'm not going to go through the entire report, but I want to take you to the conclusions by Captain Mangena on page 2A-89 under paragraph 13.
Paragraph 13.
It's on page 2A-89.
Yes, I'm there. Paragraph 13, yes.
At paragraph 13, it says, after observation of the crime scene photos, post-mortem reports, ballistic reports, and statement by officials, I could reach the following conclusions, right? He says at paragraph 13.4, The smaller shrapnel laceration injuries sustained by the deceased on the right arm and right side of the face were probably caused by glass particles and bullet fragments created by high velocity bullet impact on the glass. This gives the impression that the driver's side window was shattered by bullets fired into the vehicle. The shrapnel laceration injuries sustained on the right arm give an impression that the deceased's arm was stretched forward, possibly holding the steering wheel. Do you see that?
It is correct.
And it says the person who fired the shots with low velocity firearms were positioned on the right side towards the back. And then he says at 13.5, the position of the cartridges of cartridge cases and glass particles at the crime scene gives the impression that the vehicle was stationary during the incident. And then 13.6, there was no sign that shots were fired from inside the vehicle. Do you see that?
That is correct.
So basically, what Captain Mangena says is that Mr. Mkhize did not, and was not, when he was shot, was not firing at the police. In fact, he was holding his steering wheel with his right hand. Do you see that?
I see that, yes.
And if you look at this evidence, just asking, I'm talking on the basis that you found in your report that there was no evidence of a pattern of racketeering. Now, if one was to accept what Captain Mangena says, would you agree that then that would mean that Mr. Mkhize was killed? He was not shot in self-defense.
If you base it on Captain Mangena's report, yes.
Yes. And then we then go on to the next report, which you considered. That would be the Malmoth case. No, let's start, sorry, Madam Chair. We go to the Eskawin. That is the case of, I think it's, I forgot the name, KwaZulu-Natal, am I correct? It's a case relating to the death of KwaZulu-Natal. It's on the 28-101.
Just trying to find it.
Have you found it?
Yes, sir. Yes.
In fact, on this case, you, in your report, it accepted that that the KwaZulu-Natal was an innocent person, because him and Kanyisile Biela, there was a chapter that you say killing of innocent people. Do you recall that?
That is correct, yes.
And in fact, in this case, amongst the recommendations you suggested was that, in fact, Parayachi must be prosecuted.
That is correct, yes.
So would I be correct that you accepted that the version that he was killed in self-defense was not probable?
Based on the evidence in the docket, yes, in that specific docket.
And you know that evidence, there were attempts by his colleagues to corroborate that version, and despite that, you still found that it was not probable.
Based on the evidence in the docket, yes.
Yes. And if someone goes on and says, well, my colleague shot this person in self-defense, very well knowing that that was not the case, and the person is charged with management, then you can accept then that the person knew that the colleague had embarked on a pattern of racketeering activity over and above other incidents.
In that specific incident, yes.
And if the evidence shows then that Eva, Lockham, and those others knew that what Padeachi did in killing Kwazi, he was not acting in self-defense, but had killed him for no reason, that might then mean that they knew that their colleague had embarked on a pattern of or had conducted a racketeering activity.
If the evidence shows that they knew, yes.
But you found that their version that their colleague had shot this young man in self-defense was not probable. Hence, you said he must be charged.
That is correct on the evidence in this docket.
So, let me just go take you through the last report by Mangena. That would be the Pine Town on 28-227.
Sorry, Advocate, for the sake of the record, we have two Esikawin on this list. We have, no, on this list that was submitted in the morning. We have 14 and 16. Maybe if you can just clarify, which Esikawin were you referring to? Because both have Captain Mangena's report.
The KwaZulu that we were looking at is number 3. Three of 4 of 2010.
Or 304. 304, that would be number 14.
Yes.
Okay.
In fact, madam, I think the most one that I just want us to, let's look at the Melmoth one at 1812. Sorry to send the panel and my colleagues up to and fro. It's at 28181.
You're referring to the Esekaweni Met case number?
No, Melmoth, madam.
Melmoth.
That is another case where there was death of an innocent person or a person who was not a suspect. Kanyisani Biela.
Can direct Advocate Riley that report, that statement, the affidavit is at 2A 181 of volume 2 of 2. Volume 2 of 2. 2A Colonel Mangena's report. Volume 2 of 2. At 2A 181.
That is correct. I got it now.
You got it, thank you. Proceed, Counsel.
Now, I want us to go to the conclusions again under paragraph 15, which you starting from page In fact, at 28208.
Paragraph 15 starts at 201.
Yep.
Where do we find the conclusion? There we find findings.
Yes, but I'm focused on paragraph 15 on page 208. The last.
208.
Yes.
Which paragraph? Of
15.8.
15.8. Do you see subparagraph 15.8 at 2A-208, Counsel, Advocate Riley?
That is correct, yes, ma'am.
Proceed, Counsel.
Yes, ma'am. If you recall, in this case, there was it was the death of Mr. Biela, I would call him Biela Senior, and his nephew, Kanyisani Biela, and both of whom were shot at different locations, but within the same home state. The other one was shot naked on top of rocks, and the other one was shot in the Rondavo.
That is correct, yes.
I just want us to just zoom on the one that was shot in the Rondavo, Kanyisani Biela, whom we know that was not a suspect.
That is correct, yes.
Yes. Now, in that case, what we know as well is that according to the statements, Kanyisani, the police were there looking for his uncle, and then the next thing he started shooting them through the window, and then that's when they then started shooting back in self-defense. That is what they say in the statements. Do you recall that?
That is correct, yes.
Yes, but now this is what Captain Mangena says in his statement to show that apparently that version was not correct because he could not have had a gun at that time. He then says at paragraph 15.8, I also observed the position of the firearm. The firearm is positioned on top of blood. Looking at the condition of the firearm, the condition of hands, the deceased and the movement of the deceased since started bleeding, I would expect the hand grips of the pistol to be smeared with blood. Do you see that?
That is correct, yes.
And if one was to look at if you just go back at least 3 pages at 205, 28-205. Are you there?
That is correct, yes.
And if you look at the gun that is lying next to Kanyisani there, you would see that it does not have blood stains. And what Captain Mangena says, he says, looking at how he bled, and one would have expected that that gun would have been at least laced with blood stains, would have been stained with blood, but it is not. Do you see that?
I see the firearm on the blood, yes.
Yes. And Mangena says he would have expected then that that blood would have been smeared with blood. That firearm would have been smeared with blood.
That's what he said, yes.
Yes. And then he also says, therefore, the way therefore it's me paraphrasing, the possibility of the firearm being placed on the crime scene after the incident cannot be ruled out. Do you see that?
I saw that, yes.
And
It starts at 15.9, yes.
Yes. And if, therefore, if a court, you would accept that if a court was to accept Mangena's conclusions, then that would spin the entire case by the Cato Mena unit that they were acting in self-defense on its head.
If a court has accepted it, but one also needs to look at the other evidence in the docket.
Yes. No, the reason I'm saying that I'm not trying to debate the merits, but it's just to show that, and in fact, before I forget, the evidence shows that this scene, after everything happened, Captain Eva also took over the scene. Now, if therefore Captain Eva took over the scene and doctored the scene, would you accept then that he knew, or that his colleagues, that what his colleagues had done and doctored the scene in order to make it look like his colleagues acted in self-defense?
If you had evidence to that effect, yes, then I would accept it if there was evidence.
Yes. The reason I'm asking you this because you conclude that there was no evidence of racketeering pattern. So, but I just want us to show what value did you, as the panel, attach to Mangena's statement and the conclusions, especially in coming to a conclusion that there was no evidence of a pattern of racketeering activity?
In respect of all his reports?
At least the ones that we've got, or the ones that you've analyzed, and that I've just analyzed.
Okay, because
I analyzed 3 for a reason, because you need 2 or more.
If there was evidence to that effect, yes.
Now,
on its own, Mangena's statement is not sufficient.
Can you elaborate on that?
Because he talks about the possibility, and you bring it in terms of Eva coming onto the crime scene. And I said to you, if there is evidence to the effect that somebody testified to the effect that Eva would come onto the crime scene, he would clean up the crime scene or doctor the crime scene, and then you would put a firearm there, then I would accept it if there was evidence to that effect.
But do you recall where there was, I think, a girlfriend of one of the deceased who said that, in fact, when her boyfriend was shot, he did not have a firearm, but then to cover up that, they covered her with a blanket, and then they then shot the boyfriend?
Can you refer me to which matter that is?
It's in your report.
Yeah, but I need to just refresh my memory in terms of where it's been said in respect of which case. Because I do know that there are cases of girlfriends, and I think most of the statements in these cases, the family members do say that the deceased did not have firearms.
I'll just ask Advocate Mhlamiane to find that for me.
While
I beg your pardon, my sisters. My sister on the right, you may.
While they are still looking for that, you said in your last answer when you were asked that after analyzing and looking at Colonel Mangena's report, do you still maintain that the police shot these victims in self-defense? Your answer was qualified. You said only if there is other evidence that corroborates. Now you are being given an example of evidence that corroborates, and you say yourself that there are other instances where family members deposed to affidavits to say the victims did not have firearms. I think the closest that one can refer to is the Melmoth, the Biela case, where Biela Senior was shot naked. So if he had a firearm, where would he have concealed it because he didn't even have underwear on him. So there was nowhere where he can hide a firearm. And I think it's the wife, the common law wife, who deposed to an affidavit that Biela was naked and he was taken from the room by a group of police officers and then shot outside. But what happened next is there was a firearm next to his body, and then a claim that the police shot him in self-defense. Given that scenario, would you still say, reading Captain Mangena's statement and analysis, findings and conclusions, and together with the family members' statements, and also looking at the photo album, given the state of the victims, would you still say there was no evidence to show otherwise other than that it was in self-defense?
I will reiterate, my opinion will remain the same, that I will have to look at the facts of that specific case. I will have to look at other evidence in terms of witness statements, that is correct, but I've also looked at primary residue evidence. And then I will have to look at whether there were any fired cartridges from that specific firearm. So I can't now completely remember in the facts of each and every case. In this one that you mentioned, honorable panel member, but I would have to look at the whole matrix of evidence in that specific docket.
Yes, and that's the correct thing to do. But all those points that you've mentioned have been covered in Colonel Mangena's report. Whether, let's take for example, Mr. Bongani Mkhize. He found that there were no cartridges to indicate that shots were fired from inside the car. All the evidence pointed to shots being fired from outside, that is, shots being fired towards Mr. Mkhize. And then I'm not sure whether it's in this instance where he dealt with primary residue, but all those points that you mentioned, if you have gone through all these dockets and the evidence, you would have found that they were covered in the ballistic reports. And even the positioning of the firearms that are purported to belong to the victims were dealt with in detail by the ballistic and forensic analysts. Your comment?
If one refers to one specific docket, I would like to go back and read that docket and give you an indication. If Durban Central is the case that I think I remember, there was also a witness statement that was a retracted witness statement. And one also have to remember another aspect that you're going to consider as to why potentially there were no, it was a moving scene. So I would like, if you want to ask me about a specific docket, I can go to that docket and I can more or less explain, in addition to Mangena's statement, whether there were any other evidence that we considered.
I will avoid back and forth. I will just leave it at that. Thank you, Chair.
Advocate Riley, you asked me a question and say, where is that? In fact, in your statement, there was a paragraph in your report and statement, there's a chapter that deals with the planting of firearms. And in one of the cases that is referred to there, I think it's the Kwaduguza where Ms. Tembeka Ngcukaitobi said in her statement, I will not go there, but you've summarized in your statement that at that, where I think is the death of, I think it's Lindelani Mkhize, if I'm not correct, if I'm not mistaken, who says that, yeah, it's with Lindelani Buthelezi, sorry, Lindelani Buthelezi, who says that at the time that he was dragged outside, he did not have a firearm, and then just before he was shot, they covered her with a blanket, and then she had gunshots. You deal with that at paragraph 105. Of your statement. And you criticize that, you say, well, they were not present when the shooting occurred. Now, the question I have for you is, what do you say about Ms. Ngcukaitobi, who says, I was there, I was next to them. Just before they shot him, they covered me. Did the panel ever look at that?
That is correct, yes.
And what weight did you attach to Ms. Ngcukaitobi's statement where she says, I saw him. He did not have a firearm, but just before they could shoot him, they covered me with a blanket, and the next thing I had firearms.
We also qualified it that when the allegations, the person were not present when the shooting occurred, and there were spent cartridges next to the deceased person, which were positively linked to the firearms found next to the deceased person. I can't remember specifically in this case, and that's why I said if we're going to go into individual cases, I will also have to look whether this is one of the cases where the deceased tested positive for gunpowder residue.
Yes.
So what I'm trying to say is that each individual case, one needs to look at the evidence in each case. So I can't generalize and say in respect of every case, that is what happened.
Yes. Okay. Then so basically you concluded then as a panel that there was insufficient evidence to charge one, Major General Boysen for contravention of 21E and F, as well as the other members who were charged, because there was no evidence of a pattern of racketeering activity.
That is correct, yes.
Yes. You then move on into the next.
Before you move to the next one, you dealt with Melmoth.
Yes.
Advocate Riley, you remember Melmoth pertained to the two deceased, the Bielas.
That is correct, yes.
And in your statement, paragraph 1015, if you can go to your statement there, paragraph 101.5. You see that paragraph?
That is correct, yes.
You only make reference to Bongani Biela, only.
That is correct, but it's in the context of cases where there were warrant of arrest for persons, because I think the prosecution, Advocate Mahema, they asserted that these people were innocent, there was no reason to approach them.
I have not finished asking you a question.
Okay.
The question is 1015 makes reference only to Biela Senior.
That is correct, yes.
That case 142/11-2008, pertain to the two deceased, the two Bielas.
That is correct, yes.
And in your report, or at least in your list, you indicate that you had regard to the ballistic report of Captain Mangena. That deals also specifically with regard to the young Biela, Kanyiseni Biela.
That is correct, yes.
Where in this statement do you make reference to Kanyisani Biela?
There's no reference to him.
Why so?
Because it's contained in our report.
Where in your report?
I will have to go through it.
Madam Chair, maybe if I might assist, I think there's reference under paragraph 102. Under a case where victims were not suspects.
Yes, but in the context of the ballistic report.
Okay, I understand it.
Counsel is drawing me to paragraph 102 of your statement, where you make mention of Kanyisani Biela in your statement. But my question relates to the fact that expert findings were made by Captain Mangena about this deceased, Kanyisani Biela. My question is, did you have regard to that?
That is correct, ma'am.
Did you?
That is correct, ma'am.
Did you summarize that part of the ballistic report in your report?
I'm just trying to find that section, if I can be given an opportunity.
Yes, your report to Advocate Matoni, that is the DCOC report. If you can take me to that part, it will assist me.
There are a reference to under paragraph 194.
Is paragraph 194 saying?
That's part of our report. Do you want me to read it out, Madam Chair?
Yes.
Okay. The killing of innocent civilians, which the police allege were suspects. In the prosecution memorandum, the prosecution also alleged that the police killed innocent civilians and would then allege that they were suspects. The deceased, Kanyisani Biela and Kwazi Wiseboy Ndlovu were not suspects sought by the police. According to the accused, Biela fired at the police through a window of a rondavel when they went to arrest a family member at the reserve. The police entered the rondavel and he was fatally wounded. The cartridges found in the rondavel was positively linked to the firearm the accused alleged he fired at them. The firearm had a serial number, but no investigation was done to determine ownership.
Yeah.
In respect, yeah,
Before you go to Kwasindlovu, did you have regard to Captain Mangena's report in relation to paragraph 194 and 195 in respect of Kanyiseni Biela? And
That is
where
correct.
does that appear in the report? In your
that is correct.
in your report, yes. In other words, the findings of Captain Mangena that were read to you earlier in relation to this deceased Yambiela, for example.
That is correct, ma'am.
Okay.
Advocate Riley, because I just want us to conclude on this racketeering activity before we take the lunch adjournment.
You cannot conclude when I'm waiting for an answer.
Oh, sorry, Madam Chair.
So, just assist. Would like to know and understand in relation to the young Biela, Kanyisani Biela, in respect of which a ballistic report had been prepared. Where does the report, the DCOC report, refers to that the ballistic findings in relation to this deceased young Biela, for an example?
It doesn't refer to the Mangena report.
In other words, you did not at least include the findings of Captain Mangena in relation to Kanyisani Biela that was drawn to our attention earlier in your report to assist Advocate Batoi.
It wasn't in the report referred to. Yes, that's correct, ma'am.
Thank you. I'm not too sure, Advocate Mchene, this exercise, because if the witness has not summarized expert findings in relation to this deceased persons in their report, how does it assist us? Because it is clear that these expert findings in the ballistic reports were not included in the report to Advocate Batoi. How does this exercise assist us?
Madam Chair, the only reason I was taking the witness to that was because she says that there was no evidence of a pattern of racketeering activity. Now, what I wanted to ask her is to whether, in light of what the evidence that was before them in the form of ballistic reports, which show that which cast doubt on the version by the police that they shot in self-defense, that she still maintained that there was no evidence of a pattern of racketeering activity. That's the context that I asked her. I referred her to the ballistic reports because she considered them. They considered them as the panel, and so I wanted to attach what weight was attached to those conclusions, and in light thereof, does she still maintain the conclusion that they do not establish a pattern of racketeering activity?
You can verify from her whether, in relation to the instances you have referred her to, she still maintains same.
I think I asked her that, and she said she still maintains.
She says she still maintains same.
She can confirm that. Advocate Riley, we have just spent a few minutes, quite some time, analyzing Mangena's conclusions in the reports that, as the panel, you analyzed. I'm not going to talk about other reports which Captain Mangena prepared, which also point to the same direction, but I want to focus on those that the panel looked at, which at least cast doubt on the version by the members of the Cato Manor that they had killed these people in self-defense, and asked you then that in light of at least these 3 incidents that I've referred to, do you still maintain that they do not establish a pattern of racketeering activity, or that if Captain Mangena's evidence was accepted, that would not be sufficient to at least establish a pattern of racketeering activity? Do you still maintain that view?
Yes, let me just conclude. I think you can give as many examples as you like.
You take it individual.
I think it's a matter of argument.
Captain Riley, in your affidavit, in your statement at paragraph 101.3, when you deal with Durban Central, case 185/02/2009, okay, you deal with quite a number of cases there, but you are specific on the evidence that Bongani Mkhize was one of the orchestrators of the murder of Nkosi Zondi. Are you at that paragraph?
That is correct, yes.
You sat in the panel in 2017. Were you aware that during 2008-2009, Mr. Spam Hlongo was arrested for the death of for the murder of Nkosi Zondi?
That is correct, yes. There was a case.
And are you aware that his confession was declared inadmissible as it was coerced by torture and physical we didn't want to say physical abuse, but it was coerced by torture, and therefore the judge or the magistrate ruled that his confession was inadmissible.
I don't know everything about the case, but we were aware that they were found not guilty.
So
the accused was found not guilty.
You were aware that it was ruled inadmissible?
I don't want to say that I'm aware of the facts. I just knew that the persons were found not guilty.
His case did not go to the merits. It was a trial within a trial, and the confession was ruled inadmissible.
I would accept that, if that is what you said, madam.
And then in the case of Swayo, unfortunately, Mr. Swayo was killed before he appeared, he was killed after he got bail, before his trial ran. And in his bail application, he deposed to an affidavit where he denied the confessions that implicated Bongani Mkhize, the same as the argument raised by Mr. Spam Hlongo. Are you aware of that?
I'm not aware of the bail application.
You are not aware that Mr. Swayo was, when he was killed, he was out on bail? Or you are not aware of Mr. Swayo's case?
The bail application information and that he was killed.
Oh, okay. Because here the panel says this information was later confirmed by Swayo and Spam Hlongo. And
That is correct, yes.
this sentence cannot possibly be true in line with the evidence that has been laid before us. Are you aware, or as you say, you are not aware that Mr. Swayo was on bail, so maybe you do not know?
That is correct, ma'am.
But still, in your affidavit, you say this information was later confirmed by Swayo and Spam Hlongo without having verified whether this still holds true or not.
That was, my statement is based on the information that we had at the time of making our decision or recommendations.
Which was in 2017,
2019.
2019, and this happened in 2008, 2009, long before you made your recommendations.
That is correct, ma'am.
Okay, thank you. Thank you, Chair.
Thank you.
You propose to break for lunch. It's almost 2:30. We will reconvene at 3:30. How long are you still going to take?
Madam Chair, now I can make an undertaking 30 minutes.
When we reconvene?
Yes.
We'll take a lunch break until 3:30. Advocate Riley, we're going to pause.
Yes, ma'am.
We're going to pause for lunch and reconvene at 3:30. You continue to be
Yes,
under
ma'am.
oath as we adjourn, remember?
I will do so, ma'am.
Yes, thank you. We adjourn.
Thank you.
Afternoon, everyone. Good afternoon, Dr. Chauke. Good afternoon, Advocate Riley.
Good afternoon, Madam Chair.
You continue to be under oath, madam.
I confirm that.
Thank you.
Yes. Advocate Riley.
Proceed, sir.
Thank you, Madam Chair. Advocate Riley, can we proceed on the next chapter on your statement? That is paragraph 91 all the way to 95.
Is correct. I'm here.
Yes, you tell us that as the panel, you had identified that at least 9 accused were charged with racketeering despite the fact that they were only involved in one incident. And you cite the case, the cases wherein they were involved.
Before you answer, are the air conditioning, are they working? It feels hot, or am I the only one?
It's hot.
Is it hot? May we get help, please? Is it working? Would you please check this one on the right side? Yeah, how does it feel, madam? It's hot. Please try to control both, even the one on the center. Thank you.
May I
Thank
continue?
you. Yeah, you may proceed, sir. You can remind the witness of the question.
Yes, Advocate Riley, I will just ask you a question that you, in your statement, you list a number of persons who were charged for racketeering despite the fact that they were only involved in what you term one incident.
Can I just want to have a look at this section. Yes, just 12, yes, they were charged with one offense in the predicate offenses.
Yes.
And I list the incidents.
So are you saying they were charged with one offense or they were charged for multiple offenses under one incident?
They were charged in one incident, similar to the Howick matter, where we said one incident, and then it could be multiple offenses in one incident.
Yes. And you then say on the basis that they were charged under one, they were charged with racketeering despite being involved in one incident, they were wrongly charged.
That is correct, yes.
Yes. But despite that, in your recommendations, if I might just, you do not ask that or recommend that the racketeering charges or certificates, to the extent that they relate to these accused, should be withdrawn. You in fact recommend that the entire, both authorizations and the charges against the entire people who were accused who were charged with racketeering be withdrawn. Now the question I have is, does the fact that a person who is charged with racketeering or not to have been charged with racketeering, does it invalidate the poker authorizations?
Person was not being charged.
Yes.
I'm just trying to understand what you're saying, Advocate Msweni. Can you repeat your question?
I'm saying that despite you finding that these accused were wrongly charged under poker, you nonetheless in your recommendations recommend that the poker authorizations and the racketeering charges be withdrawn against everyone. Is that correct?
That is correct, yes.
Now
Yes.
the question is, does the fact that a person, one accused amongst the group of accused who's been charged with racketeering, does the fact that the accused was wrongly charged, does that invalidate the entire proceedings?
In respect of, we've gone through the Cato Manor grouping, we've gone through some of the accused that were charged in one incident. That is correct.
Thank you. And then you then, in the next paragraph.
Sorry, is the witness saying it is correct that once you find that there are few people who are wrongly charged, then it invalidates everything? Is it what the accused, sorry, is it what the witness is acceding to?
No, ma'am.
I didn't want to mishear or misunderstand her.
Can you just clarify that, Advocate Riley?
I did not say that if there are people on a racketeering indictment is charged wrongly, in other words, that they don't belong as part of that racketeering, that invalidates the whole authorizations. That is not what when I said that. It does not imply that.
Okay. Thank you. Are there questions from the panel, Madam Chair? Yes. Now, then, you then criticize from paragraph 96 the reliance on the monetary awards as being the purpose or the basis of finding that there was an enterprise.
That is correct.
And you say, first and foremost, there were two streams of payments which were identified. Firstly, by the Stenga. Secondly, the monetary awards by SAPS.
That is correct, yes.
And then you say that there was no evidence insofar as the Stenga payment stream that showed that there were payments made to Major General Boysens, and no, that there was evidence that the money was dissipated to the members of the Cato Manor squad.
That is correct, yes.
But in doing so, did you have regard to what at least Matoni said? Is it Matoni? Who said that he was present when the money was given to Boysen and Mostert? Did you have regard to that?
Firstly, I don't recall whether he said it was given to Boyson, and he said it was given to Mostert and an unknown man. And yes, we have debated at length now the why we said we did not place any reliance on the Matonzi statement. So we did take that into consideration.
Can I ask one quick question? Did you have any evidence to the contrary, especially where you say there is no evidence that shows that the money given to Boyson, and we know that we have a witness who said, I was with so-and-so who went into a car where there was Boyson and Mostert. He had a large envelope and he gave, the envelope had money, he gave it to them. Did you at any stage during your analysis find contrary evidence that would have convinced you that either the money was not given to Boyson or to Mostert, or there was no money at all, or any other evidence that would help you come to this conclusion?
There was no evidence in the docket. If that was properly investigated, one would have expected, and that's one of the points that we raised in our report as well. There was no financial investigation done. So one would have expected a financial investigation to be done, as well as an asset forfeiture investigation to potentially show that besides the money that they receive as a salary, they through their assets, through a bigger house, holidays they've gone to, as well as monies in their banks, that they have more money than would have been expected from a police officer on a salary. So that would have, but there was no such evidence.
And all that while we are still at the stage of seeking authorization certificates, not at trial stage.
The requirements are for a racketeering authorization is that you do a financial investigation, potentially to show money laundering, and then secondly, you do an asset forfeiture. That is standard in terms of any racketeering request for racketeering authorization. So one would have expected that to have been part of that investigation, even at the stage when they submitted an application for authorization to the NDPP.
You say that it is standard.
That is correct.
Can you direct us?
I will have to go to
relevant provisions of the Act, maybe?
There's no provisions in the Act. It's internal in terms of what is required in terms of a poker prosecutions. Obviously, in terms of a poker prosecution, we say that the drive in order to commit these offenses is very often, or if not in the majority of the cases, it's financial. It's the financial benefits that you're trying to obtain. So part of our requirements in terms of our policies is that when you look at a criminal network, in particular criminal network that is committing crimes, that you have to look at a financial investigation and that you have to look at asset forfeiture.
Is it standard?
It's not in terms of any law.
Oh, I'm sorry. I thought you were done. Sorry.
I said it's not in terms of law. It's what is required of a prosecutor when you conduct a prosecution, a racketeering prosecution.
My next question would be, is it standard or does it differ on a case by case? Are all cases where you deal with poker and racketeering the same, or you deal with them on a case by case basis?
You are required, when you do an application for racketeering authorization, you are required to address the NDPP whether there was any financial investigation and whether there was an asset forfeiture investigation. And both those, that forms part of our discussions around whether racketeering should be authorized or not. You are required to address the NDPP on the financial investigation as well as the asset forfeiture investigation. So I wouldn't say it is, I think that's the norm. That is what is required. Even if you don't find financial benefit or asset forfeiture benefit, you still have to address the NDPP on that.
Thank you.
Advocate Riley, if I may just ask, the standard for institution of criminal proceedings is prima facie case, am I correct?
Prima facie case, yes.
Now, what is the standard for to be applied by the DPP, by the NDPP, when he or she decides to issue poker authorizations? Is the standard the same?
That is correct. I think you still have to consider reasonable prospects of success, even if there's a prima facie case.
So, prima facie case means that there's a case to answer.
That is correct.
So, the test is the same throughout, in both instances.
I think our policy manual referred to prosecutors in general. What is your role, as well as what do you have to consider when you decide to institute prosecutions or not?
Please
And
just
also
answer,
factors to be considered.
Counsel Advocate Riley, confine yourself to the question by counsel, by Advocate Mchweni. Please repeat that question.
I'm saying that the test is the same for both institution of criminal prosecution as well as granting of poker authorizations.
Yes, you have to, you're a prosecutor, you make a prosecutorial decision.
Yes, and there's still room that even after the issuance of poker authorizations or institution of criminal prosecution, that that investigation can still be done, mostly under the direction of the prosecutor.
Yes, that's correct.
So basically,
investigations continues.
Yes. So basically, it is still open to a prosecutor to ask that certain information that may not have been there when the decision was taken, that information be obtained.
Yes, you can ask if
Yes.
you didn't have it, yes.
Yes, and that would not invalidate the prosecution.
It wouldn't invalidate the prosecution.
So even in this case, would you say that it was open to the prosecution team, even after the poker authorizations were issued, to still ask that the financial investigation be conducted?
We were talking about this in the context of the money that was received. What it does affect is when we consider a poker prosecution, you will obviously look at adding money laundering charges. So in this case, there were no money laundering charges. So I assume that either there was a financial investigation or it wasn't concluded. And if you say that they could have done it even afterwards, yes, it's possible.
Yes. But that does not mean that the fact that it was not done, that it was wrong to charge, to institute for the NDPP. Would you say that it was because it was not done, it was therefore wrong for the NDPP to issue the poker authorizations?
No, these are two separate issues that we're discussing now. Additional charges, and then there's the authorizations in terms of 21E and 21F, and the evidence that relates to those charges, the 21E and 21F. You can at any stage add additional charges.
Yes. So, but it is not a requirement that you should, before you institute poker charges, that you must also institute money laundering charges. The two are independent of one another.
It's required that you address the NDPP on it. But if you have a plausible explanation as to why you didn't do it or why that investigation is not finalized, it's up to the NDPP to decide what should happen to those additional charges.
Now, in this case, did you as the panel consider the fact that this money was paid in cash, therefore there would be no footprint for that money? The Stenga money.
The Stenga money.
Yes. It was paid in cash, so
We
therefore
have the one.
you would
we
not
have the
find
one
footprint.
incident. I understand it correctly. We have a statement of one incident where money was transferred. I can't tell you whether there was any other evidence to the effect that they was paid into their bank accounts. That could have been a potential as well, and that's why I said a financial investigation is important.
Okay. You then also find that the other questions from the panel, Madam Chair, before I move on? Are there clarification questions on this? Okay, thank you. You then go on to also say, well, it is highly improbable that you say that the SAEPS monetary award stream would also not constitute proof of an enterprise, and you amongst others say, well, it's because one cannot risk their career for a mere 10,000 rands, and then that in some instances some received more, some received less. Can you just elaborate on that?
That is correct. It appears that what is regarded as the motivation for the Cato Manor Group to become involved in these criminal activities was financial. So there's the money from the association, and then there's obviously the rewards. So if that is your case, one would have expected quite a number of people to receive more. So you say Boyson is the manager, Boyson is the one that's behind this whole criminal enterprise. And the point that we make, it's just interesting when you actually study the rewards, that Boyson only received the 10,000 rand, while others who are your associates or just simply participated, like a Mostert, received 95,000 rand and now 55,000 rand. So this is clearly not a very successful criminal enterprise, in particular if you say that Boyson is the driving force behind it, because he only gets paid 10,000 rand.
Is there anything in law that requires that for a manager, that the manager's reward must be higher than the subordinates for the purpose of poker?
No, but it's common sense, isn't it?
But
why would you, as a manager, the driving force, why didn't you give yourself more money? In most criminal networks, you will discover that the managers of your criminal networks are the rich ones. They're the ones with the houses. The persons, for example, in your criminal networks, like your gangs, the ones that are the runners and the hitmen, they don't really have money on their names. So it only makes sense if you're gonna, as somebody in his position, risk his career to be managing this criminal network and instructing people, or to have known that they're doing this, that you only give yourself 10,000 rand.
Now, if I might ask then, did you look at the motivation for the monetary reward that was given to the Cato Manor Squad?
Yes, I studied that whole document, including the affidavit of the person that provided that information.
Yes, and did you notice from that in fact the reasons and the basis for those awards were these people that were killed in these dockets?
That is not correct. If you actually study the document that was provided by SAPS in connection with the money being paid, it actually is it's far-reaching. It deals with cases that is not involved between 2008 and the time period of the indictment. There's cases before that time. There are cases that deals with robberies. There are cases that actually went to court as well, where there were convictions and sentences imposed in the High Court. So, in my opinion, that is not correct.
Okay, thank you.
Advocate Riley, did you consider or did you come across an affidavit that indicated that the Stenga Taxi Association, after the killing of, I think it's Buthelezi, they collected 750,000 rand to be given to the top officers, meaning either Boysen or Mostert or both. And after the killing of Bongani Mkhize, they collected 1 million rands also to be given to the same officers. Did you come across such evidence?
Is there a statement to that effect, and whose statement is that?
I didn't get your answer. You said yes, you saw that.
I said, I don't have independent recollection of it, but that's why I'm asking if I can maybe refresh my memory by means of a statement that indicates that money was paid.
Yes. And you then conclude that on your basis.
But maybe let me close this nicely so that we don't leave it hanging. Advocate Riley, that is part of the evidence that was led in this inquiry. That after the killing of, is it Lindelani Buthelezi? An amount of 750,000 rand was collected by the Stenga Taxi Association and sent to either Boysen or Mostert or both. And after the killing of Bongani Mkhize, an amount of 1 million was collected and collected again by the Stenga Taxi Association and given to Boysen's, Major General Boysen or Inspector Mostert. So that is the evidence that is before this inquiry. I didn't want to leave it hanging because you say you want to refresh, and I assumed that when you were asked to analyze the evidence, that would have formed part of the documents that you were given. But if you were not given that and you didn't see it, I'll leave it at that.
Thank you, ma'am. I will, if you want me, I can go back and maybe come back at a later stage to indicate to you if there was such a statement.
I think we should differentiate between the monetary awards in relation to the performance by the police officers who had managed to trace the alleged suspect in the killing of Superintendent Kondo, and the money that was collected from the Stenga Association. If you look at GSM 6, for instance, Advocate Matoni is attached to Advocate Mayema's affidavit, GSM 6.
Zondo statement.
GSM 6 attached. Is it attached to whose statement? It is attached to Advocate Mayema's affidavit as one of the annexures. It's volume 1 of Advocate Mayema's bundles of 3. It is at 226.
They use the page number 1A.
I'm looking at it. GSM 6.
I'm there, Madam Chair.
You see that?
Yes.
And I don't know about the bottom numbering, but look at the top of that document. That is the name of the annexure. You see that annexure?
Yes, Madam Chair.
That is the annexure headed monetary rewards. Do you have it, Advocate Riley?
Advocate Ngcukaitobi is just trying to assist me.
Yes, it is an annexure marked GSM 6, annexed to Advocate Maema's affidavit. The numbering on top is 226 in red. At the bottom, there's 1A-154, but I'd like us to look at the top numbering. It's
That is correct, ma'am.
B00243. B00239. Advocate Ngcukaitobi, if you are there. Is the document marked monetary rewards? Do you see that document?
That is correct. Monetary and non-monetary awards.
No. Look at GSM 6. The next one is monetary and non-monetary awards. Look at GSM 6, that is marked monetary rewards.
I got it now, Madam Chair.
You want to read that document? It's 1, 2, 3, 4, 5, 6, 7 paragraphs, short paragraphs.
On the 27th August 2008, Superintendent Chauke and Inspector Kanyili was waylaid on the way to court by assassins. Superintendent Chauke was the provincial coordinator for taxi violence. His successes in this investigation had raised the ire of the perpetrators of violence in the taxi industry. Superintendent Chauke was shot dead and Inspector Kanyili was seriously wounded. The killing of Chauke had sent shockwaves through the community. This criminal attack was seen as a direct attack against an organ of the state. The assault case was widely reported and applauded by the media and public alike. It most surely restored faith and confidence in the SAPS to deal with ruthless killings. It is recommended that the members on the close list be rewarded with a cash incentive of 10,000 Rand each, as well as a certificate by the National Commissioner.
You see there that the rewards is limited to 10,000 Rand for each of those who performed as was expected, in line with paragraph 7.
That is correct.
And that is coupled with a certificate by the National Commissioner.
That is correct.
There is nowhere where this monetary rewards refers to large sums of money. At least what you have read now.
That is one incident, yes, in terms of the monarchy.
No, Advocate Riley. I'm asking you, there is nowhere in this document speaking about monetary rewards where large sums of money is mentioned.
That is correct in this one, yes.
Would you like to correct your previous answer?
No, I'm not going to correct it because I read all the monetary awards awarded to the Cato Manor unit, and based on my analysis for several other cases as well, they have received monetary awards, and I indicated that based on my analysis, after all these incidents, Boysen only received 10,000 Rand, and in the case of Mostert and others, they have received over a period of years, in respect of different cases, monetary awards, and that amounts to the total that I've given.
And were the monetary awards that amounted to lump sums of money based on these documents that I've referred you to?
No, it is based on not this document. This document talks about 10,000 rand.
Yes. So refer us to the document that refers to the rewards in large sums of money that were paid, for instance, to Mr. Mostert.
This document is available because it was part, I don't know whether it's available, if it's part of the evidence that was, or the exhibits that was handed in during, but if you give me an opportunity, I can find that document.
I'm asking
Because
you
that document,
because you don't want to retract your previous answer. Your previous answer, according to the question, should have been based on this document that I've just referred to, because that was the monetary rewards in respect of the killing of Superintendent Konko. This is what was promised.
that I will,
The large
that I will
amounts
agree
of,
in
listen
respect
to me
of
first,
the-
madam. If you can just listen, please. The other
so ma'am, see?
The other monies that were paid that we are referring to does not form part of this rewards that is mentioned in this document. That is why I'm asking you if you can refer us to a document of rewards of large sums of money in respect of which Colonel Mostert was paid. Refer me to that document, because I am only aware of monetary rewards, one document referring with regards to the killing of Superintendent Konko. And this is the document
If you
that I've
give
just
me the
referred. This is the document that I've just referred to too.
If I've been given the opportunity, I will do so. I will provide this panel with that document.
When will you do that?
I can, if the call, if the panel wants me to stand down, I can go find it.
Are you in a position to tell Advocate Lekgetho to search for you? She is nearby you to assist you?
I don't think so. It's part of my documents that I have.
Or leave it at that, Advocate Mchania? You have at least seen GSM 6. Thank you.
Now, Advocate Riley, just to close up on this GSM 7, did you have regard to this document?
That document, I think, forms part of the Durban Central docket that I've read in conjunction with the statement of the police officer who provided that information about the rewards. So it forms part of, yes, so I've seen this docket, that's one incident, and then I've also read the other incidents when they have received monetary rewards for work on other cases.
So this would be the source where you found evidence that Major General Boysens was paid 10,000 rands, because he appears amongst the candidates to be paid to receive 10,000 rands.
That is correct, yes.
And I take it you understood the rationale or the reasons why Major General Boysens and those listed there were being paid.
That is correct. I read what they said there.
And did you notice that it was for the solving of the murder case of Superintendent Konko?
That is correct. That's what I read.
And we know that, in fact, insofar as those who were alleged to have been implicated in his murder, none of them were arrested.
That is correct.
In fact, they were killed.
That is correct.
Yes. So now, would you then say that the conclusion that in fact, these rewards were for the successful killing of those that murdered Superintendent Konko, would you say that is far-fetched? That they were being rewarded for killing Superintendent, they were being rewarded for killing those who killed Superintendent Konko?
They have been rewarded for solving a case. That's what the document that I read.
Yes. But we know that no case was solved. In fact, people were killed. As we stand here, no one was found guilty for murdering Superintendent Konko.
That's what the documents say they've been rewarded for.
What do you mean that they were rewarded for solving a case?
That's what the document implies, that they're being rewarded for that.
Is that how what you understand it to mean?
That is correct, yes.
Resolving a case? What does it mean to resolve a case? In the legal sense, at least, because me and you are lawyers. What does it mean to resolve a case?
It means that you have found the murderers of Chonko.
Even before you go to court, you resolve a case.
It can happen.
How?
If a case is investigated and you find suspects, and for various reasons the suspects are no longer there, that basically means that the matter has been resolved.
The suspects are no longer there. That's what you're saying?
If the suspects are no longer there in order to enroll the matter on the High Court roll, they're no longer available.
Because they've been killed.
That is correct, ma'am.
You may proceed.
Maybe I'll get a better understanding. Ma'am, Advocate Riley, you are a prosecutor.
That is correct, ma'am.
Your responsibility is to prosecute accused
That is correct.
in a competent forum, which will be a court of law, in
That
order
is correct.
to solve a case.
That is correct.
Do you regard the killing of suspects as solving a case?
Ma'am, if, as said, the suspects are no longer available and the case has been resolved, then the case is resolved.
I'm asking this question. Do you regard the killing of suspects as resolving the case?
It can happen that suspects, in many cases, in our environment, in the gang environment here in the Western Cape, you have a case, your suspects get killed. The case gets withdrawn, struck off the roll, you refer it for an inquest, the matter is then resolved.
It's a difficult one to comprehend, but you may proceed, sir.
Yes. And then we now know, Advocate Riley, that for the reasons that you just told us was that on the probabilities, it makes no sense for Major General Boysen and the Cato Mena Squad to risk their careers for mere or measly 10,000 rands. Is that what you say?
In respect of Major General Boysen, yes, I said that.
Now, let's just zoom out from Major General Boysen and zoom in on Moster Denel. From the evidence we had here was that, in fact, I stand to be corrected, there was a competition between Moster Denel as to who will take out most people. Were you aware of that?
I work on evidence, sir. So if there was evidence to that effect, I would have been aware of it.
And on the evidence, were you aware that Inspector Mostert had in fact shot almost over around 13 or 10 people, just between 10 and 13 people?
In terms of, it's quite possible, yes.
Yes. So would you say then in that case, would you say that with the conclusion that in fact he would be motivated to kill people because he stands to gain a reward, would that conclusion be far-fetched?
I can't say that because based on the evidence in the dockets, there's no evidence to that effect.
But we know that he has
You
killed.
can point me to those evidence.
But we know that on the evidence he has killed at least 13 people.
That's an inference that you make.
No.
You're making an inference now. And you ask me to agree with your inference that you're making. That because he killed 13 people, that could have been his motivation to get the rewards.
No, I'm asking
no,
that.
Advocate, you have a right to disagree with Advocate Matoni. You are not forced to answer any question favorably to the questioner. Just answer the questions. If you agree, you agree.
I don't agree.
If you disagree, you disagree.
But
I disagree.
thank you, Madam Chair. Were you aware that, or at least on the evidence, Mostert has killed 13 people?
I didn't count, but I wouldn't disagree with you.
And
It's quite possible, yes.
and so is Nell, who has killed also quite a higher number of people.
You can put it to the witness as a fact.
Yes, in fact, it's in the dockets. Were you aware of that evidence when you did the analysis?
The group that was charged killed, we read 26 dockets, and the allegation, and in terms of the indictment, 28 people were killed by the people that was indicted. So yes, I would agree with you.
Yes. And we know that it looks like there was a practice to reward members of the SAPS for solving cases. And on your version, killing a suspect is part of the solving of the case.
I didn't say killing. I said if you have a case and your accused is no longer available, whether it's withdrawn, struck off the roll, or referred for an inquest, it's regarded as being resolved.
But would we not regard the reason why it is struck off the roll or reserved for an inquest as, can we ignore that?
I
Matoni,
don't
just
understand.
before she answers, unless I'm missing something, I think the questions that you are asking, the last 2 or 3 questions that you are asking, are a question that has been asked and answered.
Okay, I'll move on, Madam Ramaka. Thank you. Okay, now is there anything on this chapter that you want to add under the alleged purpose of an enterprise that you would like to add, Advocate Riley?
In terms of, I just want to make, we spoke about knowledge of General Boyson. I just want to say that maybe I've neglected to say that besides knowledge, it could have also mean that he ought to have known. And I think in terms of the Savoy case, it's also negligence. If you, for example, have known or became aware that certain criminal activities were happening and you simply ignore it and do not act upon it. So that's just the one aspect that I want to add in terms of knowledge, and ought reasonably to have known, that you can draw a specific inference therefrom what the reasonable person ought to have known. That's about all that I want to add there.
Actually, you spend a long time on the elements, and
No,
I think we must make progress.
No,
You
I'm
only
not-
have 30 minutes.
I'm not going to ask any further questions on this.
Yes, I
amendment.
think you have to conclude with this witness.
And you then, at paragraph 99, make your conclusions. I think we already know the reasons for your conclusions. Is that correct?
That is correct, yes?
Yes. You then also identified what you call inconsistencies in the documents that were there.
That is correct, yes?
Yes. Is there anything that you want to say over and above what you said in your statement relating to the alleged inconsistencies?
No, and we also deal with it in our report in terms of the inconsistencies.
Excuse me, Madam Chair, just want to, looks like there's something, they want to convey something to me.
No, and why isn't that just Melime just sitting behind you when you could have been sitting next to you? Because your colleagues are not here, there's nobody from the NPA, it would have been quite easy for you to confer with one another.
I got the message though, Madam Chair.
Yes.
Yes.
When you re-examine, at an appropriate moment, move forward, sir.
Then the next chapter is where you say there were people who were killed who were not victims. I think we've addressed that as to what your recommendations were. And then you then say that in the next chapter, you talk about incidents where there were, you seem to refute the contention by the prosecution team that in fact in some of these instances there were no warrants of arrest. And you identify
That
at
is
least
correct.
4 cases where there were warrants. Is that correct?
That is correct, sir.
But other than this, would you agree that in respect of the others, there were no warrants of arrest?
That is correct, yes?
Yes.
Can I ask a quick question? Does the fact that there were warrants of arrest justify the killing of the suspects?
No, ma'am. It was simply in reference to the fact that the prosecution said there was no basis for them to go and look for the suspects.
Thank you.
You then, in the next chapter, from paragraph 105, you refute the evidence of the planting of firearms.
That is correct, yes?
And we know that the person who tells us about the firearms being planted is Captain Mangena. The possibility of the firearms being planted is Captain Mangena.
In the matter that you referred me to, yes?
Yes. Did you have any evidence to contradict what Captain Mangena said relating to the possibility of firearms being planted?
As I indicated before, the evidence of Captain Mangena in the docket, in the individual docket, were analyzed and read in the context of all the evidence in the docket. So I did mention before, if you found, for example, spent cartridges positively linked to the firearms, if you found, for example, primary residue, those were things that we considered as well as that evidence of witnesses.
Please repeat
Other
the question
witnesses.
for the witness to answer the question.
I'm saying that in those cases where Captain Mangena, I think we went through those dockets earlier, could you find any evidence to contradict what Captain Mangena said about the possibility of the firearms being planted? Did you have any evidence to contradict it?
Not just evidence,
In the-
expect evidence.
Yes.
The one case that you refer me where I said the possibility, we didn't have any other evidence in the docket, yes.
In particular, expect evidence, because we are talking about the expect evidence of Captain Mangena, who was a ballistic expert. Was there any other ballistic expert who presented evidence that contradicts that which Captain Mangena provided? As you know,
Not in the dockets. I don't know.
In other words, there is no such contradicting evidence or expert report.
That is correct, yes.
Thank you.
At paragraph 107, you seem to rely on the fact that some of the deceased tested positive for gunpowder residue. Do you see that?
What paragraph
That is correct.
107. Now, what we could gather from your career history, you prosecuted in the magistrate's court for a number of years. Am I correct?
That is correct, yes.
And you also prosecuted as both a junior state advocate and a senior state advocate.
That is correct, yes.
And would I be correct that some of the cases you prosecuted included where a firearm was discharged?
That is correct, yes.
And I take it you would then be aware that there are many other than having fired and discharged the firearm, there are other ways that a person can be contaminated and test positive for a primer residue.
What we refer to, or the as secondary transfer of primary residue, yes.
Yes. Now, one of the secondary transfer is if one is in the close, if a firearm is fired within the close proximity of the other person.
That is what they call distance determination, yes.
And also that if a person who had discharged a firearm touches the other person, then that other person who's touched can also test positive for primer residue despite not having discharged a firearm.
That is what they call secondary transfer, yes. If there's evidence that, for example, a person who fires a firearm, you would ordinarily have primary residue, and if he goes and puts it on the hand of that person, yes, I would agree, you can then transfer that primary residue.
Now, in this regard, did you investigate the manner in which, as to how it came about that these accused people tested positive, that it could have been through a secondary transfer? Did you investigate that?
It was not our role and function to investigate it. I worked on what was in the docket, and there was no requirement from the panel to ask for further investigation to be concluded, because the evidence that was presented to us was the evidence that was in the hands of the prosecution team who drafted the indictment based on the dockets that were handed to us. And if they never asked in those dockets for a further test to be done to determine, for example, how the primary residue landed up with on the hands of the suspects or the deceased persons. One would have expected them to do it if that was the case, that it was as a result of secondary transfer of the primary residue.
And then at paragraph 109, we've dealt with this thing where you said that, in fact, the events that are described in Danikas' statement were not properly investigated. And we know that you've also indicated that there were other issues such as the financial investigation that were not done. Do you still maintain that?
I do. In actual fact, if you look at SR5, in each and every docket that we analyze, we have indicated that there were many problems with the investigation. In fact, that there were further investigation outstanding.
Yes, but ma'am, you see, in fact, now that you mentioned SR5, you come up with a number of recommendations and identified certain loopholes. Yet you did not find it important to bring this document to the attention of the NDPP, who could have taken it to the prosecution team to say, my team has analyzed this, I have looked at this, can you please follow up on this, on the issues that have been so done? Why?
If I do recall, I can't say that it was handed to the NDPP, but we have, in fact, based on our recommendations, that they should look at the investigations that's outstanding in the 26 dockets, that they should consider concluding that investigations and where they could institute prosecutions. This document was in fact handed to Advocate Elaine Harrison.
Okay. And then you then say at paragraph 110, in fact, amongst amongst some of the dockets, there were already judicial pronouncement by magistrates in inquest that no one could be criminally held liable for any deaths. Do you see that?
That is correct.
But were you aware that some of this, that even in where there was an inquest which had found that no one could be held criminal liable, that does not close the doors for the prosecution to be instituted against anyone in case new evidence comes to the fore?
I understand that. In terms of the Inquest Act 58 of 1959, Section 17 is applicable, and that was what we found very strange, that there was no such applications brought to reopen the inquest before you made it part of your indictment or your prosecution memorandum, because that should have been the first step in terms of reopening the inquest, because one needs to remember you can approach the High Court and basically say that there has been a pronouncement that no one is criminally liable for the death. However, you have now new evidence that refute that, and you should ask the court then to reopen it. It wasn't done in these cases.
But you'd agree that the two processes can run parallel?
Remember, a finding by a magistrate is tantamount to a judgment. So you need to undo that before you add that matter. And it's the same thing with the Timor matter, for example, where that process needs to first take place before you prosecute or decide to institute prosecution. You need to undo that process by presenting new evidence, such as in the Timor matter, and then the court undo the past decision or judgment that has been brought out by that magistrate.
Yes. Now then finally...
It should have been done before the time.
Yes. Then finally at paragraph 111 and 112, you then deal with your findings and your recommendations. Is that correct?
That is correct, yes.
And amongst the recommendations or findings you made relates to the validity of Advocate Jiba's authorizations, which you had said earlier were not part and parcel of the mandate that was given to you
that
in
is
April.
Correct, yes.
But yet you went
I
on...
concede that, yes.
Pardon?
No, Advocate Riley, when counsel is asking you a question, just afford him an opportunity to finish so that you can answer.
I'll do so,
the
madam.
question.
I apologize.
Yes.
Madam, would you please wait when each of us is talking to you? Don't interrupt as we do not interrupt you when you answer. It is a respect thing. As we accord you the respect, you must return that respect to each one of us.
I apologize. I will.
You do not make that recommendation. You, in fact, make a finding that the authorizations were invalid, which amounts to basically you say that they are unlawfully issued. And then you then recommend that the charges should be withdrawn.
That is correct, yes.
Would you be able to enlighten the panel why you did not make a recommendation to Advocate Batoyi to say, to the extent that insofar as the cases where we have identified gaps and which we believe those gaps can be supplemented through proper investigations, then that proper investigations be conducted?
Our mandate was to look at the authorizations where it was valid.
What was your mandate? Do you remember SR3 from Advocate Batoyi? You want to look at that mandate again? The exact wording of that mandate? SR3 to your affidavit. At SR 1077, the mandate is spelled out very clearly there. You remember?
She's back.
Advocate Riley, you seem to be disconnected. Are you now connected again?
That is correct. We were disconnected for a while.
Yes. You had just spoken about your mandate, what your mandate was, and I said to you, we may have to revisit SR3, which is a letter that was addressed to you to the team, not you personally or you alone, to the team, the DCOC team, by Advocate Batoyi. If you look at SR 1077, you remember that letter?
Can I just refresh my memory with it?
Yes. You may specifically look at paragraph 2 at page SR 1077. Your annexure.
That is correct, yes.
Yeah, that's your annexure SR3.
That is correct, yes.
Do you see the mandate there? If you look at the
correct.
middle of that paragraph, he says, in the circumstances, I request your assistance in perusing all the evidence and other relevant material, and thereafter furnishing me with a well-reasoned and motivated opinion. You see that?
That is correct, yes.
Yes. So that was your mandate. I didn't read
That is
everything
correct.
there. It says as to
That
the
is-
validity and appropriateness of the decision by Advocate Abrams to authorize the 2 racketeering prosecutions in terms of Section 2.4 of the POCA. In the matter, please include in your report any factors that you regard as relevant and should be brought to my attention. That was your mandate. Any comment? Any comment?
Sorry, there seems problem. I lost you at some of your of what you asked us to have a look at in terms of, I just heard you reading up until section 2, subsection 4.
Yes, that paragraph, it contains the mandate that was given to you by Advocate Matoni, the request as to what you should do as a panel. You agree?
That is correct, yes.
Nothing more, nothing less. Correct?
That is correct, yes.
Thank you.
May I continue? Chair?
Yes.
Now, taking from what the chairperson just read out to you, the last sentence, in fact, goes wider than what we were asked. She asked you to say if there's any other thing that you regard as being relevant and that should be brought to my attention, please do so. Do you see that?
That is correct, yes.
Yes. Now, did you not consider the fact that there were these investigations that you had identified, these shortcomings that you had identified? Did you not consider those to be relevant factors that should be brought to her attention?
It was brought to her attention that the dockets were not properly investigated.
Yes. But you did
And
not.
that's why when we
Continue.
That's why when we go to 112.3 of my affidavit, we ask the DPP KZN must review the evidence and decide whether to proceed with the predicate offences. So we highlighted and we forwarded our document to the DPP KZN to have a look at the dockets in which we highlight that there's investigation outstanding.
Yes. But remember, the poor investigation that you had identified, or the shortcomings that you had identified, related to the sufficiency of the evidence in order to sustain racketeering charges. So she asked you to say, well, if there's anything that you believe it's important insofar as racketeering charges are concerned, please bring it to my attention. Now, you say that the lack of proper investigations affected the sufficiency of the evidence on the racketeering charges. Now, did you not regard that as being an important aspect that you should bring to her attention, that, well, in as much as we believe there's insufficient evidence, this evidence can be supplemented through proper investigation? Did you not consider bringing that to your attention?
21E and 21F, we have discussed at length the evidence that was relied on. Which, for example, I don't know what you want me to say in respect of did you expect us, in addition to that, say that what evidence are required to prosecute these people?
I think you've...
Because that would be tantamount to us then doing a further investigation ourselves, and that was not part of our mandate. We did indicate that the investigation, there are outstanding investigation, and we did include, indicate what are those investigations that are outstanding.
Yes. And then you then conclude in your report that says your conclusions were based on your understanding of the law and the analysis of the evidence as well as the material before you. Right, paragraph 113.
That is correct.
And you had indicated earlier, yesterday, that you had wished to supplement your statement by dealing with the evidence of of Captain Mangena. Do you still wish to avail yourself to that opportunity?
No, I see that I've been provided by Advocate Legoto a bundle containing the cross-examination, which also...
I beg your pardon, Advocate Lekgeto.
Laketo. My apologies.
You say she provided you with?
An index from the cross-examination, and I see on there is cross-examination that will take place in respect of the reports of Captain Mangena.
Yes. And then is there anything else that you want to add as we finish your examination in chief?
Nothing else.
Yes. Advocate Riley, thank you for your time and your cooperation. I've got no further questions for you. Madam Chair, I've got no further questions for the witness.
Yes, Advocate Riley, just the last from my side, 113. There are two 113s there. The second 113, you say, we were not influenced in any manner whatsoever. What was the point of making the statement? Has anybody ever suggested that you had been influenced?
No, ma'am.
Why would you have a statement like that in your affidavit? Or is there any
Basically,
reason why you deemed it fit to include a sentence to that effect?
I have no reason to indicate basically that our decision was made objectively.
Thank you.
Yeah, thank you, Chair. Advocate Riley?
Yes, ma'am.
Yeah, I'll be asking questions. I will try my utmost to avoid long answers. If you can help me with that, then we'll be finished soon with this inquiry. Now, is an understanding that what you were required to do was to actually interrogate the decision of Advocate Abrams of issuing the racketeering certificates in the main?
That is correct. Whether it was properly granted,
Yes.
the authorizations, yes.
Yeah, so your concern would be to look at the facts that are available and to try to get into the thinking of Advocate Abrams as to what prompted him to issue the certificate as he did.
That is correct, yes.
And Advocate Abrams has drafted an answering affidavit to the application that was made by General Boysens, seeking to, thank you, I'm sorry about that, seeking to have the certificates set aside. That is correct.
That is correct.
Thank you. And in that affidavit that he has drawn, he is dealing with his interpretation of the POCA Act or the POC Act. Am I correct?
That is correct, yes.
And also, in his affidavit, he is also placing on record facts upon which he relied when he issued these certificates.
That is correct.
So looking at those facts, it is fair to say the thinking of Advocate Abrams would be found in his answering affidavit to the application.
That is correct, ma'am.
And that answering affidavit, as you read it, clearly sets out his defense of the decision that he has made.
That is correct.
And he actually stood by his decision. At no point in that affidavit is he making a concession that he may have erred by issuing those certificates. Is that correct, madam?
That is correct.
Yeah, remember, I don't have to remind you. If it's correct, say so. And the affidavit of Advocate Abrams is actually found in page SR 0140. Please get, it's an attachment to your statement. SR 0140. Have you found it?
That is correct. I have it.
You have it. Thank you. I'd like you to please turn to page SR 0160. I'll refer you just several paragraphs, and then from there I think we'll part ways. Are you
I'm at
160? SR 0160.
That's correct, ma'am.
Okay. Now, I'd request that you please read paragraph 72, 72 to 73, no, 72. It ends at 161. Will you please read that into the record?
SAP's correspondence attached to Mahema's affidavit as SM9 corroborates the allegation that members of the Cato Manor SVC, falling under Boyson's de facto operational command and control as outlined above, systematically assassinated members of the KwaMaphumulo Taxi Association, KTA, who were engaged in a taxi war with the Stanger Taxi Association, STA.
Thank you. Now, do you agree, as you looked at the dockets, and as it has become known to you that many have died in the
That
name
is correct, yes.
of the death of Superintendent Kongo, would you agree that many of the persons that died, that were killed, they are persons that were found to be members of the KwaMaphumulo Taxi Association?
I can't specifically now say or agree, but I do know that they were members of a taxi association.
Then you cannot deny that many, if not all, that had passed on, that had been killed by the Katomena police, were from the KwaMaphumulo Taxi Association.
Not the whole case, ma'am. Not all the 28 murders. If I think about the Konko case, there were 3 deaths that emanates therefrom. But I speak under correction, but not in all the 28 matters.
I'm sure you were listening to my question. I said almost all, if not at all. They were from the KwaMaphumulo, they were members of the KwaMaphumulo Taxi Association. We are aware that we have Boko Ndlovu, but I'm talking about the great number were from members of the KwaMaphumulo. Do you agree? I said, will you dispute that? Because after you said you can't agree, then the question is, will you dispute that fact?
That members of that taxi association was killed, I will agree, yes.
Yes, and I have said members of the KwaMaphumulo Taxi Association. That is the question that I've asked.
Yes, I will agree.
And will you also agree that none of the deceased was a member of the Stenga Taxi Association?
I can't say I agree or disagree. I will have to go and have a look at the specific dockets, yes.
Now, shall we then proceed to paragraph 75 on the same page 161? Do you see that?
That is correct, yes.
Will you please read that paragraph 75 into the record?
Chauke's death set in motion a series of shooting incidents, 23 in all, in which 28 people died. I might mention that many more were suspected to have been killed by Cato Manor SVC, but there seems to be insufficient evidence to the others. Cato Manor SVC investigated the murder of Chauke. Most of the applicants form part of the investigation team that work on the investigation.
Yes. Now, from that paragraph, is it correct to understand it to mean that much as the issues were raised around the death of 28 people arising from 23 shootings, but in fact, there were even more who were suspected to have killed, but they were not pursued because of apparent lack of sufficient evidence? Is that also your understanding of this paragraph?
That's my understanding of what Advocate Abrams is saying, yes.
Yes. And in fact, what Advocate Abraham is saying to us, there could be more, but what persuades us whether to pursue or not, it's evidence. And if it is so hopeless, then we don't pursue. We could have pursued more, but because of lack of sufficient evidence, or because of insufficient evidence, we only pursued these 23.
That is correct.
That is correct, yes. That's fine, thank you. And now let us turn to paragraph 76. And it is still on the same page, and I would appreciate if you are to read that paragraph into the record.
28 people were shot dead by the members of Cato Manor SVC. 8 people suspected of killing Chauke were themselves killed in the wake of Chauke's death. One of them was Bongani Alphys Mkhize, B.E. Mkhize, a former head of the KTA. Members of Cato Manor SVC claimed he had opened fire on them when they attempted to pull him over. B.E. Mkhize had earlier obtained from the Durban High Court a futile interdict restraining Cato Manor SVC from killing him.
Yes, you can stop there.
Mkhize's
Thank you. Thank you, ma'am. I'm sorry I did not indicate to you as to where you can stop. you can stop there. So this paragraph confirms that the 28 people that were shot dead, they were shot dead by the Katomena SVC.
That is correct, yes.
And then let us look at paragraph 80. Hmm? Paragraph 80. And also that I'm making you read these extracts into the record because this is part of what you looked at as you were preparing to advise the NDPP about the decision to issue the certificates. Please read the paragraph 80.
The extraordinarily high mortality rate among suspects where Katomena SVC was involved formed the basis that it may have evolved into a hit squad. Ordinarily, for every fatality in policing of this kind, one might expect at least one wounded suspect. But here, almost all instances, all the suspects at the scene were shot dead. The explanation given by Katomena SVC was that the suspects had returned fire. But that is difficult to square with the fact that in no instance was a member of Katomena shot, nor were there reports even of police vehicles being damaged by bullets.
Yes, in this paragraph, the Advocate Abrams is explaining himself as to why, what caused suspicion, and taking into consideration what is within your knowledge from studying the dockets, looking at the dockets and so forth, and the time span of the deaths of all these people, would you agree that indeed the mortality was extraordinarily high? The mortality rate actually was extraordinarily high, where Katomena SVC was involved and was consequently then labeled as a hit squad.
It was a high mortality rate, yes, I agree to that.
Yeah, but you don't answer what I asked. I did not say, is it a high mortality rate? I said extraordinarily high mortality rate at the hands of Katomena.
That is correct, yes.
You agree? Okay, thanks. And then please now proceed to read on the same page to the next page, 164. Please read 81 into the record.
The alleged modus operandi was to track down suspects and instead of apprehending them, slaying them. Katomena SVC officers would then, so it was alleged, plant firearms to support the claim that the victims were killed when the police returned fire. I refer to the following eyewitness statements relating to the killing of Prince Tapedi in Kwamashu 69811 of 2009, referred to in counts 62 to 65 of the indictment.
Yes, before you then proceed, as a public prosecutor, you know, lawyers here, fortunately lawyers know, that the duty of the police officers is to track suspects down, and the success would be when those people have been prosecuted in an open court and a verdict is given by the court. That would be justice. Verdict, whether guilty or not guilty, but that is what we call justice. Do you agree?
That is correct, ma'am. I agree, ma'am.
And contrary to that, what is painted here in this paragraph is that suspects, the modus operandi would be to track down the suspects, which should be loaded. But the downside is that instead of apprehending them, it would be to slay them. I'm sure you're also disappointed with that approach. Advocate?
That is correct, ma'am.
It's correct, yes, I agree with you. Now, when one even looks, trying to scrutinize this very paragraph from Advocate Abrams, he says the Katomena SVC officer to then saw it was alleged plant firearms to support the claim that the victims were killed. Now, this, in my view, and I'm sure you'll agree, shows that Advocate Abrams is not taking sides with anyone. He is saying, so it is alleged about the firearms. And then later in the affidavit, then he deals with information where it was corroborated by other experts about this alleged planting of firearms. Do you see that he is not associating himself with the allegations, and he will associate himself with the allegations only at the time when he is showing? Yes. Yeah, is it too low? At times witnesses, ma'am. Yeah, there are times when witnesses will try to say to you, hey, you are asking too long a question, and they intervene. Okay, go ahead.
Sorry, ma'am, I didn't hear your last part. There seems to be a problem with, sometimes it freezes a little bit. And then I can't hear your entire question that you put to me.
This paragraph 81, ne? We have dealt with the modus operandi, and now we are dealing with how Advocate Abrams relates the matter or narrates the matter in his affidavit. And he is talking about the alleged, do you see that? Please read the second part again. Katomena SVC, that second line on page 163. And just that sentence, when at the full stop, you stop there. Don't proceed to, yes. Please read that.
Katomena SVC officers would then, so it was alleged, plant firearms to support the claims that the victims were killed when the police returned fire.
Thank you. And that says to us, I, Advocate Abrams, am saying it's an allegation at this point of my affidavit. Am I correct?
That is correct. He said it's alleged.
Yes. And now look at paragraph 81.1. Still on that page. When I change pages, I'll indicate to you. Still on that page. Can you read it into the record?
81.1, Kaba Mdluli, 821, attached here to as annexure SA 5A, in brackets 1, who saw applicant 5, accused 4, who was carrying an R5 rifle, running back to the Quantum combi in which he and Kaba was seated to collect a spook ghost under the left front seat of the Quantum.
Read
81.
81.2 so that when I deal with them, I deal with them at once.
Okay, ma'am. 81.2, Denise Hurley, in brackets 812 and 830, attached here to as annexures SA 5A, in brackets 2 and SA 5A, in brackets 3, respectfully, who saw a white male throwing a pistol or small firearm next to the deceased's right hand.
Thank you.
Yeah, 81.
Yeah.
Oh, sorry.
Now, these two subparagraphs, what do they show us? They are telling us about eyewitnesses that saw the firearms being planted. Do you agree?
That is what the statements say, yes.
Yeah, I'm saying, it is saying, so and so did this clearly. And can you say, maybe, that there are no such statements? Because you went through the dockets. And my expectation is that if my duty is to interrogate the conduct of a particular person, I will take the affidavit and match it against evidence as I conduct the investigation. And I think you too do that as a prosecutor. Now, back
That
to
is
the
correct,
question.
yes.
Yeah. The question is, can you say that this statement by Advocate Sean Abrams is not true? That Ngaba said he saw them planting a spook, the ghost firearm. Others said the Bombay
Not what,
firearm.
that is,
Yes?
if I read 81.1, it says Nkabinde said he went to collect a ghost or spook under the left front seat of the Quantum. Denise Hurley says she saw a white male throwing a pistol next to the deceased right hand.
Okay, maybe
We have studied those statements.
I think in some way I'm now allowing myself to be carried away by what you are saying, but of importance is that what is stated is in 81.1 and 81.2 respectively illustrates the existence of eyewitnesses to the fact that the firearms were planted. Remember, we are not in court yet where the court will make a finding as to whether indeed that happened or not. But what we know is that there are eyewitnesses who will be able to say, I saw so and so plant the firearm. Do you agree that the import of those statements is to illustrate that?
Ma'am, I didn't, you're breaking up, I'm sorry, but so I don't hear the full context of your question or what you put to me. It's very bad in terms of me having to listen. I can't respond if I can't hear the whole question put to me.
Okay. You know, the question is in what you have read into the record. Do you hear me thus far?
I can hear you, yes.
Okay. Now, that which you have read into the record is that there is a statement of Ngaba who saw applicant 5, accused 4 in the indictment, carrying an R5 rifle, running back to the Quantum, and then to collect a spook firearm. You still hear me up to this funny? Advocate.
Can you hear the last part, ma'am?
Okay, maybe to cut the long story short so that I don't make you listen to what you have already read in. Do you agree with me that 81.1 tells us that Ngaba saw what we can call the planting of a firearm, which is described as a spook firearm? Do you agree that that paragraph does that?
No, I don't agree because he said the person, applicant 5 or accused 4, came back to the combi to collect
seem to be having problems with connection. Advocate Riley. Unfortunately, we don't have anyone here to assist. The secretary is supposed to be here to help us.
We're also having network issues in this building.
Are you also having network problems here?
Yes, since after lunch.
Yes, we know that. Just a minute. Yes, I'm advised that they've gone downstairs to reboot, but it will take 30 minutes, meaning that we may have to adjourn for 30 minutes so that we can get the connection back. You can see Advocate Riley. Yeah, someone will communicate with Advocate Lekgeto telephonically and tell her that we are rebooting the connection. Yes, thank you. May we adjourn for 30 minutes? Good evening. Good evening, Dr. Chauke. It seems that you are still going to be detained here. Good evening, Advocate Riley.
She'll be on her seat, Madam Chair. A second.
Good evening, Advocate Riley.
Good evening.
You continue to be under oath.
It is correct.
Before you proceed, my sister is going to ask you to continue with her question. We are now connected. But before she does that, let me do some housekeeping. Advocate Ngcukaitobi, we request that in an hour's time, we pause. It's for a few minutes. You can join us in chambers so that we can do some few housekeeping matters about next week. Then we can reconvene. So if within an hour you'll still not be done, we will nonetheless pause for a few minutes, then you can join us in chambers and reconvene.
Reconvene back here.
Back here. Yes, thank you. Please take note, all of you. You can come to chambers, then we can discuss about next week. You may proceed, my sister.
Thank you, Chair. Advocate Riley, can you hear me?
Yes, ma'am, I can hear you.
Okay. When we adjourned, we were on page 0164. And I'm going to ask you only maybe 2 questions or so. Look at, you had read into record 81.1, 81.2.
I'm just trying to find that page.
SR 0164 of your statement.
That is correct.
Okay, thank you. Now, do you see paragraph 81.3?
That is correct, yes.
Will you please read that paragraph into the record?
Check Jacobus Stale, in brackets 826, attached here to as SA 5A, in brackets 4, whose finding was that the deceased was lying on the bed with his head on the pillow when all the wounds were inflicted, and further that the revolver, as depicted on the scene photographs, was defective and not capable of discharging ammunition.
Okay, yeah. Now, that says that the revolver that was next to the deceased was defective and not capable of discharging ammunition. You confirm that?
That is,
right.
I confirm that.
Thank you. Then read paragraph 82.
The modus operandi was further explained in a detailed statement by Danikas, a police reservist who worked closely with Boyson, annexure NJ3, referred to above. It was corroborated by ballistics reports supporting the allegations that those killed were not in fact resisting arrest when they were killed. Some corpses show execution-style head wounds. Danikas' statement, which was later supplemented as detailed in Mahema's state affidavit, has since been signed.
Yes, this says that statement of Danikas, whether signed or not, but it was corroborated by ballistics reports. We are in agreement about that.
That is what it says, yes?
Yes, and the rest now, it deals with each and every case concerned, and it will not be necessary for us to proceed to deal with it. I think it has been dealt with in detail. And Advocate Riley, that is the end of my questioning. Thank you.
Thank you.
Yes, thank you, Advocate Ngcukaitobi.
Thank you, Madam Chair. Advocate Riley, can I just ask you to start with, this is a disciplinary inquiry against Advocate Chauke, and the allegations which you said you were familiar with are that he supported or endorsed or promoted a decision to charge Major General Boyson and others with racketeering despite no evidence. Correct? You are familiar with that?
That is correct, yes.
Yes. And one of the, in fact, the only ground upon which he has been charged in relation to the Ketomano issue is your report, correct?
If I read the charges, that is correct, yes.
Yes. Did you recommend that he should be charged with misconduct?
No,
Yes. And so that was a decision of the NDPP, not your decision.
I wasn't involved in that decision.
Yes. Now,
I beg your pardon? What's the answer?
says, or can you repeat your answer, Advocate Riley?
I wasn't involved in that decision.
And your recommendation is made a decision. That decision is then set aside by the High Court. On the logic of Advocate Matoni, you would be guilty of misconduct.
I'm not guilty of misconduct. I disagree with you.
No,
I
please.
was part of a panel of
Yes.
4 people. We were requested to review the evidence, which we did, and we made recommendations to the NDPP.
I
We
understand.
did not tell her to follow those recommendations.
I understand precisely. That's exactly what happened to Advocate Chauke. He was not a decision maker. The decision maker was the NDPP. He is charged for recommending and supporting, which is precisely what you have done. And he is also charged because he comes from Gauteng and is involved in matters from KwaZulu-Natal. You come from Cape Town, you are involved in a matter in KwaZulu-Natal. So it seems to me that it's hypocritical for you to say, no, you should not be charged, but Advocate Chauke should be charged.
I didn't institute any charges against Advocate Chauke. I never said he should be charged. You are there, you are incorrect.
I see. So you would agree then that it would be wrong to charge Advocate Chauke merely for making a recommendation which is not binding on the NDPP?
I did not make the decision. Neither do I know on what basis that decision was made.
I understand that, but if you want us to go through the terms of reference, we can do that. It's clear on what basis the decision was made. I'm simply testing whether there is consistency inside the NDPP's office. That's why I'm asking you that you cannot be a hypocrite. It is either you agree with me that if the MK party succeeds, you should also be charged with misconduct, or you say, I don't agree with you, in which event that applies to you and it applies to Advocate Chauke. It's as simple as that.
It's not as simple as that. Like I said, in our line of work, we make decisions every day. We also ask for opinions, and this was exactly what has transpired, to make a decision on recommendations to the NDPP. She wasn't bound by our recommendations. She says it in her internal memorandum to us that the final decision will lie with her.
Yes, but
In
that's,
respect of the charges, I was, like I said, right, in respect of your first question, I was not involved in any way with the decision to charge Advocate Chauke.
yes, but I'm asking you for your opinion now. I hear what you're saying. Whether or not the DPP of South Gauteng, who is in the exact same position as you, was correctly charged for making a recommendation that is not binding on the NDPP? What's difficult in committing an answer to that?
Because I was not involved in that decision. I don't know on what basis the decision was made to charge him.
Well,
If you can explain to me that, then that's fine. But I wasn't involved in that decision.
okay, let's look at the basis for it. I'm going to ask you to look at the terms of reference, which set out the basis. I need my copy of the terms of reference. Oh, I don't have the... Are you able to find it, Advocate Riley?
Can you refer me to where I can find it? Then I can ask Advocate Lekgeto to assist me.
I'm sure she can find it. She knows her way around the papers. It's in various parts.
I do have it now.
Thank you. If you can turn to page number 6, paragraph 3.1.1.1. Can you see that?
That is correct, yes.
Yes. Now, the opening paragraph there talks about racketeering certificates, correct?
That is correct, yes.
And it's common cause that racketeering certificates are within the exclusive jurisdiction of the National Director of Public Prosecutions, correct?
That is correct, yes.
Now, 3.1.1.1 accuses Advocate Chauke of supporting a decision, not making it. Supporting a decision to charge Major General Boysen, correct?
That is what it says, yes.
You would agree that he's not a decision maker, someone else is a decision maker, correct?
That is what it said, supported a decision.
All right. If you then go to 3.1.1.2, it talks about recommended, correct?
That is correct, yes.
And again, even there, he's not the decision maker, he's merely recommending, correct?
That is correct, yes.
Now, that is what I mean when I say he is in exactly the same position as yourself, where you are either supporting or recommending a particular decision, but it is not your decision, it is the NDPP's decision. So
That is correct.
this is the basis of the charge that you were looking for. Now, I come back to my original question. If you say, if this decision is subsequently set aside of Advocate Batoyi, you should not be charged for supporting or recommending. You must agree that even Advocate Chauke should not be charged for supporting and recommending.
I didn't draft these charges.
I know you didn't, and I am asking you deliberately because you are in exactly the same position as Advocate Chauke, that it seems to me it's logical, unless you want to be hypocritical, that if you say you should not be charged for supporting and recommending, it must apply to Advocate Chauke. What's difficult in saying what's good for you is good for him?
Are you able to comment, Advocate Riley?
I'm not able to comment because I was not part of this decision making. To charge Advocate Chauke, I don't know the basis for it, and I didn't draft any of these charges against him.
So your answer is, should we understand your answer to be no?
That is correct, yes. I did not, I was not involved in this decision to charge Advocate Chauke.
No, that's not the point. The point is not whether you were involved or not. The point made by counsel is that if you are similarly placed as Advocate Chauke, or in the position similar to Advocate Chauke, because in your report, together with your colleagues, you supported and made recommendations in relation to racketeering authorizations to someone, well, let me put it directly, to Advocate Batoi, who has the power to decide on those racketeering authorizations. She has exclusive powers to decide on these racketeering authorizations, not you, not Advocate Chauke. And counsel is saying, because you are in the same position, doesn't it then follows that if Advocate Chauke, who is in the same position as you, who is alleged to have done what you did in your report, should then make you to be in the same position, and therefore you should also be subjected to the disciplinary hearing? Because you supported and recommended on the decision on the matter that falls within the exclusive powers of the NDPP.
And you come from Cape Town.
And yet you come from Cape Town.
Once again says, I do understand we gave an opinion. We also made certain recommendations in respect of whether the application for racketeering authorization by Advocate Abrams is valid or not. Like I said, in terms of 3111 and 3112, I do not know the basis on which they are saying what is the evidence or information that they have where they said he supported a decision. I can speak to what we did in terms of our recommendations, but I cannot speak to what is in 3111 and 3112 as to why those charges were put.
No, Advocate Riley, it's very simple. I can tell you, it's very simple. They are saying Advocate Chauke is from Johannesburg. He's getting himself involved in matters that are in KZN. And he is exceeding the scope of his jurisdiction. He's violating the law. That's what they're saying. Advocate Batoi said this many times. I look at this report you've prepared. I see that the other two gentlemen are deceased. The two that remain is yourself and Advocate Tenga. Unfortunately, you are the only one who's testified here. That's why I'm putting to you that if it is misconduct to make a recommendation on a matter from KZN that falls within the exclusive power of the NDPP for Advocate Chauke, it is also misconduct to you. Should you now also receive your charge sheet? That's the simple question.
You indicated, and that's what I'm trying to indicate, what the evidence, on what basis they are saying he supported a decision in his capacity as the DPP. You now mentioned the fact it's because he was the DPP in South Gauteng and he tried to improperly have the acting director of public prosecutions, KZN, sign the case dockets or a prosecution memorandum. That's the basis. That's not an opinion. That's not an opinion. And I keep on saying, we were asked to provide an opinion and recommendations. That charge is different. And on what basis and what evidence they have to support that charge, I am not privy to it.
All right. So you would say the mere fact that he provided an opinion or supported a decision or made a recommendation on a matter that is from KZN, the so-called exceeding the jurisdiction charge, you would agree with that or not agree with that? I just want to get a clear answer because it seems to me you are similarly placed.
I'm not similarly placed.
All right.
As I indicated, the allegation against him that he sought to improperly have the acting director of public prosecution, KZN, sign the case dockets and or prosecution memorandum, I cannot speak to that. But that's very different from granting an opinion, reading dockets, and giving an opinion to the NDPP.
Yes, I see. So if it was only about granting an opinion and making a recommendation, that wouldn't be a charge, even if you came from a different jurisdiction.
That is correct.
Thank you very much.
It's very much different from somebody interfering, in my opinion, in the work of another DPP.
No, that's all I wanted to confirm. Thank you for that. Can we then move on to the next topic? If you go to your statement, particularly at paragraph 101.3, and it is a question that was raised by Advocate Baloymere SC.
It's one, sorry?
Paragraph 101.3 of your statement.
That is correct, yes.
Yes, now in this paragraph, it says, in Durban Central CAS 18502-2009, Pinetown CAS 1005-2009, Rustenburg 109809-2009, there was evidence that Bongani Mkhize was one of the orchestrators of the murder of Inkosi Zondi. The information was later confirmed by Swayo and Siphem Mhlongo, correct?
It is correct.
Yes. Now, you've given this statement under oath, is that correct?
That is correct.
Yes. Now, the question that was raised by Advocate Baloymere was that in 2009, 2010, there was a trial of Mr. Swayo and Mr. Mkhize. It started off with a bail application. Mr. Swayo was granted bail. He was shot and killed immediately after that bail. Mr. Mhlongo stood trial and he was acquitted. The evidence they gave, which implicated Mr. Bongani Mkhize, was obtained under torture. That was the evidence in that trial. We've got the full transcript before us. We played it before the panel. Mr. Zungu accepted that that evidence was obtained by torture. Now, I want to understand why, as the Deputy Director of Public Prosecutions, you are relying on information obtained under torture.
As I indicated when I was asked that question, I was aware of the judgment, but I wasn't aware of the information regarding the judgment.
No, you see,
I was aware that they were found not guilty.
no, you see, I cannot accept that because, firstly, this is information that has been in the public domain since 2010. You did your report in 2019. Secondly, this is evidence that was led in this inquiry only 3 weeks ago. You did your statement 2 days ago. But in your statement before this inquiry, you are still relying on information obtained under torture. That's what I want to ask you. Why are you intentionally relying on information obtained under torture as a lawyer?
Whether it was in the public domain or not, I wasn't aware of the evidence that was led during this inquiry. I work every day. I don't follow the proceedings every day. So I'm not aware that that evidence was led.
The evidence of Mr. Mhlongo was available already in 2019 when your entire team, which you claim did a thorough job, prepared its report. It was in the High Court. It was struck out because it was obtained under torture. So either you were grossly negligent in failing to follow up, or you were intentionally misleading.
The information was that there was a not guilty. I indicated that we were not privy or read the judgment. That I will concede in respect of that. And if you want to determine that was grossly negligent or that is your prerogative.
Yes, but how do you describe your failure in the light of your knowledge that the two were found not guilty? Your failure to find the judgment, to read the record, because it was all public knowledge. Even the acquittal of Mr. Mhlongo was reported in the newspapers. Even the allegations of torture were reported in the newspapers. So
And?
if it is not gross negligence on your part, how do you describe it?
Well, once again, that's your prerogative to call it gross negligence. I don't agree with you. I said to you, we were aware that they were found not guilty.
I'm asking the fact that this was all public, the fact that it didn't come to your attention. I'm saying I'm describing it as gross negligence. You say you don't agree. Give me the correct description of your failure to get information that's in the public knowledge.
We were aware that he was found not guilty.
All right. Now, can you
I
tell...
indicated to you, you're more than welcome to call it gross negligence, and I don't agree with you.
Yes. Can you tell me something else? It is the second time in this inquiry it has been brought to your attention that you have relied under oath on unconstitutionally obtained information, obtained under torture as if we are still under apartheid. Do you want to retract that part of your statement or not?
I will go read the judgment, and then we can return back to that.
No, I'm telling you now that the information was obtained under torture, and I'm asking you if you want to retract that paragraph or not.
I said I will go read the judgment, and once I've read it, and as a legal person, properly applied my mind to the judgment, I will then be in a position to give you a response.
So at the moment, you are not prepared to say information obtained under torture cannot be relied upon by the NPA.
I never said that. I said I will go read the judgment, and once I've read the judgment, we can come back to 101.3.
Yes, but I'm asking you a different question now, which is, are you prepared to accept that information obtained under torture cannot be relied upon by the NPA?
As a matter of
The
principle,
evidence during...
maybe put it this way, Advocate Riley. As a matter of principle, if it is correct, and it is correct because we have read the judgment of the court that the information was obtained under torture, and there were statements to that effect. Regrettably, you have not read the judgment, but it is a fact now that there is such information, that the statements obtained from these accused persons were obtained under torture, as a matter of principle, as a prosecutor, you cannot rely on information obtained under torture, correct? Because there's a judgment that says so. There are statements that say so, and the court has found that such information was obtained under torture. It's not a speculation. In that event, would you, as a prosecutor, rely on such information when the court has pronounced on its unreliability?
In respect of that, if a court has found that the evidence is unreliable or inadmissible...
The court, I can tell you now, the court has found that such information, having been obtained under torture, cannot be reliable.
That is correct.
Now, as a prosecutor, having that judgment, can you rely on information obtained under such circumstances?
No.
Thank you.
Thank you, Madam Chair. Just one more point on this topic then. I'm not going to repeat this. I think we've explored this enough. You admit that you were aware that this gentleman, well, the first gentleman, Mr. Swayam Kiza, was killed while he was on bail. The second gentleman, Spamandla Mhlongo, was acquitted. Then why rely on the confession that he made as to the killing of Mr. Bongani Mkhize when you know that he was acquitted?
There was evidence. Like I said, I did not read the judgment. So the fact that he was acquitted, if I've known that he was acquitted as a result of unconstitutionally obtained evidence, we would have revisited that decision.
Well, I suppose that takes us back to where we started, which is this was all publicly available information. So your point is that it is simply because you were not aware of the unconstitutionally obtained information that resulted in the Sections 174 discharge.
That is correct, it happens.
But doesn't that make your report entirely unreliable?
No.
I see.
Not entirely, that is incorrect to say that.
Well, your report in relation to these findings that we have explored, it is entirely unreliable.
Unreliable in respect of 1013?
Yes.
Yes, potentially.
Thank you very much. Can we then move on to the third topic? Now, you submitted to us earlier a list of dockets considered by the de Kock panel.
That is correct.
Yes. Now, that was a list you considered in 2019, correct?
That is correct.
There were 28 people that were killed, correct?
That is correct.
24 of those people had no warrants of arrest. Only 4 had warrants of arrest, correct?
That is correct.
Yes. All of them happened to be black African men, correct?
That is correct.
According to the evidence of Mr. Danikas, there was racism throughout the Keitomano unit. Did you ask yourself the question, why only Africans are being killed by this unit?
No.
I see.
I looked at the dockets, the evidence, and that was the decision that we had to make in terms of whether there was sufficient evidence. I did not look at the race of the person.
I'm asking you, oh yes, I see, the race, you didn't see that it was only Africans that were killed, I guess.
No, I did not say that. I said we did, when we made our decision in our dockets, we looked at the evidence.
I understand.
We did not look
I'm
at
asking
the
you
race.
a race question. Intentionally asking you a
I don't
race question.
understand how that's relevant. I
Because
explained to myself
I beg your
that I was
pardon,
looking
I
at
beg
the
your
evidence
pardon,
in the
I beg your
docket.
pardon, Advocate Riley. Please don't have an attitude. You are an advocate. You are well vested with procedures in court. You lead witnesses in court, you cross-examine witnesses in court, and you should observe the court decorum. We expect better from you. Please.
I apologize.
If you need to pause because you need to compose yourself, please ask so that we can give you a chance to pause. We all understand that cross-examination is not easy for anybody, but don't.
It's also late in the day, ma'am.
It's late.
Madam Chair?
It is late in the day. We started late. We had an opportunity to start early. Yesterday, we were made to wait the whole day because we were going to file a supplementary statement, which has never come forth. And we lost 1.5 days. And it is as a result of that that we have to sit until late. This delay cannot be put at the door of anybody except you. Because you made us wait when you had signed an affidavit over the Easter weekend, which we read, and we thought that we were going to start on time. But you said you are not available. You will only start on Tuesday after lunch. So we lost 1.5 days. That is why we are sitting until late, to make up for the lost time. If you need to pause, we are prepared to grant you the indulgence if you ask, but please answer the questions.
Thank you, Madam Chair. Advocate Riley, I'm not going to leave the question of race. I want to know whether you noticed that only Africans were being killed by this unit.
That is correct. I said it before that they were African males that were killed.
Yes, but you noticed that in 2019 when you did your evaluation.
That is correct.
Yes. Now, there are two witnesses. One was called here, the other was not called. The one that was called is Mr. Ari Danikas, who said that there was a racist pattern embedded in Keitomano, which included the use of the K word. Were you aware of that?
In his statement.
Yes, in his statement to this inquiry, yes.
That is correct, if it's in his statement.
Now, that's exactly the point I'm asking. You have a group primarily of white men, Van Tonder, Lockham, Mostert, Boysen, executing African men. Didn't this play a role in your evaluation about the possible explanation? The reason I ask you this is because Merity Haas wrote a letter to Advocate Batoyi and asked in the letter, if the deceased had been white, would you respond in such a careless fashion? She never got a response to that. And I ask myself this question, even to yourself. If the deceased had been a different race, would you be so nonchalant in the way you have dealt with them?
I don't agree with your term nonchalant. As I explained it on several occasions, We studied the docket. That is my role as a prosecutor, to look at the evidence in the docket. So I do not agree that it was done nonchalantly. I have submitted SR5. That is our work document in which we looked at each and every docket that were given to us, the 26 dockets. I can't respond to the letter that was sent to the NDPP.
Let me show to you why this was such a poorly executed job, that it shows that you didn't care about what you were doing. That's what nonchalant means. It means I don't care. You prepared a report in which you listed 22 dockets that you covered, correct?
In the report,
Yes, the report you gave us this morning, list of dockets considered by the DICOC panel.
can I just, are you referring to, just hold on. That is correct, yes.
Yes. Out of that, Captain Mangena appears 5 times. He appears on paragraph 6 under Durban Central, correct?
That is correct, yes.
Under item 10, Melmoth, correct?
That is correct, yes.
Under item 12, which is Phoenix.
That is correct, yes.
Under item 14, Eskaweni, the first Eskaweni.
That is correct, yes.
And then under item 16, the second Eskaweni. Correct?
That is correct, yes.
Yet, you knew that according to the evidence of Advocate Sean Abrams, Captain Mangena had done 19 reconstructions. Correct?
If I understood it correctly, yes, he did several reconstructions of the crime scenes.
No, he did 19 that were considered by Advocate Sean Abrams in the answering affidavit that you've referred to in your own statement.
I can't specifically remember, but I am not going to disagree if that's what the statements say.
Look at SR 0271. Paragraph 539.
That is correct, yes.
And that's where the number 19 comes from. Can you say that?
That is correct, yes.
Now, it is only a person who doesn't care about what they are doing who will pick 5 reports out of 19 for analysis. That's the point I'm making.
If 19, they were not all 19 dockets that form part of the indictment and the prosecution memorandum. If you can tell me that is what it is, the 19 out of the 26 dockets, then I will agree with you. But you need to be able to show me that there were reports. How many reports were in those dockets?
Well, this is exactly why we have included all of the reports in the cross-examination bundle, which you did not consider. I'll give you the names now of all of the reports that were in the dockets that you didn't consider.
We can go through those reports, and I will give you an indication whether that report was ever in that docket or not.
Well, I am telling you, we found them in the dockets. These were circulated to this panel.
In all the dockets,
Yes.
because I double-checked it against the dockets that were handed in at the inquiry, because that is exactly why I requested an opportunity to look at the Mangena reports, because if my recollection was correct at the time of 2019, there were not in each and every docket a report of Captain Mangena.
Let me tell you those where the reports were. Berea, case 288/05, 2008. It does not appear from your list.
I once again want to reiterate, if those reports were in the dockets as an A1 or an A5 or 94, then I will accept it. But I double-check, for example, the Berea case 288/5 of 2008, and I counter-checked it with the docket that was handed in at the inquiry. And I could not find that report at the docket handed in at the inquiry, and neither could I find that docket in the docket that was scanned and put on a disc and handed to the prosecutors, Advocate Chauke, Advocate Ivy Tenga, Mama Bola, and myself. There was no report filed in that docket. And we can go on to the other dockets.
Next
as well.
docket, Rustenburg, case 1090.
Before that, Counsel, Advocate Riley, look at number 9 in the list. Berea case 288/05/2008, ballistic report analyzed. And Counsel has just asked you about Berea, and your answer is inconsistent with the listed number 9. Berea, ballistic report analyzed. You remember why this list was provided?
I do remember. Can I respond, Madam Chair?
Yes, ma'am.
If I understand, if I look at the index to Advocate Riley cross-examination bundle, number 12 says Mangena report. I was under the impression that we're talking about the Mangena reports. And I said there was no Mangena report in the Berea case. I concur that there are affidavits of the forensic examiners that were analyzed, and that is in the report, that was in the docket, not a Mangena report.
Yes. Now, I want... Sorry, Madam Chair.
Counsel, I'm sorry.
Yes.
You did not have the ballistic report of Captain Mangena in the dockets as at the time you prepared your report?
That is correct. It was not filed as in the A section.
Yes. You said you wanted all of them. Let me continue listing them. You did another one for KwaDukuza, case 39/09/2008, not part of your report.
Yes, hold on. Let me just check.
Sorry, Advocate Ngcukaitobi, maybe as you call them out, because apparently they are filed under Section A. If you have the A number there, it would really assist.
They are in... Oh, well, Mr. Ramukhale says I'm holding his computer. All right, I'll give you your computer. Are you finished looking, Advocate Riley? There's another job we will do, which is looking for the A number, but I'm just giving you the reconstructions that have been presented to this panel of the dockets that don't appear in your own report?
You indicated the Quadcusa.
Yes.
Which case number is that?
3909-2008.
You're absolutely correct. There was no Mangena report, but I did make a note in my SR5 that, in fact, when I read these dockets, that docket specifically, there were no any other ballistic report in the docket.
Rustenburg.
I do say, Rustenburg?
Yes, case
Just hold on,
1097, stroke 09-2009.
Let's hold on. There was no report from Captain Mangena, except for a ballistic report of ballistic examiner vessels.
I understand that. Escort, case 3408-2008. The point is that these are not in your report, but they are in the answering affidavit prepared before you did your report.
They are not in the docket.
Well, this is where I am heading. Can we just finish the job? We've got 3 more to go. Escort, case 34/08/2008. Do you admit that that is not in your report?
Can you please just, can I ask the chair if the advocate can just give me an opportunity to actually go to that specific case number so I can double check my note as to whether there was a report or not.
Escort,
You're
case
going to-
3408-2008.
There was no Mangena report in that docket.
In the escort docket.
That is correct, yes.
Yes.
Kwamashu, case 314/11/2008. That's also not in your report.
You can have a look before you answer. We have 2 Kwamashus. Which one is that?
This is, Madam Chair, this is 314/11/2008. I'm coming back to this.
Is that the case number?
The case number is 314/11/2008. It's number 19 on the list of the witness. Thank you.
Thank you.
In that matter, similarly to other matters, and I double-checked it against the docket that was handed in at the inquiry, there was no report filed in the A section, B, or even C of that docket of Captain Mangena.
Pinetown, that's the last one. Pinetown case 1000/05/2009.
There was no report of Captain Mangena in that docket, and I double-checked it also with the docket that was handed in at the inquiry.
Yes. Thank you. Now, the point of this exercise is to show that at least 6 reports that have been presented here are missing from your analysis. According to Advocate Abrams, there were 19 in total, which you've attached. I do not understand why you didn't ask for them at the time you were doing your job.
If you can confirm that all 19 relate to the 28 dockets,
Well,
I will understand that. But if I looked at your list that you have also provided, there are many other dockets that did not form part of the 28 dockets. For example, number 28, Tokoza CAS 1766 of 2011. Docket did not form part of the 26 dockets. I can list you perhaps another example of another matter. Heidelberg CAS 8911 of 2010. That docket did not form part of the 28 dockets.
No, the 6 I read
Certainly,
are
don't
only taken
pop
from.
Yes.
Yes, the 6 I read are taken from the 23 only. They are taken directly from the indictment.
6, yes?
Sorry, I don't hear your answer.
Advocate
You,
Ngcukaitobi, you are exchanging information from some list. She's talking about Heidelberg, and where is that?
I think she is talking about the.
She says the list comes from you.
It is the index to the Riley cross-examination bundle. That's what she's talking about.
Where do we find that?
It's apparently here behind me. I apologize, Madam Chair. I had forgotten to ask that it should be distributed. So what the witness is talking about is from paragraph item 12. So that's where all of them appear up until item 29.
Yes, thank you.
Thank you. Now, Advocate Riley, I'm again not leaving this question because I need to get clear answers. I've just put to you that the 6 I read, I intentionally focused on those that are in the 23. Do you have any comment to that?
comment to you reading the 6.
Sorry?
I don't understand what you're saying. Sorry, can you repeat what you're saying?
You commented earlier, without being asked, that there are certain references to Captain Mangena's reports that are not part of the 23, correct?
I don't know the number, whether I said that. I just quoted which dockets we received, counter-checked against the dockets in the inquiry, and then whether we have a report of Captain Mangena. I don't have the exact number. I didn't count it.
No. Again, I am going to repeat this point because I don't want the record to be confused. You said, you read to me Thokoza, and you said that is an example of a report that does not form part of the indictment, correct?
That docket didn't form part of the 26 dockets, yes. That we studied.
Exactly. Now, I told you that the 6 I read out as missing from your report comes from the 23 dockets. That's the point I'm making to you. It's not any docket that is outside of the 23. That's what I'm putting to you.
I'm just trying to count which dockets we studied that had reports in.
Well, you gave us 5 out of the 22.
That is correct. That is correct, yes, 5.
Yes, now this is the point. There is a massive discrepancy. By the time you did this, you were aware that according to Advocate Abrams, there were 19 Captain Mangena crime reconstruction reports. You didn't ask for them. If I give you the benefit that when you opened the docket, you didn't find it, you didn't ask for them, but you knew they existed. Can you explain yourself?
Now, I keep on asking, please, can you answer this? Are you saying that the 19 relates to the 26 dockets?
This is what Advocate Abraham says. Let's go back to that paragraph because I don't want the impression that, no, the witness didn't understand. You perfectly understand what I'm saying. We go back to SR 0271.
That is correct, yes, if he refers to the 26 docket.
No, 23 cases which are in the indictment. And out of those, at 539, he then talks about 19 crime scene reconstructions.
That is correct.
That's why I'm asking you the question. I'm still expecting an answer. Why did you not ask for the copies of these reports which you knew existed and come from the 23?
As I indicated, we did ask Advocate Mahema for all the relevant evidence. If it was not in a docket, one would have expected him to have provided us with it because it was definitely not even mentioned in the C section of the docket.
You see, the problem is that we've got all of the exchange because it's attached to a statement that you had with Advocate Mahema. If you could take us there and show us the request for the Mangena crime scene reconstructions, that would be very helpful.
It doesn't mention Mangena's report, that I will concede. What it does mention is that the prosecutor should provide us with all the evidence that he considered in respect of his indictment as well as prosecution memorandum.
All right, can you take us there? So show us where the request is made.
The communications was with between Advocate Chauke and it's SR 1081.
1081. Let's go there.
That is correct, yes.
So show us the request.
So I think the initial email was between Advocate Chauke and Advocate McAdam. He starts off by saying, I was advised by Danny Smith that you will be leading the panel. I'm trying to get all the material together, which is proving quite a challenge. Then he says, he explains further in the email how he's trying to obtain the files, the memos, and he also asked the DPP KZN for her files as the case is being conducted under her name.
No, sorry, Advocate Riley. I just want us to do this job easy. You've said that Advocate Chauke wrote an email to Advocate Mangena in which he asked for all of the dockets. Just take us to that email.
I said, not all the dockets. I said, you are misconstruing my words. I did not say Advocate Chauke wrote to Advocate Mahema.
Well, I thought that's what you said.
What did you say?
We say, sorry, ma'am?
What did you say?
I said we tried to obtain all the relevant evidence, which included the dockets, to consider our decision on. That's what I said.
And you refer to the communication between Advocate Chauke and Mr. Mahema.
I didn't say that there was communication between Advocate de Kock and Advocate Mahema.
You see, we are writing notes here. You are not taking notes of what you are saying. That's why I'm looking at my notes and I'm asking you a question. The communication that you were referring to earlier between Advocate de Kock and Mr. Mahema, and then you mentioned the emails, at least in accordance with my recording or my writing. And the counsel is asking you, take us to the email.
What I meant was that there was, on the part of Advocate de Kock, we were seeking all the information, all the dockets, as well as all the files. That communication, and I apologize if it came across that I said that Advocate de Kock personally communicated with Advocate Mahema. That communication was primarily between Chris McAdam as well as Danny Smith. And that is what those emails referred to as Annexure 4 to my affidavit.
All right. So, in other words, there is no communication from Advocate de Kock to Advocate Mahema asking either for the Mangena reports or all of the dockets, correct?
Not between Advocate de Kock and Advocate Mahema. That I will agree with.
Yes.
But there are other communications between Advocate de Kock, Advocate McAdam, as well as Advocate Sibongile Mazinyati, where they explain that they have spoken to Advocate Mahema to specifically inquire about his alleged non-cooperation. He said he was unaware of the mentioned non-cooperation. He said he gave McAdam the original documents of all the dockets and documents and file is in his possession. He spoke to Advocate McAdam yesterday. He will give him the presentations that were made to the previous NDPP as part of the motivations for the racketeering authorization.
Yes. Now, the reason why this question is important is not simply to catch you out. It's because Advocate Mahema was the leader of the prosecution team. What he testified in this inquiry, he expected, is that he would be called in by your panel to explain the evidence they worked on, to explain the logic of their thinking, to explain their strategy. But that opportunity was never given. That's why I was curious to see the communication between the chair of your panel and the head of the prosecution team, which I cannot find.
I'm doubtful whether there is such communications between the chair of the panel, Advocate de Kock, and Advocate Mahema. I only aware of one email or one or two emails where Advocate Mahema responds to Chris McAdam and he will copy in Advocate de Kock regarding some of the information that was required, for example, the Danikas statement.
Yes, I understand that. I don't know if you want me to repeat my question. But I guess you've already said I will not find what I'm looking for because it doesn't exist.
Yes, I agree with you.
All right,
there
thank
would
you.
be no communications between Advocate de Kock and Mahema.
Yes, thank you very much. Now, we have finished the analysis I wanted to make of comparing your report versus the existing objective information and that you did not request. I want to move on then to my fourth topic.
Okay, Nkcukaitobi, we will pause at 8 o'clock.
Yes, Madam Chair, I think I can, yes, 8 minutes will be sufficient to cover this topic. Thank you. Advocate Riley, I want to ask you to look at the provisions of POCA, which you will find in the cross-examination bundle at page 275 and 276. You let us know if you are struggling to do that. It's extracts, not the full section.
I'm just asking Advocate Legeto to assist me.
Yes, that's fine. Thank you
Yes,
very much.
you can do that.
Yes, I'm at 275, page 275.
Yes, if you are at 275, I want to ask you to turn your attention to a pattern of racketeering activity, the definition. Can you see that?
That is correct, yes.
Means the planned, ongoing, continuous, or repeated participation or involvement in any offense referred to in Schedule 1. And it includes at least 2 offenses referred to in Schedule 1, of which one of the offenses occurred after the commencement of this act, correct?
That is correct.
So what is required here is the planning, the ongoing, continuous, or repeated participation in the offenses referred to in Schedule 1, correct?
That is correct, yes.
Yes. There is no provision here that says that your participation in those offenses must have been for reward, correct?
Just repeat that, please. I didn't hear properly the last part.
There is no requirement that the participation of the alleged offender must have been for reward, correct?
Must have been?
For reward, for payment, for profit.
Okay, yes, that is correct, yes.
If I can then ask you to turn your attention to the indictment itself, particularly under the heading Summary of Substantial Facts. You will find the indictment at 1078, which is item 30.
It's 1078 of what?
1078 of the cross-examination bundle, Madam Chair. Yes, thank you.
You want me to turn to the summary of substantial facts?
Yes.
Which page is that?
It is at page 1157.
That is correct, yes.
Yes, if you turn over the page to 1158.
That is correct, yes.
Now, if we read together paragraph 2, the way the indictment describes the pattern of racketeering activity, it says, the unlawful activities of the enterprise began to manifest themselves in May 2008 to September 2011 through a pattern of racketeering activities, full stop. They killed members of KwaMaphumulo Taxi Association, which was in conflict with the Stenga Taxi Association, ordinary civilians, and or suspects and criminal gangs suspected of ATM bombings, correct?
That is correct, yes.
Do you admit that that section does not refer to killing for profit?
That is correct.
Yes. In other words, consistent with the definition of a pattern of racketeering activity, what we go to this issue of an enterprise. Now, what I want to ask you about an enterprise is firstly to take you to a judgment of the Supreme Court of Appeal, which is in item 8 of the cross-examination bundle index at page 295. Do you have the judgment called ASEN versus S?
That is correct.
Now, if I can ask you, please, to go to the I think it's the last. It's the definition of I think it's paragraph 6, but I'm looking for the page where paragraph 6 appears. Yes, yes, page 298, paragraph 6. Do you have that?
Just reading, just hold on. Page, what page?
298, paragraph 6 of the judgment.
Okay, it says the word enterprise, yes?
Yes, exactly. Now, firstly, it extracts the definition of an enterprise from the Act. We don't have to read that. We can see it, both of us, correct?
That is correct, yes.
I want to take you towards the end of that sentence. It is 1, 2, 3, 4, 5. The fifth line from the bottom that says there is no requirement. Can you see that?
That is correct, yes.
It says there is no requirement that the enterprise be legal or that it be illegal. Can you see that?
That is correct, yes. I see it.
So the enterprise itself can be a lawful organization. It is not necessary that the enterprise must be an unlawful organization, correct?
That is correct.
Yes. The unlawfulness is introduced in the second element, which is the pattern itself. And that is what the judgment says. It says, it is the pattern of racketeering activity through which the accused must participate in the affairs of the enterprise that brings in the illegal element, correct?
That is correct.
Yes, thank you very much. Now, I think you and I are completely ad idem on the meaning of an enterprise and the meaning of a racketeering activity, correct?
That is correct. That is correct.
Thank you. Madam Chair, it's 8 o'clock, so we may take the adjournment.
Yes, thank you. As I said earlier, you should all assemble in chambers. As we take a break, we will reconvene after, say, 30 minutes. If you can come to chambers, and we will come back. Advocate Riley.
Yes, ma'am.
We are going to pause for 30 minutes and we'll reconvene at 8:30.
Thank you, ma'am. I confirm.
Yes, thank you. You are still under oath, by the way.
I confirm that.
Thank you very much. Good evening, everyone. Good evening, Advocate Chauke. Advocate Riley.
Good evening, ma'am.
Let me just apologize to all of you that we are taking a little bit more of a time that we didn't anticipate, but we won't be too long hereafter. Hopefully we will finish not before long.
Yes.
Thank you. Advocate Riley, you are still under oath, madam?
I confirm.
Yes, thank you. Advocate Ngcukaitobi.
Thank you, Madam
please.
Chair. Advocate Riley, before the adjournment, we had finalized conceptually the definition of a pattern of racketeering activity and the definition of an enterprise. We had also looked at the charge sheet or the indictment in relation to how it conceptualizes the pattern of a racketeering activity. You confirm that?
That is correct, yes.
Now, I just want to finalize that part by looking at how it describes the enterprise itself. You will find that at 1157 of the cross-examination bundle.
Please repeat that, Counsel.
Page 1157, Madam Chair, of the
1157.
cross-examination bundle, yes, under the heading Summary of Substantial Facts in the Indictment.
Okay, he's back.
Have you found it, Advocate Riley?
I have Advocate Ngcukaitobi.
Thank you. Now, if we look at paragraph 1, the South African Police Service is a legal entity established by legislation in terms of the South African Police Service Act, number 68 of 1995. It is composed of a national office and provincial structures for each province. So you can ignore all of that because that's not the enterprise. But the next sentence is the enterprise. The serious violent crime section, based at Kaitomano, was a section within the Durban Organized Crime Unit, which formed part of the KZN provincial organized crime structures and was therefore an enterprise as defined in the Act. Now, that must be correct in the light of what we discussed, that it would be permissible for the prosecutors to say the serious violent crime section based at Kaitomano, which is part of organized crime, is an enterprise, correct?
That is correct, yes.
Yes, all right. Thank you very much. Now, that takes us then to the two additional elements of this charge. Those are the elements of management and participation. We start off with the management part, which is at page 1158, how the indictment saw the management. Firstly, at paragraph 4, it says, the state alleges that the accused knew or ought to have known that the unlawful activities were against the provisions of Section 205 of the Constitution, South African Police Service Act, and Part 3 of Standing Order 251.6.1 and Common Law. Now, that is talking about participation. Would you accept that? Because it's all of the accused.
Participation or Section 21 if you knew or ought to have known?
No, they are saying it's all of the accused that participated in those activities, but they did so knowing full well that those activities are unlawful. Correct?
Okay, they said yes, they knew or ought to have known the activities were unlawful.
Correct, yes. In other words, they participated in those patterns, and the pattern is limited to the killings. Correct?
Correct, yes.
Now, then we come to another element, which is the management element, which you've agreed with Mr. Matoni that depends on knowledge of the unlawfulness. That you will find at paragraph 5. It's limited to the managers. Can you see that? 1, 6, 9, 15, and 16. And you know who they are: Mr. Boyzin, Mr. Olivier, Mr. Eva, Mr. Van Tonder, and Mr. Lockham. Those are the managers, according to the indictment. Now, the way they are accused is that they knew or ought to have known that their subordinates were engaged in ongoing and continuous commission of unlawful activities as mentioned in the predicate offenses. And this would be permissible to charge a manager who knows that their subordinates are engaged in a pattern of racketeering activities, as themselves being implicated in the pattern of racketeering activities, correct?
That is correct, yes.
Yes. Now, I know that you have raised an issue about the extent to which the indictment clarifies why these 5 have been chosen as managers. You remember that?
That is correct, yes.
And specifically, you have said you cannot merely duplicate the official title into a pattern. You have to show that there are some facts of the role that you played in the activities of the enterprise, correct? A management role you played in the unlawful activities of the enterprise, correct?
That is correct.
That's been your
yes.
argument, yes. Now, I want to deal with that now, this is now topic 5. Did you consider the reply to the request for further particulars? It is a lengthy document. It's 1,052 pages long. And it's not referenced at all in your report, nor is it even referenced in your statement. Now, that document starts, if you look at the index we gave, it starts at page, it's item 31, starting at page 1,230 to 2,249. Did you actually ever read that document at all?
I'm just asking the advocate to assist me so I can just confirm whether I've read it or not.
1230.
That is correct, yes.
It's various parts. There's 5.1. Oh, that's okay. Very good. What?
Is it in your bundle volume 3?
Let me check.
Because I don't have.
Oh, no, Madam Chair. It's volume 4, 5, and 6. Sorry, it's volume 4, 5, and 6. Yes. Now, what happened, Advocate Riley, just to put you in perspective, after the indictment was served in August of 2012, the evidence shows that Major General Boyzin and the others submitted a lengthy request for further particulars. That was then responded to in this was a further request.
Give us a chance.
Oh, sorry, Madam Chair.
We have 1230.
Yes, 1,200. Yes, 1230. Yes,
Yes.
that's where it starts.
This is a request for further particulars.
This is the request for further. Well, this is a response. No, actually, the chair is right. It says further particulars request of the accused.
Yes.
Yes.
At 1231.
Yes, at 1231. Yes. Now, this document is 1,052 pages long. The question to you is, did you actually read this document at all?
I can confirm that the panel never read this document.
Never read it.
That is correct, yes.
Yes, you see, Now, that is an extraordinary confession because a response to further particulars is part and parcel of the indictment. Correct?
That's correct, yes.
Now, if you have not read it, then it means your analysis is so deficient that it has no value because you did not read the full indictment.
Of what was said in respect of the further particulars.
Correct. Now, this is the reason I'm asking is that as a matter of law, a response to a request for further particulars is regarded to be part of the indictment. When you admit that you didn't read it, you didn't read 1,052 pages. What I'm putting to you, you can say I'm wrong. I'm happy for you to say that. Is that your analysis that you gave to Advocate Batoyi was so deficient that it had no value because you did not read the full indictment?
Let's correct something here, Counsel. At 1231, the bolded words in the tramlines seek to suggest that this was a request for further particulars. When you read the body of that document, please kindly take notice that the state hereby furnishes the following further particulars, which means it is a response indeed.
Yes, correct.
But the words in the tramlines are misleading.
Yes, no, they are. I was just saying you read it correctly, but because we knew what it is, then we said, no, it's a response. But we were wrong.
Yes.
Thank you, Madam Chair. So, Advocate Riley, I've put to you the proposition that your entire report, together with your statement, are so worthless because you did not read the full indictment. 1,052 pages of the indictment were never read by the 4 advocates that were asked by Advocate Batoyi.
My response to that question or submission will be that a request for further particulars and a response thereto emanates from what is in the dockets.
Yes?
It's the evidence in the dockets. They respond in terms of the evidence in the dockets.
Yes?
That is correct. So it's not additional information or extra information that was not made available to the panel.
Yes, I'm not talking about the docket. I am talking about the indictment. Because your report goes on about criticizing the indictment. But I'm saying that criticism of the indictment is deficient because it does not have access to the full indictment.
And the response to further particulars?
That is what I'm talking about.
It would refer to the content of the dockets.
How does that answer my...
As your charge sheet, sorry, I didn't mean to break your word, as with the charge sheet, your charge sheet ordinarily would not contain each and every piece of evidence that is in your docket. And if I understand it, a request for further particulars is for the defense to request more information on the charges of the indictment. So your request for further particulars and your response thereto, every response thereto will emanate from the evidence in the docket. You cannot have anything else other than that.
Yes, I don't think, I'm going to ask you for the last time. Your criticism of the deficiencies in the indictment were themselves deficient because they did not read the full indictment, because the response to a request for further particulars is part of the indictment.
I do not agree,
Yes.
and for the reasons that I've stated.
Now, if you actually go to the portion I wanted to take you to, which is you go on in your report challenging the indictment because it does not sufficiently flesh out the management role of accused 1, 6, 9, 15, and 16, Boysen, Mr. Major General Boysen, Captain Olivier, Captain Eva, Captain Lockham, and Captain Van Tonder. Captain Eva is no more. 4 are remaining. But if you had actually read the response to the request for further particulars, you would have got all of the information. Let me show you where it appears. Start at 1332.
Yes, I'm there.
If you are at 1332, you will see paragraph 5.1.
That is correct, yes.
And the defense asked, why are you saying these people are managing the enterprise? Precisely the question that was raised in your report. The state answered, yes, accused 16 managed the activities of the enterprise together with accused 1, 6, and 16, who were the co-managers of the enterprise. Whenever any of them would not be at that particular scene, the most senior member would fulfill that management role. In count 8, accused 4 had more information from his informer and then shared it in the briefing with other members at Pietermaritzburg before they set on tracking Magojela and Tembe. Accused 8 was a passenger in pursuit car 1, driven by accused 4. Accused 9, 15, and 16 created an environment where other members of the enterprise could function to advance the objectives of the enterprise. So here is your first answer. We have charged these people as managers because their job was to create an environment for the fulfillment of the unlawful activities by the other members. Now they explain why they say that. Sorry?
I said I still have to find out where that evidence is.
I understand
that they
but
indicate that there was no evidence in a docket of that nature where the senior management would fulfill that management role.
well,
There was no evidence in any of the docket where accused 9, 15, or 16 created an environment where other members of the enterprise could function to advance the objective of the enterprise. If I've come across a statement of that nature, I would be able to tell you that.
all right, well, let's carry on. 5.2. Accused 9, 15, and 16 created an environment in which the activities of the enterprise could take place by giving his members access to resources without engaging the unit commander, knowing that he has the blessings of the provincial commander. So there is your evidence. Major General Boysen skipped the unit commander to provide resources to the members. And I can show you now where the documents are.
All I'm saying is there's no statement to that effect. That if that is a reliance primarily on Colonel Aya's statement, and we have discussed the reason why we say why we do not believe that it will muster
No.
Colonel Aya.
Yes, no, I know
There's
that.
no evidence to that effect.
No, I
So
know that.
I would still.
Carry on, finish.
Sorry, can I just repeat? So
Yeah.
I would just say there was no evidence or no statement to that effect, and you can't read it into Colonel Aya's statement
Yes.
that he was giving that Boysen was giving access to resources.
No, we will
Because he was the unit commander in any case.
We will
commander.
go through the underlying evidence. I know that you are criticizing Colonel Aya, but what you can never say is that there is no evidence. You can say that I don't like the evidence, but you can never say there is no evidence. You will just be blind to the facts. I'll come back then to 5.1. 5.21, the enterprise remains the same and continues to be the same in all of its activities. In this incident, now this is the incident of the killing of Mr. Magojela, Nkabinde, as well as Sibusiso Tembe. The accused persons who participated in the enterprise are accused 1, 4, 5, 6, 8, 9, 15, and 16. They continue. Accused 4 ensured that all the participants are briefed and updated as to the latest information regarding to the movements of the suspect. He was the driver of the pursuit car number 1, the silver BMW. He pulled his vehicle alongside that of the deceased while his companions were firing shots at the deceased. And when the deceased vehicle came to a standstill, he went closer to the driver's door and fired shots towards the driver at close range. Again, you've been told that this was his role, briefings and updates as to the latest information regarding the movements of the suspect. Accused 9,
That's
15,
normal
and
police
16.
work.
Sorry?
That's normal police work in terms of if you are going to try and track and trace a suspect, there's communication between the police officers regarding and the sharing of information. Unless you can provide me with a report from inside where somebody said that is what happened regarding accused number 4, Mostert, giving information that does not relate to the tracking and tracing of that suspect, then I will accept it. But for me, it's the police has to share information.
Yes, but what
And
is...
that doesn't mean, sorry, let me just repeat, but that doesn't mean that that necessarily amounts to an unlawful act on his part or show that he was part of management or part of the illegally gave information.
Shouldn't you wait for counsel to take you where he wants to take you, madam? Because you earlier answered that there is no evidence. Maybe you should wait for him instead of giving a long answer. Let him give you the evidence that you said does not exist, and you can take it from there. And if you can answer briefly to the questions, please.
Yes, thank you, Madam Chair. Now, if you go further down in that statement, I'm still explaining to you how the indictment described the leadership role or the management role. At 1334, 5.6.1, it says the work and functions of each person employed by the enterprise or associated with the enterprise can be summarized as follows. Accused 5, Eric Nell was part of pursuit car, fired shots in the direction of the Hyundai with his R1 after the vehicle came to a standstill. He secured the scene. Accused 2, Pumelela Makanya, was part of the pursuit car and also fired shots in the direction of the Hyundai. Now, I would admit that those are the shooters. Those are the people that execute. Accused 15, Anton Leckham, was the driver of the pursuit car, the gold Toyota Corolla police vehicle with registration number ND309345, and was driving behind the silver BMW driven by accused 4. So here he is described as an enabler of the shooters. Accused 16, Eugene van Tonder, was part of pursuit car 2 and fired about 7 shots towards the Hyundai with his R5 rifle. Boysen supplied information on Magojela's whereabouts to Paul Mostert and arranged the helicopter flight after Magojela was located on the N3 highway, where he landed immediately after the shooting. Olivier accompanied Boysen in the helicopter and alighted at the scene. Accused 4 managed the tracing, and ultimate shooting of the deceased, Magojela and Tembe. He started when he instructed the owner of the VIP protection that was providing security services to the KwaMaphumulo to remove their securities from their members. Now, you've been told what each what each member is doing and what the managers are doing in providing an enabling environment. Now you say, well, show me the evidence. Let's do that now. Firstly, I want you to look at page 2250, item 32.
Page?
2250. In volume 6, Madam Chair. Now, you've seen this document before, correct?
I'm still waiting on the document.
Oh, I see.
For the record, you can tell us what the document is?
The document is a letter headed Monetary Rewards, dated the 15th, I think 16th of October 2008, signed by Director Boyson, JW, addressed to Assistant Commissioner P.T. Brown of the Detective Services, KwaZulu-Natal.
I think this is the same document that I earlier on referred the witness to, and she read the entire
Yes.
document into the record.
Thank you, Madam Chair.
You remember, Advocate Riley, I referred you to this document earlier from a different bundle, I suppose, but the contents are the same, and you read from paragraph 1 to paragraph 7. Do you remember?
I remember, Madam Chair.
Has it been placed before you again?
I am looking at it now.
Yes.
Yes. Now, there are two things I want to explore with you about this. Remember that I've taken you to the response to the request for further particulars, which says Major General Boyson's primary role was to enable the commission of the offenses that form part of the pattern of racketeering activity. In other words, the killings, correct?
That is what you allege, yes? What's in the papers, yes?
I don't allege anything. That is what is in the response to the request for further particulars.
That is correct, yes?
Yes. Now, in that role, he says the solving of this case was widely reported and applauded by the media and public alike. It most surely restored faith and confidence in the SAPS to deal with ruthless killings. So the first thing he is doing is to praise and reinforce the conduct of the police who were involved in that operation, correct?
Yes, he praised him.
Yes. The next thing he does is in paragraph 7. Not only does he praise and reinforce them, he also offers them money, correct?
He makes the recommendation, yes, that they be rewarded.
That they be given money. Yes.
That is, he makes that recommendation, yes, I agree.
Now, you would agree that that role is completely compatible with the role of enabling a person to perform a function, whether the function is lawful or unlawful. But that is a role of enabling the performance of a function.
If he believes that it was unlawfully done, then I will agree with you. But if he believes that it wasn't unlawfully done, then it's simply a commander that is recommending his members to be rewarded.
I've not asked you about whether he believes it was unlawful or not. And we were doing well so far when you answered the questions. Once you introduce your own things, we're going to be here until 12 midnight. The only question I'm putting to you is this. This function of praising a member and recommending their reward is compatible with enabling them to perform a function.
I disagree with you, and I will say it for the same reasons that I can understand. There's two aspects here. The one is, if you believe or you knew that they were committing crime and he still recommends them, then I will agree that it's you're right in terms of that. But if it's not, if he believes that they were not committing crime, it's then simply the recommendation of members to be rewarded for cash.
Yes, but let us assume he did not believe they were committing a crime. He is still enabling them to perform their functions.
Their functions, their normal functions, yes.
Yes. Now, the question here then is whether or not he had enough evidence that this was commission of a crime. Is that correct?
That is correct, yes.
Now, we then go to the next document, which is 2251. Can you see that? Can you see that document? The next
Just
page.
hold on. Yes, yes.
Now, this is a document entitled Monetary and Non-Monetary Awards for the attention of Director Boysen, who is the Provincial Commander of Organized Crime in KwaZulu-Natal, correct? Is that correct?
I'm reading. That is correct, yes.
Yes, and the candidates to be rewarded, the first candidate is Director Boysen, correct?
That is correct, yes.
And they are all rewarded for allegedly solving the Mapumulo case, correct?
That is correct, yes.
Now, how did that happen? How did they solve the Mapumulo case? You go to the following page, which is page 2253. Correct?
I'm going there. I'm there.
And then under paragraph 3, they talk about the apprehension of 2 more suspects, correct?
That is correct, yes.
Now, we know that that is false. Those alleged suspects were not apprehended, they were killed. Is that correct?
That is correct, yes.
Now, under the summary of events, the first person who passed on the information and started off the entire operation is who?
Director Boysen or Major General Boysen.
Exactly. Now, look at how they describe then what happened at the actual scene. Page 2254. I want to read this because it's a very, very, very important passage. It says, the investigation team, that's the second sentence, which at this stage consisted of Inspector Mostert, Nell, and Makanya in one vehicle, while Captain Van Tonder, Lockham, and Eva, whom followed in a separate vehicle. Inspector Mostert managed to catch up to the vehicle, and in an attempt to get the suspects to pull over, the official blue light and the siren was used. A shootout then took place between the passenger of the suspect's vehicle and the investigation team, resulting in the driver of the vehicle being injured in the process, which resulted in the vehicle stopping. Do you admit that there is no statement there that says that the people inside the vehicle shot at the police first?
That is correct. I simply refer to a shootout between the passengers of the suspect's vehicle and the investigating team.
Yes,
They don't specify as to who shot first or
No, I
that is
understand
correct.
that, but again, that's not my question. My question is there is nothing there that says the suspects, the alleged suspects, shot at the police first.
My understanding, a reading of a shootout then took place between the passenger of the suspect's vehicle and the investigating team. My understanding is there's a to and fro shootout between the suspect's vehicle and the investigating team.
All right, I'll ask you for the third time. If you don't want to answer, just tell me. There is no sentence there that says the suspects of the inside the vehicle shot at the police first.
Not first, yes, I agree with you.
All right, thank you, finally. Then we move on. Inspector Mostert, sorry, I've read that already. Yes, we move on. It says, the passengers, now the vehicle has stopped. That's the vehicle of the so-called suspects. The passenger in the suspect's vehicle during the shootout made an attempt to flee from the moving vehicle, which resulted in him being flung out of the moving vehicle. So next thing that is important is that the passenger is running away, is fleeing, correct?
There's an attempt to flee, yes, I agree.
Yes. Well, there's nothing called an attempt to flee. You are either running away or standing. So he is running away. Now,
I don't read that.
Sorry?
I don't read it. There was an attempt to flee. So I don't know what the attempt to flee means.
Yes, well, okay.
Do
Let's work on your assumption.
But you can read the whole sentence.
Yes.
Because it says that it resulted in him being flung out of the moving vehicle.
So, Advocate Riley, we have a suspect, so-called suspect, who's a passenger. He attempts to flee, which means he tries to get out of the vehicle so that he could flee. But unfortunately, he gets flung out of the vehicle, correct?
That is correct.
Yes. So what we are dealing with, which is the second part, is a fleeing suspect, or a suspect who is attempting to flee. Look what they say happens next. Both the suspects were fatally injured in the shootout. The driver was positively identified as Timson Nkabinde. We've read this throughout. There is not a single reference that Mr. Nkabinde ever attempted to shoot at the police. If you can find it, show me.
In this passage?
Yes, this is the passage that is describing what happened.
No, they don't. In the passage that is describing, they're not saying that he fired at him.
Yes, the first
they
time.
They simply refer to a shootout.
Yes, the first time we hear his name is when he is fatally shot.
That is correct?
Yes. And then we talk about the passenger. The passenger is also fatally shot when he is attempting to flee. Is that correct?
That is correct, yes.
Now, this is the whole point then. You can read the rest of that. The driver was positively identified as Timson Nkabinde and was the main brain behind the assassination of Superintendent Chauke. The other suspect was his bodyguard. In both of these killings, at the time this was made already in 2008. There is absolutely nothing in this letter that shows that the police were under threat. That shows that the police were being shot at. That shows that the police had no other alternatives but to kill these suspects. What we have is the most extraordinary thing of killing a fleeing suspect, which I would submit to you is clearly illegal.
On what you're interpreting in the submissions for a reward.
Well,
No. Advocate Riley, please just confine yourself to the question, please.
Do you want me to repeat, perhaps?
Madam Chair, my question still remains. There's evidence in a docket, and then there is...
It's not your question. You are not asking questions, madam. You are answering questions. I'm saying to you, try to confine your answers to the questions that are posed to you. Counsel, just repeat the question.
Should I repeat, Advocate Riley?
Yes, please repeat.
Thank you, Madam Chair. Advocate Riley, I am putting to you a simple proposition. On this document, the police shot a fleeing suspect or a suspect that was attempting to flee and was flung out of the vehicle. They shot Mr. Nkabinde without any reference to how he posed any threat to them. That's why I've said to you, this is very important. Let's go through it together. Correct?
On this paragraph?
Yes, on this document as a whole.
How it's described. I will agree with you. And that is and I still say, we worked with what is the evidence in the docket.
I'm
Not
not
this.
asking on what you worked on. That's not my question. I am reading to you the document because I'm going somewhere else, not where you think I'm going.
That is correct, if based on the document, yes.
Precisely. And then we go back to where the document starts. Major General Boysen rewards these officers on the strength of this document. Remember the reward I started with of 10,000 rands, which is page 2250. And not only does he reward them, he himself benefits from them, from the reward. Now, this is in circumstances, they sit there in the office, they're paying themselves money. They have a document that shows clearly that a fleeing suspect was shot, and Mr. Nkabinde, who posed no threat to them, was shot and killed. You want to seriously tell me that Major General Boysen did not know that this was illegal at the time he took the money and he approved the money for the others?
I don't know, what am I supposed to say in terms of this document? This document is not the evidence in the docket.
I am not talking about the docket. You remember what we are talking about. We are talking about an enabler of unlawful activities being Major General Boysen. You kept on saying, show me the evidence. I told you that, wait, I'll show you the evidence. I've now shown you
This
the
is not
evidence.
evidence.
You are shifting the goalpost now, talking about the dockets. Here is the evidence. It's direct, original evidence.
A letter for the rewards is not the evidence. That is different from the evidence in the docket. How people write up their reports, that cannot be, that must be compared with what you have in the docket.
Well, this is even stronger than witness statements prepared after the event, because this one is authored by the very same people at the time, even before they knew there was an investigation. So this is the most honest account of what happened. Signed by Major General Boysen, supported by all of these other officers who got it. Now, you've shifted the goalpost again. Oh, no, it's not evidence.
Because I work on what's in the docket and what is a docket says in terms of the evidence.
Did you realize?
I cannot agree with you. I'm sorry, can I just continue? I cannot agree with you. I cannot agree with you that a summary or a summary of what was transpired there in a document for rewards is either similar or better evidence than what is in the docket.
I understand that. I am not talking about the docket. I'm simply talking about Major General Boysen enabling the commission of crimes because he knows when he reads this letter that something wrong has happened here. Because the first thing he must ask himself, why did you gentlemen shoot a fleeing suspect? But no, he approves the payment, he pays himself as well.
Do you have any comment, Advocate Riley?
I don't agree with the submission by Advocate.
All right, thank you. Now you've got another point you've made. You are saying this was this information was not in the docket. Are you serious about that?
I never said this information was not in the docket. Are you talking about the paragraph that you read out?
Yes.
I never said that.
All right. I thought you said that you didn't work on a letter. You worked on what was in the docket. But you admit
That is
that this
correct,
document
yes.
was in the docket.
This document pertaining to the rewards was in a docket. Yes, it was in Durban Central, 85. That's
you.
where I read this docket, all the statements in respect of the rewards.
Thank you very much. And what I found striking is despite your claim that you were very diligent, you never actually engaged with what I have read to you in your summary, including in your SR5.
No, I didn't.
Yes, thank you very much. Now, you know why we ended up on this route is because you refused to accept the submission I made that the indictment, when it is read together with the response to further particulars, places Mr. Boysen at the center of conceiving, strategizing, managing the commission of these crimes. And it is a lie that he came after the event. He was there at the beginning. Do you have any comment on that?
At which event, sir?
The killing, we're talking about one event, please. It is the killing of Mr. Ndimande and the killing of Mr. Tembe, because that's the crime that he is charged with under the racketeering offenses. It's those two murders. I'm saying to you, it is a lie that Major General Boysen came after the event. He was there at the beginning, he oversaw it, and then he came afterwards, and then he wrote a letter to congratulate the members and then to motivate for their payment.
We could not find any evidence to that effect in any of the dockets, in particular the Howick docket.
Yes, well, because you decided to ignore the existing evidence.
The evidence in the docket?
Yes.
Where there was no evidence that he was on the Howick scene before the time, or that he engaged with people. If it was done in the course of his duty as a police officer. There's no evidence from any witness that said that he engaged with him other than knowing that they are tracking and tracing certain suspects.
Well, you know what? I first accused Major General Boysen of lying. I'm going to accuse you of doing the same thing. How can you say that the only offense of Major General Boysen is knowing that these people are looking for the suspect, when we have just read the original letter that says he is the one who got information from an informer and passed the information to Mr. Mostert?
That is correct. But that is exactly what I said. If he was not on the crime scene, and if he provided any information regarding the tracking and tracing of a suspect or handed over that information, it was part of his duties as a commander or another police officer. Because I thought we also agreed that my submission was that I understand that that is the manner in which the police operate.
Yes. Advocate Ngcukaitobi, I'm sorry, I really tried not to interfere or interpose, but I have to ask this question. Advocate Riley, you keep on referring us to the fact that if Major General Boysen did this, he did it in the course and scope of his duties as a police officer. And I don't think that is in dispute, because these people, this group of people were all police officers. All do you appoint a police officer? All appointed as police officers, all carry South African Police Services badges and use police services firearms. So they were doing all this under the pretext that they are carrying out their duties as police officers. Hence, there are case numbers where they say they are investigating the murder of Superintendent Konko and. So you keep on going back to that answer, that if Major General Boysen shared the information, he did that within his scope and duty as a police officer. But would you say the same where, let's say, Inspector Mostert shot, Inspector Mostert shot at the occupants of the Hyundai in the case that is under discussion? Is it in the scope of his police official duties, and therefore he cannot be blamed for such an act?
If I understand if he shot at someone and that person then it would be, and that person has never shot first at him, and he was acting in self-defense. But if it was not the case, then I would agree. Yes, he did not act in self-defense, and therefore that can never be during the course and scope of his duties as a police officer.
And what about the information that Director Boysen gave to Inspector Mostert pertaining to Magojela and Tembe, and which led to the group of police officers cornering them and firing at them, ending up killing them? Would that still be within the scope of his duties as a police officer?
If the suspect, whether with or without a warrant, the police was looking for that person, tracking and tracing of that person, and Major General Boysen, as the provincial commander or as any other police officer who has information about where the suspect is provided to another police officer, that will be during the course and scope of his work, unless it can be proven through evidence that they, in actual fact, gave that information with the intention to go and kill that person, and that person wasn't being sought by the police, or even if the person was sought by the police.
Advocate Riley, I think I need to put this on record. Your answers take me by surprise, because you are a prosecutor, and one would expect that a prosecutor would go after a suspect with all the resources that he or she can, with the aim of bringing a suspect before a court. But it seems as if your position is that a suspect can be killed. And as you said earlier when you and I had an interaction, that once a suspect is killed, the case is solved. That is a bit unsettling. especially in this democratic era that we're living in. That is, I thought I should put it on record that it is, for me, it is a bit unsettling if we still hold such views. Thank you, Chair.
Madam Chair, I propose.
May I,
Okay, sorry.
may I reply, or am I not allowed to reply?
You may comment.
Thank you. We're working on evidence, and I did not say, as a prosecutor, you can be allowed to go and kill somebody if you're a police officer. I simply said it's the norm of the police during their working that they will give information regarding the tracking and tracing of a suspect. If there can be two scenarios. I said the police officer has a right to defend himself if he gets shot. If he did not, if he wasn't shot at and he killed that person, then he is liable. Then he did it without any, then you can't claim that he acted in self-defense.
Do you remember the passage that you read at page 2254? In that letter from the South African Police Service relating to the monetary and non-monetary rewards?
That is correct, Madam Chair.
In which a summary of events is given by the police themselves. If you look
That
at
is correct.
page 2254, you remember that statement in relation to which a suspect was attempting to flee and he was thrown out of a moving vehicle. This is what the police are saying. And he was subsequently, immediately thereafter, shot at. You remember that passage? There is nowhere in that passage where a suggestion is made that these two suspects were shooting at the police, and the police, as they fatally shot at them, were defending themselves. You remember that passage at 2254?
Madam Chair, if my understanding of a shootout is between, there was
No.
to and
Do
fro.
you remember that passage?
I do. I
There
read
is
it.
nowhere in that passage where a suggestion is made that the suspect were shooting at the police and the police acted in self-defense. If I am missing something, please direct me to the relevant part at 2254.
At 2254, starting from the line right at the end of line 5, it says a shootout then took place between the passenger of the suspect's vehicle and the investigating team, resulting in the driver of the vehicle being injured in the process, which resulted in the vehicle stopping. So I do say I don't know if there's agreement. For me, a shootout is between two groups of people. And the way they describe it, there was a shootout between the passengers of the suspect vehicle and the investigating team. So my reading, unless I'm incorrect, is that there's shooting between the two vehicles, the investigating team and the vehicle of the suspect.
You are drawing an inference. Where in this passage do I find a line that says the police were shot at and they acted in self-defense?
It's not said that they acted in self-defense.
Thank you, Madam Chair. I propose to really move from this topic. I think the last exchanges have put everything we need to know about the approach of this witness clear. Now, can I also ask you something that is common cause, just to get your confirmation? The police killed 8 people in response to the investigation over Superintendent Ncukaitobi's murder. Do you remember that?
That is correct, yes.
They did not arrest a single person.
That is correct.
Yes. In relation to the killing of Inkosi Zondi, which was the Peggy Temba case, the police killed 3 people, correct?
That is correct.
They did not arrest a single person.
That is correct.
Yes. The person who oversaw the Zondi investigation was General Boyson.
Yes, I can confirm that.
Yes. His own statement appears in the Peggy Temba docket.
That is correct, yes.
Yes. He also oversaw the Ncukaitobi investigation because he alleged that both of them were high-profile investigations that required his personal attention.
That's quite possible, yes.
Not possible. It is in his book, Advocate Riley, which was published 3 years before your report.
Now, maybe I should rephrase. It's quite possible that provincial commanders, when you have high-profile cases, that they will oversee it or be in charge of it.
Okay, thank you very much. Now, when you look at that, that is 8 plus 3, 11 dead bodies, where Major General Boyson is the overseer of the investigation, out of 28 dead bodies. That's approximately half of all of the bodies we are dealing with. You want to tell me that Major General Boyson had no knowledge that these were unlawful killings?
I cannot take it further except what I read in the dockets.
Yes.
And I had to decide on what is the evidence that he knew or ought to have known.
Yes, no, but the point I'm making, Advocate Riley, is simpler. The 2 dockets where Major General Boyson was personally in charge of had the highest murder rates out of every other docket we've dealt with. They had the highest killing rates where his hands were involved. It was the Ncukaitobi docket that produced 8 deaths. It was the Zondi docket that produced 3 deaths. Those were the highest in proportion to every other docket. That's where Major General Boyson was personally in charge of the investigation. And you want to tell this panel that he had no knowledge about what was going on in the dockets that he was personally assigned to investigate.
That is correct. If there was evidence to that effect that he knew or ought to have known, then I will give you, I will agree with your submission.
I have just shown you in relation to the Ncukaitobi investigation, the killing of Mr. Magojela Ndimande and the killing of Mr. Sbusiso Tembe, where he knew because he signed the letter of rewards. He knew that they shot at a fleeing suspect. What other evidence were you looking for?
You said he personally knew or he
Yes.
received the information?
He personally knew because he signed the recommendation for the payments.
You can't say personally knew. If you're a provincial commander, then you are going to receive information. You are supposed to receive information about incidents of this nature in writing.
Well, we've gone through that episode. I'm not going to repeat it with you, showing his personal knowledge. But it seems that your mandate is to defend General Boyson at all costs. Can I move on to something else? You've
I
given
just
us.
want to respond to, may I respond to that, Madam Chair, about
Yes.
my mandate?
Yes.
Yes, you may comment, ma'am.
I disagree with you in terms of my mandate. I don't know where you got that from in terms of what my mandate was.
Well, I'm getting it from your responses that are so defensive that you would even ignore plain evidence staring you in the face.
And I disagree that that is evidence.
Yes. Thank you, Madam Chair. You've given us a number of authorizations that are signed by Major General Boyson. They appear at item 33 of the cross-examination bundle, 2257 to 2303.
Can you repeat what you're saying about number 33, please?
2257 to 2303. It's a number of authorizations that are signed by Major General Boyson and Captain Olivier.
Okay, I'm just going to request that I get that document.
Yes, no problem.
Is Advocate Ngcukaitobi still with you there?
She's still with me, Madam Chair.
Yeah, she'll assist you.
It is at page 225. Oh, sorry, it's item 33 of the index. Volume 6, apparently.
Just place on record what these documents are.
Madam Chair, these are attachments to the statements of Advocate Riley, which appear to be requests for trip authorizations. And there's quite a number of them spread between two dockets, Durban North 151 and Maphumulo. And the Durban North one seems to be an investigation into a robbery in Sibaya Casino. Do you have them, Advocate Riley?
Yes. May I ask a question, Madam Chair? These documents doesn't come from me.
Well, they are attached to your statement. I mean, where do they? That's why it's got SR. That's meant to be for you.
It was never attached to my statement. I'm sorry.
Well, they are attached to your statement, all of these documents.
I never attached this to my statement. I don't even refer to this in my statement. I don't know where these documents come from.
Well, can you go to your statement at SR2?
SR2.
Let's just get this right. My researcher is taking me to the annexure, the answering affidavit by Advocate Abrams, to which these documents are annexed. Do you get that? Advocate Riley, you have annexed.
Yes,
You have annexed. Listen to me first, please. You have annexed Advocate Abraham's answering affidavit to your statement. And I'm advised that SR 0798 is an annexure to that answering affidavit.
Okay, I do understand
we'll
now.
look into that. Do you find that, Advocate Ngcukaitobi?
Madam Chair, I need to also be directed. Apparently, that's correct.
Yes. It is volume file 3.
Yes, we found it, Madam Chair.
File 3.
Yes.
Do you have file 3 there, Advocate Riley?
Just looking for it, Madam Chair.
Yeah, thanks to our researcher. Have a look at file 3. These are documents attached or annexed to your affidavit. It's part of SR2. Is it 2? It's part of SR2, but it starts from the other boundary. But this is file 4? Yes. Okay. Is Advocate Lekgeto winning?
That is correct, ma'am.
All right.
Advocate Riley, at what stage are you now? Have you found the source of these documents?
I found it as an annexure, yes, to Advocate Abrams's affidavit. Yes, that's correct.
But the Advocate Abrams' affidavit is an annexure to your affidavit. That's the point that the chair is making.
That is correct, yes.
And that's how these documents ended up being an annexure to your affidavit.
That is correct, yes.
Yes. Now, I have...
It is correct that this is your document. In other words, it forms part of your founding statement.
That is correct, yes.
Thank you.
Thank you, Madam Chair. That's been a lot more productive than I've been able to get. Sorry, I apologize.
Our research has been helpful.
Yes, thank you. Because the Advocate, I've analyzed all of these documents, starting from 0797, 0796, which is 2257. Sorry, 0798, if you look at the red coloring, which is 2257. And what I find with them is that there are requests for advance payment from KwaZulu-Natal, often to Pretoria, sometimes to Johannesburg, but for substantial amounts of money. And they are made primarily by Mr. Jeremy Martin, Mr. Olivier, Mr. Lockham, Mr. Eva, Mr. Van Tonder, and approved by Mr. Olivier and Mr. Boyson. Now, what I found striking about that is that these are all of the managers of the enterprise. They are the people enabling the movement of the officials. Now, they also claim substantial amounts of money. There is one claim for 90,000 rands, 92,000 rands actually. If you look at 2261, that's a claim made by Mr. Lockham. So if you look at the amount there at 2261, the amount is at the top, says total.
Yes.
Can you see there, is it 92? Is that correct? That is 92,000.
That is correct, yes. Looks like it, yeah.
Yes, and then you go through, let's go to 2263. Now that's to the attention of Major General Boyson, but it's signed by Colonel Olivier, Can you see that?
Yes, I can see that.
Yes. Now, there is not a single one that is approved by Colonel Aya, who is in fact the unit commander. None of these. Now, you remember when we started, I pointed to you where the response to the request for further particulars says, Major General Boyson and Colonel Oliver would skip Captain Ayer and go straight to the officers reporting to him. And we find that pattern here all over. The people that are approving is Oliver and Mr. Boyson, but the requesters are the people reporting to Mr. Ayer. How do you explain that?
Well, first of all, if you talk about the huge amounts, may I respond to that? Or do you simply want me to say that in terms of Colonel Aya not being there?
No, I can't restrict
Then
your responses, but I am interested in the fact that these people are skipping Colonel Aya.
I don't think you can base it simply on this document, unless you can indicate to me the operational requirements that it must have included Colonel Aya. What I do see from these documents, that there are applications for authority to travel. I sit on the projects meeting at DPCI. I'm part of those meetings. So I do understand that there's a lot of money that is required in order to travel and to do your investigations. What I see in terms of these applications, that it's applications to travel to different places to do investigations. I can't comment on what are the operational requirements when you do submit an application for authority, and I can't comment on whether they have skipped Colonel Aya in this regard. Because I see the application is addressed to the Provincial Commander, Organised Crime, as well as the Deputy Provincial Commander, DPCI, which is Major General Boyson, and the Provincial Commander, Organised Crime, KZN, is Brigadier Madonsela.
I mean, I can even make you one glaring example at 2282.
Sorry, 22?
82. And then look at who 2282 and 2283.
Sorry, I might be not, is it, I'm here by SR 0798 still, and you're referring me to?
No, to the blue numbering, well, the green numbering, 2282 and 2283. If you're looking for the red numbering, it's SR 0823 and SR 0824.
Okay, got it.
So, again, this makes the example I was trying to make to you that with none of these do I see the actual unit commander making any approval. All of them are from the people reporting to him, and then he is skipped and they go straight to Major General Boyson. So take this one. This one is from Mr. Oliver, if you look at 2283, but look at who approves. It's General Boyson. But in between General Boyson and Mr. Oliver is Mr. Aya. How do you explain that? If you deny that they used to skip him.
I indicated this is an application for authority to travel. I'm not familiar with what is the operational requirements when you do an application of this nature.
All right. So your point on this, you would accept the facts that Mr. Ayer does not appear, his subordinates appear, but they are approved by Major General Boyson. Your point is that you don't know what the operational requirements are.
when you apply for authority to travel, whether it should go to Colonel Ayer or whether it should go to the provincial commander directly.
Yes. Now, you would remember that one of the issues you have is that you cannot accept the evidence of Colonel Ayer, who says, these people used to skip me and go to Major General Boyson on inter alia traveling requests. And I've now shown you the evidence, what he means by that. Can you comment on that?
That's what he says, yes. They skipped him.
Yes.
That's what I read in his statement, yes.
Yes, but I have shown you the evidence because you have this tendency of saying, I want to see the evidence. I've shown you the evidence. You now say, well, you want to see the operational plan.
That was my response was, I do not know the operational requirements when you do an application for authority to travel.
Can I move to another
proceed, Councillor.
topic? Thank you, Madam Chair. Can I move to another topic, which is in your report, you say, because Major General Boyson was charged with predicate offenses arising from the same incident, that would not qualify under POCA as being two or more offenses, correct?
That is correct, yes.
Now, you also rely on this judgment of Watts versus State. It's a Florida case. Now, I want to take you to that judgment, which is item 35, page 2317. Of the cross-examination bundle. 2317, volume 6.
We're just looking for it.
So if you go to Anthony Watts versus the state of Florida.
Before that, did you find it, Advocate Riley?
Not yet, Madam
It is
Chair.
in that same volume in which the trip authorizations or applications were made towards the end of that bundle. 2317.
Yes, yes, sir.
Now, this is the case that you rely on in your report. And in fact, if I recall correctly, even in your statement, you rely on this case.
That is correct, yes.
Now, if you go to, yes, that same page, 2317, you read the judgment where it deals with section 895.02 brackets 4 defines a pattern of racketeering activity as, can you see that?
Hold on.
It's in the middle of that page. And it starts with the sentence, section 895.02 brackets 4 defines a pattern of racketeering activity. Can you see that?
That is right.
Now, how does it define it?
Sorry, let me just. defines a pattern of racketeering activity as engaging at least 2 incidents of racketeering conduct that have similar intents, result, accomplices, victims, or methods of commission, or that otherwise are interrelated by distinguishing characteristics and are not isolated incidents, provided at least one of such incidents occurred after the effective date of this act, and that the last of such incident occurred within 5 years after a prior incident of racketeering conduct.
Precisely, thank you. Now you see the question on appeal, it's dealt with in the next paragraph. What was the question on appeal in that case?
The question of appeal is whether the 2 incidents requirement is satisfied when the state proves that the defendant is guilty of 2 offences which arose out of the same incident. We find that this does not satisfy the 2 incidents requirement.
Yeah, stop there.
This issue.
Well, I mean, you can continue if you want to read about State versus Rosso. I don't want to stop you.
Now, the issue was addressed in State versus Rosso, 493 SO2D 505, FLA 4th DCA 1986, review denied. 504 SO2D 768 FLA 1987. In Rosso, the court held that the 2 incidents requirement is not satisfied when the defendant is charged with 2 offences which arose out of the same transactions.
Yes, the Rosso court stated that its interpretation is in line with the Florida Supreme Court's determination. Can you see that?
That is correct, yes.
Now, we go back to that definition. You see the judges are making it clear that they're distinguishing between 2 incidents and 2 offences.
That is correct, yes.
Now, can I ask you to go to our legislation, not the Florida? This is the Florida statute that you've been reading, not the South African statute. Now, can I ask you to go to page 275 of that same bundle and look at how we define a pattern?
Which page?
Commission of
Which volume?
Volume 1, Madam Chair. So if you are at 275, under the definition of pattern of racketeering activity.
Yes, it means the planned, ongoing, continuous, or repeated participation or involvement in any offense referred to in Schedule 1 and includes at least 2 offenses referred to in Schedule 1, of which one of the offenses occurred after the commencement of this Act, and the last offense occurred within 10 years, excluding any period of imprisonment after the commission of such prior offense referred to in Schedule 1.
Now, can you see the clear difference that the Florida statute refers to incident? The South African statute does not refer to incident, it refers to offense.
That is correct, yes.
Now, can you then explain why you used the Florida statute and not the South African statute?
I referred to a case in terms of what they describe as 2 incidents.
No, the case, as I've shown you now, the case you've referred to is Anthony Watts versus the state of Florida. It took the definition from the statute and put it in the judgment. That's why I ask you again, why did you use the statute of Florida and not the statute of South Africa?
Because how they define what 2 incidents are assist us with a pattern of racketeering of activity in our definition.
But can you not see that it's plainly different? Because in Florida, it must be 2 incidents. That is why they say if it is 2 crimes from the same incident, that amounts to 1 incident. In South Africa, the word incident is not used, but the word offense is used.
That is correct, yes.
Can I come back then to ask you the question? Why are you applying Florida law when we have clear South African law?
If you can refer me to a South African case that deals with this issue rather regarding the planned, ongoing, continuous or repeated participation, then I will agree that there are differences. But my understanding was in terms of proving a planned and ongoing, continuous, or repeated participation does not refer to a single incident, because the idea is regarding a pattern of racketeering activity is that you are involved over a continuous, ongoing, repeated participation in these offenses. And it does not refer to one incident with multiple counts. It refers to many more.
Yes. All right. And you want me to refer you to South African authorities. You did not read them yourself.
I said if you can refer me